Kotov sir, can you hear me?
ಹಲೋ
Yes, madam.
ಸರ್ ಹೇಳಿ ಏನ್ ಬೇಕಿತ್ತು ಹೇಳಿ ಸರ್.
I was just testing. Can you hear me ಅಂತ ಅಷ್ಟೇ. Thank you.
ಯು ಆರ್ ಆಡಿಬಲ್ ಸರ್.
Thank you, madam.
ಅದೇ ಫ್ರೆಶ್ ಗೆಟಿಂಗ್
Your Lordship's kind permission. Serial number 48, I'm going to withdraw this.
This
Please,
was withdrawn.
much of.
Not, one matter for urgency today at 2:30 minute. What has happened, not suit for not partition. At final arguments, not defendant files, not a will. I challenge that will not file an RTI application stated, but the finding is that the RTI application, that the will does not exist. I file an application before the trial judge, not stating I want to recall my evidence. Trial court rejects it, not on 21st of July. I get certified copy on 22nd. It post not yesterday. Again to today, not taking my final argument as nil. Therefore, there's urgency of this matter. Today again, the matter is dismissed before the trial court. They're posting on regular basis to dispose of the matter, my lord.
You didn't even file till now.
I filed, my lord.
When?
Writ petition today, my lord, I filed. Yes, my lord, I received certified copy on 23rd of July. Therefore, my lord, is urgency because yesterday, my lord, it was listed for final argument for the first time. I made submission for the learned trial judge. Trial judge not takes my argument as nil and he puts it again to today, my lord.
Suit of which year?
Not suit of 2012, my lord. But my lord, your lordship note that the amendment application is filed by defendant in 2026. The will is brought in 2026, my lord. Will is brought in 2026. I filed RT application in 2026.
Tomorrow.
Please, my lord.
Your Lordship, list 1, serial number 58.
Please wait. First mentionings to be taken for 2:30 matters.
My lord, in these two matters, my lord, we take up the urgency that, my lords, one suit is for posted for judgment and fixing the date of hearing on 30th/7/2026, my lords. The urgency, my lords, the learned trial judge heard the arguments on the plaintiff side on 23rd, and without hearing the defendant said, no, Lord, urgent the matter for judgment. Anyhow, my lord, on the same day, I have filed application for reopen and recall of the orders of concern. The learned judge dismissed those applications, my lord, in OS as well as execution petition, my lords. By fixing the date of posted for the judgment on 30th/6, my lords.
When was this filed?
Today morning, my lords.
It will be filed
My lord, what
eventually.
is, my lord, 23rd is Friday, my lords. What is the certificate copies yesterday, my lords?
Anyway, you have to file it. Without
Already
even
filed,
filing
already
it, how will
filed,
you come to the court
My
and
lord, already
say,
filed.
if you file it, will come tomorrow. Why a memo for that?
My lord, the petition is filed, but judgment is 30th, my lords. Urgent.
What is tomorrow's date? Every matter is coming. Can't you see 50 fresh matters are
Tomorrow
listed
is
every day?
Tomorrow is also.
For that, I don't like this procedure of granting memos for a fresh matter. Because as per the directions issued, there is a SOP, it is coming. So what for I should give you a memo?
But the trial court is on fixing the day after tomorrow.
No, I'm saying if you do it, if you comply with the office objections, it will come tomorrow. That is what are the specific instructions. No, once I entertain this, now again,
Malad,
see, like this,
Malad, the
how it is
petition-
happening.
But petition filed in the morning today, my lord. But they taken the matter to tomorrow for day after tomorrow for complaints is concerned. But maybe tomorrow, my lords. For that, my lord,
I'll not give the
at least
memo.
tomorrow, my lords.
You comply with the office objections. If it is not coming, tell the court officer.
But without
Yes.
memo, they have not completed the office of this.
Why they
Because
will not do?
fourth,
That is,
the
that's
mat
a
will be,
non-submission.
my lord, the mat will be listed the fourth day, my lords. But meanwhile, 30th is the day after tomorrow is a fixing the date by the trial court for
I'm not
judgment.
able to
my lords.
understand these kind of urgencies every day. Every day, like one urgency.
I can
Saying
understand.
that yesterday matter, today I'm filing, I'm at to file.
My lord, I can
Now-
understand, my lords, the mat will be listed before this court on the fourth day of immediately after the filing, my lords. But the learned trial judge fixing the date of hearing, my
I
lords.
said is immediately you should list it. That is what instructions from this court to the registry.
But,
So it will come. No, if you start with this, everybody will come up with
At least
this.
tomorrow, at
I'll
least
be-
tomorrow, my lords.
I will not grant. I will not grant. Tell the court officer if it is not coming, she'll attend to that. Yes.
My lord's matter pertains to unauthorized hoardings that was put up on state highway. My lords had recently disposed a writ petition. It's a similar one. I appear
So-
for the. My lords,
So what? It will come. When it come, I will decide it.
my lords, the issue is there are unauthorized hoardings and it is causing a problem.
We will see. We will see.
My lord.
Yes.
Maybe
For
had-
all that, please don't don't mention, please don't again make the court to tell you every day repeatedly. Any urgency, write on the paper and give. I'll look at it at 2:30 and grant
Can I
the
pass
date.
this memo?
Take it, give it. Don't have to mention. That is what I'm saying.
My lord.
And code officer, please look at it. Look at it. What is that memo? And then only you accept it. And if any urgency is mentioned in that, then only you accept. Otherwise, don't accept any of the memos.
Serial number,
My lord.
list
That
number.
stage has not come. Please wait. Yes. Huh?
Wherein I was
memos
asked
are-
about the rental amount in the court.
Why you are mentioning,
My lord, this is for urgency, my lord, because the matter.
what is urgency?
Urgency is the matter is already been posted for arguments, yet since the writ petition is still pending.
Which
before this
year
court.
is that? Which year is the writ petition? Huh?
2024, my lord. This honorable has
Then
already-
2024 matter, it will be posted for arguments if there is no interim order. What is urgency now? I will not take it.
My lord,
Give it to the court
urgency is
officer,
that-
I'll see.
one
Yes,
submission, my lord. Urgency is that the trial court, they are already posted for final arguments, my lord.
let it be. You should have had a stay in 24 matter.
Yes, my lord. It is already there. Subsisting that also, they posted for final arguments, my lord. I've already brought it to the court, notice. There's already a stay order, but they've posted for final arguments, my lord. There's an extreme urgency, my lord.
When is it posted for final arguments?
Yesterday, last week, my lord.
When?
Last week, my lord. It's on date. My lord, on the 23rd, 23, sorry, I'll just, but.
That is 23/8.
It was last week, my lord. It was last
23/8 it must have been posted.
No, my lord. It's last week only.
No urgency. I'm not convinced. I am not convinced, Mr. Counsel. Yes, next.
My lord, yesterday trial court was, order was passed, delivery possession, my lord, for urgency, my lord. I'm not party in that, but I'm the objector, my lord. It affected my property, my lord. It
Have you
has-
filed it? You have to file before the trial court your
Trial
objection.
court already,
petition.
order was passed yesterday, my lord. Delivery of possession, my lord. Yesterday, order was passed.
No, if you can't file an application before the trial court objecting the
I
execution.
have filed, my lord. Application was rejected, my lord. Order was passed, my lord.
If it is rejected, you can't come before this court. You have to file an appeal.
My lord, already, possession, delivery possession order was issued, my lord. It was urgency, my lord.
Against an application rejecting and your objector application appeal lies not before the court. That is what it is. Yes.
My lord, list number 2, serial number 5, my lord. Yesterday I filed a wakalat and still some papers are required. My opposite party advocate is also there. I require 2 weeks time, my lord.
For that, I'll not hear the matters now. For these kind of submissions, call the list.
Your lordship, adjournment, your lordship.
Yesterday I filed
My lord, adjournment, my lordship. My lord.
Serial number one.
Yes, memo is speaking to.
Serial number 15, list number
Adjournment.
2, my lord.
Serial number 143, my lord.
Withdrawals, no mentionings in the morning, except withdrawals. Wait for your turn. Just call the
My
list.
lords,
My lord,
one
serial
urgency,
number-
my lords.
Adjournment, my lord.
Adjournment, your
Number
lordship.
144, my lords.
143, my lord.
What petitioner?
Yes, notice to the respondents, 1, 2 also notice.
Same, my lord.
Then number 3. Then number 3. Shantan Gowda.
Serial number 3, I may be permitted to serve the notice on the counsel appearing for the unserved respondent before the trial court.
The petition is permitted to take out hand summons on the counsel appearing for the respondent number 28 before the trial court.
Lords, 28 is deceased, my lords. The other unserved respondents, my lords.
Then what about the deceased?
I'll ascertain, my lords. I'll
You
file a
have an
memo.
interim order.
No, my lords, there is no interim order.
R1, R3, R6, R9, 19, 23, 25, 27. Petition take out hand summons on the counsel appearing for the respondent before the trial court, and steps shall be taken in respect of R8. Yes, 4.
Please, my lords. Much
The memo, this hand summons within 2 weeks from today, the memo shall be filed, or else the CRP stands dismissed against these respondents.
Then number 4.
I appear for the petition in this matter.
Yes.
Yes.
But this matter came up on Friday.
Yes, what are your instructions?
My lord, instructions are that whatever is stated, my lord, the petitioner says that as what has happened, my lord. Let me be, my lord, I'm my lord, I would like to put the entire thing very straight, my lord. On that day, my lord, 3 days, my lord, things have happened, my lord. On the first day, the presiding officer, my lord, says that he is unable to hear the matter. My lord, what has happened, my lord. I cannot, my lord, place any materials.
As directed by the Honorable High Court, no proceedings are held in MA number 10 of 2026 on this day, which is pending before this court. memo complaint which produced before the Honorable High Court was not produced before this court, and copy of the complaint which addressed to Honorable District Judge was also not placed before the court. The petitioner who appeared before Honorable High Court filed false documents by stating that same were filed before this court.
False documents. My lord, I would like to place
No,
things.
any-
No, please think. I should be, my lord.
I am on the, let's not waste any
No,
more
I should
time
be
on
heard,
this.
my lord. I should be heard.
No, I already heard you on the last occasion.
My lord,
I said,
if-
I have
if
given
this
you, I
report-
have given you only two options. Either of it, you opt for it. Either one that I will grant an interim order, and once the inquiry reveals that I'll ask for a thorough inquiry into this. If it reveals anything contrary, I'll impose exemplary cost of 10 lakhs.
Your
and
lordship was
dismiss the
clear on that.
petition.
My lord. Your lordship was clear on that.
Yes. Yes.
My lord, the second option, my lord, is,
Second option is I will confirm this order.
my lord, then I have to go back before the presiding,
Yes,
same presiding.
yes.
My lord, I do not have any issue in going beside, in
I
front
said
of the
I'll
same.
ask him to hear you and pass orders. That's what I said, the second option.
My lord, there is an element of bias. My lord, now the report says I have filed false documents. My lord, I don't know what false documents I have produced.
Yes.
Well, I should be given an opportunity to rebut that, my lord, report. I don't know what that report is.
I am not making not recording any of that in my order. I am saying, as I have said earlier, there are only two options. If you still stick to all this, I'll stay the matter. I will ask the PDJ to conduct an inquiry into this. Any of the statements that happen to be not correct, I will impose costs of 10 lakhs. Number two, I'll ask the learned judge to go to hear your matter and pass orders on the merits of it. Only two options. I will not interfere with this order.
My lord, there is a complaint that has been filed on the administrative side, my lord. My lord, now what has happened is that has become negatory, my lord, that the right of the litigant.
You have
my
a
lord-
right, you have a right of appeal against that. You have a right of.
No, that
appeal
is
of a-
pending.
You have a right of appeal against any judicial order.
That
That
is-
the appellate court will consider whether such order is passed.
No, but
as
with
law
these
or not.
observations, my lord, that is still pending today.
What observations?
No, the observations made in section 24 order which is impugned in this CRP, my lord.
Hmm.
And also the order that has been passed by your lordship on Friday, which says there is no element of material. My lord, that is where, my lord, I would like to, my lord, be very, very straight. I had a discussion with the petitioner. What transpired on that day is extremely important, my lord. Now, the Honorable Supreme Court says the element of bias, my lord, should be looked into from the canvas of the litigant, my lord. There should be adequate balancing of rights. The presumption that my lord, the litigant is wrong at the outset, my lord, has to be, my lord, is a little
But
bit.
if that is your understanding, I'm sorry. I didn't say so.
My lord, your lordship made an observation to that effect.
No, I didn't say so. Nothing, no material on record. That's what I said. So please be
Madam,
very
what-
specific in what
No,
you're
I
making.
would say, my lord, what
Yes.
the presiding officer on that day say, very clear-
Everything, every allegation made against a judicial officer will not be taken
Lord,
it on
this
its face
litigant is
value
litigating before-
unless and until there is a material on record.
my lord, those materials are not subject matter of adjudication on the administrative
Yes.
side.
Yes. Whatever you want to make submissions on the merits of the matter, you submit, I'll pass orders.
My lord, your lordship is already.
No, why do you can't keep on assuming something to the officer that he is
I'm
doing
not
something,
making any
district judge
allegations,
is
my lord.
making
That should
something,
not.
Court is making something, don't
My
assume
lord,
all
no, my lord, at the outset, I greatest respect of from the judiciary, my
that.
lord.
Yes,
This petitioner is litigating for the last 20 to 25 years, my lord. Not a single complaint against any presiding officer has been made. My lord, that pattern has to be, my lord, taken into cognizance. It's not that every time he makes an allegation. My lord, on that day, the presiding officer, my lord, said that he would not like to hear this matter because it is causing immense stress on him, and threw away the file. I don't know whether those things I can address that in the open court, my lord. There are certain things that happened on that day, which are factual statements, my lord. My application, my statement of objections was not taken on record. My advancement application was thrown away. And there was a very clear threat to the petitioner that the adverse orders will be passed. My lord, if I am asked to produce any material for this, my lord, where should I place the material, my lord? Where should I get the materials? On the next day, my lord, your lordship may kindly see the convenience compilation, my lord.
yes. Yes.
My lord, the next day, in fact, we said we will address the court. The cause list, it was not mentioned. The petitioner, along with the GPA holder, was present. He is a heart patient. My lord. For the entire day of the court proceedings, and half a day the court proceedings, my lord, he was present. At 11:40, my lord, it's already adjourned without the matter being called. And with an observation that the respondent Your Lordship may kindly come to Annexure E5, my lord, at page 52 of the petition itself, my CRP.
Yes.
Respondent absent, no representation, respondent argument taken as nil for orders call on.
Yes.
Now, after the cases were called, the petitioner made a representation to the court that I have been present. Now, the presiding officer says, prove that you are present. Whatever I have said is gospel truth. My lord, I cannot place any materials. These things did happen. I have produced the order sheet. Whatever materials that I could have, my lord, produced, I have produced that. Now, other than this, my lord, I have also filed a complaint stating all the facts, my lord, narrating all the facts, not of which that on the administrative side that is pending. Now, the section 24 application that came to be adjudicated, which is impugned in this petition, my lord, sets that at naught also now. Now, I am okay if that at least that complaint is alive, and my lord, there is an order on that at least. There should be an inquiry, my lord. It should not be that everything gets closed by the section 24 impugned order. I am extremely, my lord, put into prejudice now. Now, your lordship is right in saying that no compelling materials. My lord, what more compelling materials, my lord, I can produce? This is a question that I asked myself today.
Yes.
Now, your lordship also says there is no compelling materials and imposition of cost also, my lord. So where should the litigant go, my lord? There has to be absolute balancing of rights. Now, if your lordship is making an order to go before the same presiding officer, and that presiding officer is going to pass an order which uninfluenced by these, my lord, happenings for the last over a period of time, my lord. My lord, I would say, I definitely talk to my client and my lord, see whether he's okay with it.
No, not necessary. We don't require his consent now. You have argued.
No,
on
he's before the court.
No, you have argued on the merits of the matter. You continue your arguments, conclude it. I'll pass orders on the merits of it.
My lord, he should not be prejudiced is what I meant.
That's what, I understood your arguments. What else you want to submit before the court?
No, let the matter be passed over 5 minutes. I will talk to him. At least let that be.
Yes, next.
Then number 5, C.G. Gopal Swamy for petitioner. Yes, Sampath.
For the caveat respondent.
Office objections shall be complied.
My lord, all objections have been complied.
Copy is not served on the caveat.
That's what is coming up. Non-compliance is that.
My lord, I have served copy on the other side. Even I.
You that. When all these orders matters, I'll not hear it. It's only coming up for that purpose. In single writ challenges on more than one IA to be clarified.
Yes, please.
What are those 2 IAs?
2 IAs is one is to recall and one more is to reopen.
Office objection with regard to the office objections are overruled. Yes, sir, papers are not served.
It's not served, my lord.
It is served. Endorsement is also there.
Then counsel for the petitioner, the copy of the writ petition on the counsel for the respondent. List this matter tomorrow in the first list. Yes.
Then number 6, T.N. Vishwanatha for petitioner.
R1 and R3.
As far as the notice to R1 and R3 is concerned, returned as unclaimed, amounts to deemed service of notice. What about 4, 5, 6, 9 and 10?
4, 5, 6, I'll take notice to the advocate who appeared before the
The
trial.
petition is permitted to take out hand summons on the counsel appearing for the respondent 4, 5, 6, 9 and 10 and shall file a memo to that effect by 11th of August.
Your lordships, I undertake to appear for respondent number 3.
Respondent number?
3.
So and so submits that. He has instructions to file wakalat on behalf of respondent number 3. Interim order is there?
No.
Yes. Next 7.
There is only one office objection. Is that 2 orders made on 2 IAs are under challenge.
What are those IAs?
The IA number 5 is on an application under order 26 rule 10A for comparison of thumb impression.
And the other one?
The other one is for amendment of the prayer.
Amendment of the plate. Office objection with regard to, office objection is sustained, petition shall file separated petitions. Yes.
Cell number 7.
Yes.
Mohan Kumar
Take that. What is that order?
on complaint.
Seventh.
You have to you have to file 2 writ petitions against 2 orders.
It's serial number 8, Malats, because it was called as 7. That's why he also got confused. I'm for the petitioner in serial number 8.
Yes.
Yes, Malats. In so far as maintainability, Malats, there is non-compliance of order 39, rule 3 and 3A, Malats. After granting ex parte order, matter was adjourned by 6 months, Malats. And therefore, in so far as the office objection on maintainability, Malats, in identical circumstances, writ petitions are entertained. The impugned order is
Not maintainability.
is
Entertaining is not
entertained.
maintainability.
Yes, Malats. It's
Whether it is
entertained.
maintainable, no.
Yes, Malats.
What has been done earlier, don't expect it to be done now.
Yes,
It has to be as per law.
Yes,
If your law permits you to come here, yes. If there is, go before wherever you are. Office objection with regard to
Malats, if I may request, Malats, if the matter may be remanded, at least a time frame be fixed, Malats, because there are some grave errors in the order, Malats. If I may
Office
point out.
objection with regard to the maintainability is sustained. Petitioner is. Yes, next.
Cell number 9. Arun Pradesh for
Here.
petitioner.
This one, your lordship said, heard and granted an interim order on 9/7/2026.
You that.
And we were directed to serve the copies on the advocate appearing in the trial court. That we have done. We have filed a memo reporting compliance.
All are served?
Yes. Now, defendant number 1, my lord, he's been placed ex parte. We have taken out notice, but we couldn't serve it on the advocate, my lord, because nobody is representing him in the trial court. Rest
Memo
are
is
advocates.
filed.
We have
Memo is
served a
filed.
copy.
It is a memo is filed stating that as per the order passed by this court dated 9/7/2026, they have served the note, the hand summons on the council appearing for the respondents 2 to 8, and a memo to the effect is filed. According to the notice to R2 to R8 is self-sufficient. It is submitted that R1 is set ex parte. Then if it is not necessary, file a memo.
We'll file a memo.
A memo is filed stating that notice to R1 is not necessary as it was set ex parte before the trial court. Interim order earlier granted is extended. Is this matter in the month of October?
Please oblige.
Yes.
Cell number 10. Ramesh
I
Chandra.
appear for the petitioner, my lord. Serve the copies on the trial court council, my lord, and file the acknowledgement on 25th, my lord.
You have an interim order.
Yes, my lord.
You have served on 1 to 4.
Yes, ma'am. Yes, my lord. Acknowledgement has been filed, my lord.
Memo of hand summons served, acknowledgement not filed is.
On 25th, I have filed, my lord.
They don't look at it. What is the position yesterday? No, the cause list says hand summons served, acknowledgement not filed. They say they have filed.
On 25th, my lord. They have not put up.
Your first, where is that memo? Look at it. You have a copy?
But not right now, not.
Look at it, call for the memo. And no, not necessary to call this man. You appear for the?
R5.
Interim order earlier.
It is submitted that they have filed the memo in the registry. Registry is directed to put up the same. Interim order earlier granted is extended. Let's this matter in the month of October.
Much obliged.
Yes.
Number 11.
Appearing to the petitioner. My lord, office has raised an objection with respect to maintainability of this petition because I've challenged an order and in the execution proceedings. My lords, what has happened? The private respondent's land was never acquired, but he claims compensation by playing fraud. The assistant commissioner of the taluk states that his land has not been acquired.
No.
Please, my lords.
What has this order impugned?
Lord, page number 90, page number 86 may kindly be seen.
Consequently, of the director to issue necessary intimation, so and so.
Lord, your lordships have
The
the
application filed
translated.
under order by the DHR is hereby allowed. Is it that?
Please, my lords, I have filed a translated compilation, my lords, along with the entire translated documents. A separate compilation is there in the file, my lords. Initially, the petition was filed where documents in Kannada were there. I filed a separate compilation, my lords.
No, first let me look at the impugned order.
Please,
Impugned
Lord.
order must be in English.
Please, my lords.
Yes, where is that order?
Page number 88, my lords.
Yes. The application filed by the DHR under 151 is allowed.
Please, my lords.
Separate affidavit filed by indemnify bonds, so and so. Office is directed to release each in favor of so and so.
Please, my lords.
Hmm.
Lords, what has happened?
Who are you? Who are you? You
My lords, I was one of the objectors before in the execution proceedings.
What happened to that?
My application was rejected.
Hmm.
Lords, in the meanwhile, after I challenged that order before this honorable court, during the pendency of that writ petition, the execution proceedings came to be closed. Thereafter, my lords, what had happened? The award was passed in favor of the private respondent. That award was challenged by the government before this honorable court in MFA. My lords, there they enter into a compromise. The chief officer of that Taluk Panchayat enters into a compromise stating that they are entitled for compensation. And this honorable court, the division bench, passes an order that amount may be released accordingly because the state government itself is admitting.
Hmm.
Now, my lords, we have found documents wherein the assistant commissioner himself states that it is the petitioner's mother's land which was acquired and not the private respondents, and the land which was granted in his favor is also nullified. So his land is not acquired, and when he claims that he is the owner of that particular land which is acquired, that grant has also been cancelled. So there was a fraud played before the executing court as well as before this honorable court, and amount of rupees 80 lakhs has been gotten released.
That is true. Their objection is, office objection is,
Please, my lords.
in the light of section 96 of CPC.
Let's have the precedents of the Supreme Court, wherein if fraud is played, the High Court has plenary powers to consider. And under similar circumstances, an insurance company had challenged an award on the ground that fraud was played before the court and award was released. There, the honorable
Wherever there is fraud, everybody should come to High Court.
Lord, when the superior officer themselves have stated that he is not the owner of the land, he is not entitled for compensation. I'll point out the documents, my lords. They say that he is not entitled for compensation because his land is never acquired. He claims compensation of around 80 lakhs. Public money, my lords, of that huge amount.
Why the appellate court cannot decide this?
Lord, they have already
asking appellate court will not
Lord.
decide it.
Lord,
Why the only High Court can understand the fraud and other things?
Lord, under 226, your lordships have.
No, they also have the power. They're all.
But there are other aspects which needs
Hierarchy
to be
of courts.
considered.
Everybody has the same power.
Lord, with.
We are not dealing with some
Lords,
226
appeal
matters.
would be very much limited to the documents available before the trial court and what transpired there. These are the documents which I'm bringing to your lordship's notice that officers of the
The
Taluk
issue with
Panchayat
regard to the maintainability is kept open.
My lord, I filed a memo, my lord.
For?
I filed a memo, my lord.
Notice
for
itself was
deletion-
not ordered. They have filed a memo.
Memo for what?
Deletion of respondents 8 and 9.
He has completed the office objections. The maintainability of the writ petition as that issue is kept open. Notice to the respondents.
Lord, I have sought for
I
him.
already filed a wakalat for
Relief
respond number 4,
that-
my lord.
My lord, the interim relief which I am seeking now is let them furnish a bank guarantee for that amount. If they utilize that amount,
See, we'll see.
my lord, it will be very difficult to recover it.
After service of notice on the respondent list on 12th of August.
I filed wakalat already fine. R4.
Yes, next.
Well, on 12, I appear for the petitioner, but there are no office objections as such. What is filed, my lords, as per the cause list, the memo to report the conduct of parties. My lords, may have a look at that memo for a moment. My lords, scurrilous allegations have been made, that too on a memo. Before the contents are looked into, I just want to say one or two things, which is firstly, that this DHR party in person, this is a execution petition. He is the decree holder. I am the legal representative of the judgment debtor. What he says, my lords, in the memo, there are various allegations made that I am suppressing facts, I'm playing fraud, but there is not a single material particular which is disclosed to which I have the benefit of answering. Secondly, He does not file any affidavit in the prescribed format. He says he's a resident of Australia. There is not a notary on the affidavit. There is not a apostille on the affidavit. He has not even affixed the welfare stamp of 20 rupees, which is prescribed by the civil rules of practice. Yet application after application is being filed, and moreover, he files these allegations by way of a memo. So tomorrow, if a court holds him to account, or for example, if a court says that no, all these allegations are baseless without particulars, my lords, if I have to take action against him, I'm prevented because he's not even on affidavit. He has not even sworn before a competent notary or an authority attesting the affidavit. Moreover, he e-files. I have no problem with him e-filing. Let him e-file. But the particulars of law have to be complied with. The prescriptions have to be complied with. That is on the technical aspect. So far as the memo itself is concerned, Your Lordship may kindly look at the memo. I will just read it out what he says over there without any material particulars. And in fact, if I may have the benefit of answering in written, I will file an affidavit instead answering all those contents. Those memo where he says to report conduct of parties.
How these people have tagged this memo? I mean,
My lords, in fact, this matter was coming up in IA for vacating stay. He has filed for vacating stay. That is fine. But then he has filed this memo. So I presume that it has come up above that, bypassing all the other matters. Please.
when is that?
My lordship, may make some submission, my lordship.
Sir, kindly wait a moment. I will just kindly wait a moment, sir. I'll just finish.
That is dated
24/7/2026. Just 3-4 days back, he files a memo.
Has he appeared before the party in person committee?
He appears as a party in person.
Or has he appeared before the party in person committee?
My lord,
Yes,
he
my
says
lordship.
that he has.
Yes, my lordship. There is a form C has been issued. I'm on VC, my lordship. Respondent party in person.
No, I have not filed. No, the respondent party in person has filed a memo on 24/7.
It is mentioned here, memo of report of conduct of parties filed by advocate.
I can read out the memo if you. May I just read it, Your Honor?
Yes.
Memo to report conduct of parties. The respondent party in person most respectfully submits as follows regarding the conduct of the party affecting the sanctity of court, wherein the petitioner and deceased JDR is treating court proceedings as children play and hold no respect to court order and proceedings. There's no material particular. The respondent is victim of court and court officer, and petitioner JDR fraud on court, wherein third party and his family lost their valuable 11 years lifetime in fighting unrelated litigation from Australia and suffering financial losses more than 90 lakhs. The copies of relevant supporting documents are enclosed as Annexure R1 to R4. Till date, 11 honorable judges, including Apex Court and High Court, observed 10 years history of indulged fraud on court and perjury of JDR on records. The copies of so-and-so are enclosed as Annexure. The current petitioner, JDR LR, this is the statement against me. The current petitioner, JDR LR, continuing indulging fraud on court, willful contempt of court order to suppress their perjury act and false claims in execution so-and-so, and OS court proceedings. The copies of relevant supporting documents are enclosed as Annexure R6 to R8.
Yes, what is
Can
this?
I request?
Can you file a
My
memo like
lordship,
that?
my lordship, what has happened here? There is a attachment order, my lordship. The court has made an inquiry.
Please understand what is my question.
Yes.
I said,
Yes, my
can
lordship.
you file a memo like this with these kind of statements?
My lordship, there is a
File an affidavit. File an affidavit.
I will do, my lordship. In the next date, I will do, my lordship. I will do. My lordship, one submission.
A memo is filed alleging several things against all the parties, alleging fraud on court and perjury, and several allegations are made by filing a memo. This memo cannot be accepted. The petitioner shall come up with
the respondent party in person.
The respondent party in person shall come up with an appropriate affidavit.
My lordship.
Notarized
apostilled, my lords.
As he is a resident of Australia. This is matter on.
My lordship, may I make some submission, my lordship? It is required. I have filed an e-filed. I have taken an oath online, my lordship. As per the e-committee, I am permitted to take an oath online, my lordship. It is approved by.
If you have to, you have to file a clear affidavit stating everything, not just alleging something and saying that I am filing the
No, no, ma.
documents.
No, my
What is
lordship.
contained
I
in the
will.
documents, everything
Yes.
you should file in the form of an affidavit so that they'll get an opportunity. Yes, this is in the month
Definitely.
of in August
My
19th.
lordship,
Yes.
my lordship, one submission I wanted to make, my lordship. This writ petition, what they filed, bypassing Order 21, Rule 58, my lordship, they declared judicially admitted binding admission that they're the third parties. They're nothing to do with the attached property. They say they're self-acquired properties, and they're supposed to file an Order 21, Rule 58 objection application
That's on the
without filing that.
maintainability, we will hear it. That's on the maintainability, we'll hear it.
My lord,
along with the
my lordship, interim order is taken on suppression of fact, my lordship. That needs to be considered.
My lords, it is wrong for him to say it is
My
submission. A court is
my
considered by
absence,
court.
my absence, they taken, my lordship.
Person is not understanding what is happening. Why are you making submissions when I'm adjourning the matter and extending the interim order? Yes.
Cell number 13, H.E. Gundegowda.
The notice to R2 and R3 returned with a postal share unclaimed amounts to deemed service of notice. Look at it, if interim order is there, extend. This is matter in the month of October. Yes, 14.
Cell number 14, M. Jagannath Alva.
Yes, what is the office
Petition,
objection?
my lord. The office objection is that we have not furnished the cost title of final decree proceedings in the cost title to this petition. Your lordship may kindly consider we have challenged the orders passed by the trial court in respect of P&SC proceedings. In the P&SC proceedings, we had sought for stay of FDP proceedings. Your lordship may kindly consider suit for partition is filed, decreed.
What is the impugned order in this?
Impugned order is the order passed in the P&SC only. Your lordship will find it at annexure A. P&SC order is challenged.
Interim order is to stay all further proceedings in FTP number.
My application filed in P&SC is rejected, against which I have filed this petition before this honorable court. I had sought for stay because now, so far as P&SC is concerned, it is before the district court. Final decree proceedings is pending before the civil judge senior division. Now I have filed an application before the before the district court in the P&SC seeking stay of the final decree proceedings. That application is rejected, against which I
Office
am before this.
objection with regard to office objections are overruled. Yes, this matter for objection as far as to replicate the cost title of the execution proceeding, the FDP proceedings is concerned, is overruled. If other objections, if any, are complied with, list this matter for preliminary hearing in first list
Cell number,
on Thursday.
Grateful.
Yes, 15.
cell number 16, 15.
Milord, this is the matter of the electricity, Milord. Without notice, they have disconnected my connection, Milord.
Office objection, what it is.
Milord,
That's how it is
with
coming up
regarding to
before
the
the court.
notice, already the respondent number 1 and 3 is on record, Milord, and 3 also has filed the wakalat, Milord. On the earlier occasion also, Milord, they were not present before the court, Milord.
What is the office objection?
Office objection with regarding to the representation of the R1. The already wakalat is been filed, Milord, by the R1. And other objection is with regarding to the minor, which I'll do on the day course itself, Milord, with regarding to the annexure J, which is not forthcoming.
Non-compliance of office objections at scrutiny level.
No, Milord, I have paid the court fee, and with regarding to the office objection,
they don't even make it clear what is that. Land counsel for the petition submits that the
I'll do on
office
the day
object-
course, my lord. Kindly have it on there tomorrow.
office
at
objections are complied with. Registries shall verify the same, and if office objections are complied, this is the matter on Thursday in the first place. Yes, 16.
Bill number
Please, oblige,
16.
my lord.
Request for a week's time.
A week's time is granted for complying the office objections, or else the writ petition shall stand dismissed
Interim order may kindly be
without any further reference to the court. Interim order earlier granted is extended. 17.
Bill number 17. Nagabhushan R.
For the petitioner, my lord, I have served the hand summons to the,
All the respondents 1 to 7.
one,
I have yet to receive wakalat, my lord, sir.
Per one.
Week's time, wakalat I have not yet.
R1.
Respondent number 2, 3 and 7 minutes.
defendant number 7 has not appeared before the trial court, my lord.
6, 7.
Only one person is. Other has been served.
If that is the case, what you should do, you should file a memo seeking dispensation of notice to him.
Please, my lord.
Which respondent you don't want notice to be served?
They have not appeared before the court.
That's why you have to file a memo for that. Otherwise, how will the court know?
Please, my lord.
It is submitted that defendant number 7 is at ex parte.
Not ex parte, in a notice has been issued.
Huh?
Notice has been issued before the trial court, but it's not served.
Even before the trial court.
Not served.
It is submitted that defendant number 7 is not served before the trial court. And you have served hand summons to whom?
1 to 6.
He has served the hand summons on the counsel appearing for 1, 2 and 3. Then there are R1 to R7.
Total 6, all 6 I have served. Only 7 in respect of.
R1 to, then usually that is R1 to R7.
Yes, ma'am.
Lord, I appear for respondent number 3.
Why
4.
such big confusion on your face? I don't understand. There are 7 defendants.
Yes,
One
ma'am.
defendant, you said notice is not served.
Yes, ma'am.
When I say you have served R1 to 7, you say 3, 2, 4.
It's only in respect of R7, it's not served.
That I understood.
Yes, ma'am.
Remaining are 1 to 6, isn't it?
It has been
You have
served.
served on them or not?
It's served, ma'am.
Yes, it is submitted that R1 to R6. The hand summons are served as per the order passed by this court. Hence notice to R1 to R6 is held sufficient. Land counsel,
I undertake to file wakalat on respect of R3, 4, 6 and 7.
for 7 also.
Please.
Land counsel for the respondent
Respondents.
submits that. So and so submits that he has instructions to file wakalat.
Vivek, yes, my lord.
Huh?
Vivek, yes.
Submits that he has instructions to file wakalat for R3 to
3,
7.
4, 6 and 7.
4, 5 is not there.
5 is not there.
3, 4, 6, 7. Interim order is there.
No, ma'am.
List this matter for hearing on 13th of August.
That's short date maybe given, my lord. There is some urgency. They are interfering with my property.
List the matter on 6th of August.
Please.
Bill number 18.
Yes.
Ajay N.
For petitioners, kindly a week may be granted. my lords.
A week's time default order.
Bill number 19.
This also.
Anil Kumar. Bill number
A week.
20.
In submission with the serial number 18, interim order may be extended.
Interim order extended. Same, the 1 week default order. 19.
19.
I'll comply, ma'am. It's 2 days time.
A week's time, not 2 weeks, a week's time default order.
Bill number 20.
Look at it in all these matters wherever interim order is
That's
there.
19 interim order may be extended.
I already said before you asked. Yes, 20.
20 for the respondent in this matter.
The first order is against the MA order, miscellaneous appeal
Oh,
order.
there are 2 IAs.
Two IAs, one is for injunction. Against that injunction was granted. Then we filed appeal in miscellaneous appeal. That was dismissed. Thereafter, they filed application for assistance of police assistance. Against that, 2.
You have to file 2 writ petitions. Office objection is sustained, and the petitioner has to question the IAS independently by filing 2 writ petitions. Yes.
Bill number 21. Party in person.
My lord,
Banu Prakash.
I am the party in person petitioner. So anyway, the court objection is regarding that IA number 3. Actually, all the reliefs are not same, my lord. But they ask this is not independent. It is all the relief the same. It is intertwined and the interconnection regarding the office objection, my lord. And regarding the party in person, I had made the defendant number 1 and 2 actually is there.
1 minute, let me see what are the objections. Single writ not maintainable against more than, what are the
The 3
IAs?
3 IA has been filed by petitioner myself, my lord. For the recall of this further cross-examination of the plaintiff, where has been the second time has been perjury has been done. The FIR has also been registered, and for that reason it's been dismissed. And second, IA for rejection of the plaint, where that he is not never in the position of that OS number 4067 in the position. There, for that reason, I had requested for the rejection of the plaint. He has paid only 250 rupees out of 1000 rupees minimum amount according to the Valuation Act of 1958 under section 24A of the Karnataka state. So, and the third one is actually it is lapse. Actually, the IA has been filed in November 22nd, 2025, my lord, where it has been the order has been given on 5/6/2026. So it has been taken 6 months by default has been lapsed. For that also they imposed cost of 3,000 for each application.
The office has raised objection with regard to maintainability of one writ petition against 3 IAs. Then the party in person submits that he has filed a separate court fees as per the circular issued by this court. With these kind of distinct IAs, one writ petition is not maintainable. The party in person has to file 3 different writ petitions against these 3 different orders. Then next, photocopy of IAs to be filed properly, annexure to be stated properly. All other objections shall be complied with. Yes.
My lord, all the objections have been complied, my lord.
It says if it is complied, it's fine. If it is not complied with.
Number
Yes.
22, Archana Murthy for petitioner.
Yes.
Acknowledgement is filed on 21, ma'am. IA hand summons was served and acknowledgement is filed on 21.
Memo of hand summons served, acknowledgement not filed. When did you file?
21, ma'am. 21st of this month.
21st. How many are the respondents?
1, ma'am.
1.
For others, it has been dispensed. 11 to 13, I have taken notice, my lord.
Uh,
For others, it was
dispensed.
Where is the memo? You have a copy of it?
No.
Please directed to put up the memo. Yes, next.
Then number
Interim order may be
23,
extended.
Gautam BS.
Interim order earlier granted is extended.
For the petitioner, my
Yes.
lord. With respect to respondent 1, it has been filed, my lord. With respect to respondent number 2 and 3, on the parties, it has been served, my lord. On 25th of July, the acknowledgement,
Order of the court.
my lord, to serve on the trial court.
Why, how can you do something contrary to what the court says?
No, my lord, with due respect, my lord, respondent 1 advocate, I found him, my lord, it was served. With respect
You
to,
have to seek permission of the court. Whatever you
I shall
take,
do
that
that,
will
my
not
lord.
be accepted.
No, my lord, I shall do that also, my lord. I shall do that also, my lord.
As per the order passed by this court, notice was served on the hand summons was served on the counsel appearing for R1.
Please.
A memo is filed. Notice to R1 is dispensed with.
I am for the R1, my lord. I have filed my wakalat R1.
So and so submits, has already filed wakalat on behalf of R1. R2 and 3, the petition is permitted to take out hand summons on the council. What is happening to that?
Please, my lord,
3.
I shall do the needful, my lord.
Yes.
Interim
Within a week, he shall file a memo to that effect by 3rd of August, or else the writ petition shall stand dismissed against respondents number 2 and 3.
Interim order may be extended.
Interim order earlier granted is extended till then.
Obliged,
Any
madam.
date of hearing. Any date may be given, my lord. Hearing.
Yes, 24.
24. Prakash.
Yes, 24.
Prakasham.
Have you filed the memo?
Service, my lord, yes.
Then number 24.
You appear in
Prakasham.
24?
25 now.
24.
Prakasham. Awaiting service of notice.
No representation on behalf of the petitioner. This is matter in the month of October.
Then number 25.
In this case, my lord, may kindly see, Rule 7 and 9 of the writ petition rules provides for a single writ petition being filed. May I pass on the.
What I'm saying again, there is a separate circular issued thereafter. Now, what the difficulty that's faced by the court is?
It only multiplies the proceedings, sir.
What are the, that's why I'm asking, what are those 2?
Only single cause of action because one is
No, I'll tell you. If it is a recall and reopen.
recall, reopen, that is the case.
That is then in those cases, I'm allowing.
Yes.
Office objection, the IAs or reopen and recall, hence office objection is overruled. Yes, this is
Kindly
not-
see the order, my lord. May I make a submission?
Not now. Order matter I'm not taking up because I want to complete this orders list
Very well,
that I've
very
taken.
well.
This is matter for preliminary hearing.
Tomorrow, my lord.
If office objections are complied with.
All objections are complied.
Thursday in the first list. Yes, 26.
26.
Lords, I appear for the petitioner.
Sundaraman.
22nd July, my lords, a memo was filed. My lords, serving hand summons, my lords, on the councils appearing for R1 to R10. My lords, respondent number 11, in respect of respondent number 11, they have been deleted from the suit. And therefore, my lords, the
Is
council.
submitted that memo, the notice to, as per the orders passed by the court, notice to R1 to R10 is served. But they have served the hand summons on R1 to R10, and a memo in that regard is filed considering the same. Notice to R1 to 10 is held sufficient. Interim order earlier granted is extended. List in the month of October.
Much obliged.
Case
Number
27.
27. Shivashankar
Appearing
K.
for petitioner, my lord, filing memo for withdrawal, my lord. The petitioner is not maintainable. Kindly direct the branch to give the certified copies and file RFM, my lord. With
Memo
liberty.
is filed seeking to withdraw the writ petition with the liberty accordingly. Memo is taken on record and notice to, memo is taken on record and the writ petition is dismissed as withdrawn with the liberty to file a RFA within a period of 2 weeks from the date of receipt of the copy of the order. The registry shall return all the documents to the counsel for the petitioner by retaining the copies. Yes.
Much obliged.
Cell number 28. Nardan G.
There are three applications
Yes.
that are regarding for appointment of commissioner only at a different point of times. All the three orders have been, now the latest order by annexure G2 at page 2.
No, what are the orders? How many orders?
There are three orders.
At different point of times, all
Point
together
of
question.
time, but what happened is the matter was.
Give the dates.
Yes, madam. But what happened was, but I have first, madam, the trial court on page 42, madam.
No, you can give the dates. That's
The trial
sufficient.
court has passed an order, madam, the matter was argued and posted for judgment. But on 5/10/2018.
Hmm.
And the trial court found that because of the encroachment, court commissioner was necessary to be appointed.
That order is questioned now.
That not questioned. But what happened, there from there, the counsel for the petitioner, he retired from personal reasons. But another counsel was engaged and proper, this order was not complied with that for appointment of a commission, process was not taken out. And thereafter, he filed an application by, after some application was filed for a further cross-examination of the defendant, that was allowed. Thereafter, an application annexure E at page 40 is filed once again, instead of getting this apprising to the court regarding the appointment of commission is already passed.
No, what are the orders impugned before this court now?
What is, annexure, the
That is-
earlier.
I want
annexure
the
E
dates
to
of those
malarious
orders.
That is dated 26/11/25 and 27/1/26.
Office objection.
And
to-
11/6/26.
With regard to maintainability is upheld. The petition shall file independent writ petitions.
May office objections.
With regard to the maintainability on one IA, two different IAs.
These, they all are for appointment of commission only for.
Maybe.
But I
They are
paid the
different
court fee.
interim, different applications, different orders. You please question it by way of different writ petition.
But if that is so, the matter is posted for argument today. I paid the necessary
Restricted.
court fee.
You no. You restrict it to one prayer and remaining you file. Whatever is the prayer you want to restrict, you restrict and make necessary changes.
If that is so, Lordship may kindly come to annexure G order, latest order.
The
And other
petitioner
two
submits that he will restrict this writ petition to the
Annexure
order
G2.
dated.
It is on 11/6, hello, sorry, it is on, order dated is on 2/5/2026, 2/6/26.
2/6/2026. With regard to the other prayers, he'll file a separated petition. Necessary correction shall be carried out. If the corrections are carried out, list this matter on Thursday.
This matter for admission. Lordship,
Thursday, I said.
Yes. I'll be in the meanwhile.
Thursday in the preliminary hearing. Yes, 29.
Cell number 29. Cell number 29.
And summons is served, my lord. I filed and summons is served, my lord. I filed memo in counter, madam.
To all the respondents, 1 to 7.
Except 5 and 8, madam.
Why? What happened to 5?
Except 5 is out of station, madam.
The
8 is a ex party, madam.
Have you served the notices on the council or
Yes,
party?
madam. Council, madam. And I filed
The office is directed to put up the memo filed by the petitioner.
Madam, for respondent number 7, I filed wakalat yesterday
but it's not shown in cause title. My name may
you-
kindly be seen, please.
So and so submits a yes file wakalat for so
But
and
I
so.
request for a date, please, my lord, for hearing.
Interim order is there.
Yes, my
Please,
lord.
my lord.
Kindly interim order may extend, my
This
lord.
extend the interim order. The petitioner shall take out hand summons on respondent.
Respondent in a different dates, my lord.
I said, who are left now to be taken
My lord,
R7 Gopal.
5 and 7, my lord.
in respect of 5 and 7, he shall take out hand summons and file in a counsel for the counsel appearing before the trial court
One.
and file a memo to the effect by 5th of August, or else the stay is granted by this court stands vacated.
Right, right. Respondent
If-
number 7, I have already entered, please, my lord. They are saying 5 and 7. Respondent number 7 is me. I am in.
It's a whole difficulty, even in respect of service of notice also, if the counsel is not able to submit, what the court can do.
My lord, sorry, my lord. Apply respondent number 8, my lord.
In respect of respondent number 8, if the memo is not filed by 4th of August, the stay granted by this court stands vacated. If the memo is filed, list the matter on 6th of August.
Let them direct to serve me a copy, please. I request.
Next.
Cell number 30. Cell number 30.
The memo has been filed yesterday, my lords. The office copy is here.
All are served.
To the counsel appearing before the trial court, 1 to 18, all the copies have been served, my
1
lords.
to
1 to 18, my lords. There are 18.
is served on the
To the
council.
council, yes, my lords.
Memo is filed stating that the notices are served on the council.
Along with the
Appearing for the respondents 1 to 8.
18, my lords.
1 to 18, and a memo in that regard is filed before the court.
And also
Considering
the
same
cost is
Notice to 1 to 18 is served. And also cost, how
Cost.
much is paid?
Yes, my lords.
As per the order passed by this court, they have already paid the costs. Yes,
Interim order granted earlier.
interim order earlier granted is extended. Notice to so and so held sufficient. List in the month of October. Yes, 31.
Cell number 31. 31.
For the
One
respondent.
does not appear.
For the respondent, R2.
Where is the count? Interim order is there?
No, Lordship, the
No
first one.
interim order. No representation on behalf of the petitioner. List this matter in the month of October, September. Yes,
Cell
32.
number 32.
At serial number 32, we have filed a memo, my lord.
DJ, 32.
Respondent number 1 to 7 are served to the counsels appearing in the trial court. Respondent number 8 is only, my lord, that counsel was not available. The
So
present
now what is served, to who are served? 1 to 7.
R1 to R7 are served.
Yes, as per the order passed by this court, it is submitted that they have served the hand summons on counsel appearing for respondent 1 to 7, and a memo to the, in that regard is filed. Hence notice to 1 to 7 is held sufficient. Then what about 8?
R8, my lord, we have taken out notice, the process is paid, my lord. But also they are not the contesting because the application was filed by the respondent number 1 to 6.
Then give a memo.
Please.
A memo is
I'll
filed
file a
stating that R8, the notice to R8 may be dispensed with accordingly. Memo is taken on record.
Please.
Notice to R8 is dispensed with. You have an interim order.
We had an interim.
Interim order earlier granted is extended.
Cell number 33.
List this matter in the month of October. Is 33?
33. YP Vijay person.
This honorable court was pleased to grant an interim order in the case on 2/7/26, my lord. While granting the order, this honorable court has directed me to take hand summons to the respondent 3 and 4 and to issue and to take notice against the respondent number 1 and 2. Here respondent 1 and 2 are regularly appearing in the trial court, my lord. So I have taken steps against, I have taken hand summons to the respondents 1 and 2. Whereas respondents 3 and 4 are the proposed impleading applicants, the third respondent has got filed wakalat through his advocate, but from the date of filing of the wakalat, neither the respondent.
Emergent notice to R3 and R4 interim order
I have
earlier
already
granted is
taken-
extended.
I have already taken notice against them, my lord. Steps has been taken against third and fourth respondent, my lord. On 13/7, still it is to be
Yes,
served. up.
notice
Interim order may kindly be
order earlier
extended.
granted is extended. Yes, next.
Cell number
List in the
34.
month of October.
Appear for the petitioner, as per the directions of this honorable court, I served the notice and summons to the advocate appear for the plaintiff number 1 to 3 before the
R1 and
R1 to 3, others are placed ex parte before the trial
have
court.
taken out to R1 to R3.
R1 to R3, I served the advocate to the hand summons in respect of the other respondents is concerned, they are all placed ex parte before the trial court. But
Memo
they
is
have,
filed.
yes, memo is filed. And also I have taken the steps by through the post.
No. For the defendants who are set ex parte.
Yes.
Have you filed a memo before this court seeking dispensation of
Yes,
notice?
my lord. Therefore, it is necessary to dispense the notice to the
Where is
respondent.
that memo?
Memo is, my lord,
A
27/7/2026
memo is filed seeking dispensation of notice to
to respondent number 427.
4 to 7. Memo is taken on record and notice to them is dispensed with. R1 to R3 you have served.
R1 to R3.
R1 to R3, you have served the notice.
Interim
You
order
have
is-
served the hand summons and the memo is filed. Accordingly, notice to R1 to R3 is held sufficient. Interim order is there?
Interim order.
Interim order earlier granted is extended. This is matter in the month of October. Yes.
Cell number 35. Indraju KR.
My lord, affidavit had been filed, my lord. Respondent number 1 to 4, I have declined to accept court summons and summons, my lord. Now, defendant number 1, respondent number,
Issue notice to the,
lord, notice has been already issued, my lord. Process has been paid. And also I take,
after service of
my lord,
notice.
I am seeking for interim order, my lord.
I will hear it once because I have heard and it is not a case for interim order, it is.
My lord, earlier, my lord.
List it on
Serve it
Thursday.
and come. My lord.
List it on Thursday, we'll see.
My lord.
36.
Cell number
In
36.
first
These
list,
matters are not come in the list for granting interim orders. They
Earlier-
have come up for orders. A date will be given for that. That day I will hear it. Now I will not hear. List this matter on Thursday.
Cell number
Please.
36. Badri R for petitioner.
Appearing for the petitioner.
Yes.
We have served the copy to the respondents. And some.
R1 and R2.
Yes, ma'am.
Yes, a memo is filed as same as per the orders, same R1 and R2. Notice to R1 and R2 is self-sufficient. Interim order is there.
Yes, ma'am.
Interim order earlier granted is extended. List in the month of October. Yes, 37.
37. Venugopal.
Appear for petitioner, my lord. Already served the and summons, my lord.
On R1 to R4.
Yes, my lord.
Same on. In this R1 to R4 held
Already
sufficient.
memo filed dated 25/7/26.
The interim order is there. Yes, same. Interim order extend October.
Cell number
Yes.
38. Ashoka T.
My lord, I entered wakalat for R5. My lord, I have not served the copy of all the writ petition and annexures, my lord. I have served only the piece of paper.
List
Lord, I-
after service of notice to R1 to R4. Counsel for the petition serve the entire papers
all
to the
taken,
counsel
my lord.
appearing for the fifth respondent. Look at it. If interim order is there,
My
extend
lord, one more submission, my lord.
the month of, on 19th of
My lord,
August.
this is a matter. My lord, it is a connection to the RFA number 1617/2023. My lord, for adjudication of the present writ petition, examination of the papers in RFA is necessary. For the reason, my lord, in the impugned writ petition,
Let all the respondents be served, then we will see. Yes.
Cell number 39. Ananda K.
As per the direction of this honorable court, I served the and summons to the respondent number 1 and rest of the members were already filed a memo seeking dispensation. This honorable
Respondent number?
Respondent number 1 and served the and summons.
Yes, R1 as same and notice to R1 is held sufficient.
Interim order maybe.
Yes, interim order earlier granted is extended. List in the month of October. Yes, 40.
Cell number
Obliged.
40.
Not identical matters are pending before your lordships. The demand raised by the.
No,
Lord,
what
the
is this office of,
Yes, office objections are, my lord, that schedule is not made as an annexure, but schedule is a computation sheet, my lord. It is similar, same cases. We have produced that and no such objection has been raised, my lord.
This office objection is overruled. Yes.
Deeply obliged, my lord. Lordships may peruse the interim order that is granted in the similar matters, my lord. If your lordships are considering.
Take that.
Sir, yeah, sir. Page number 3, my lord. 22/4/26 order. Last 2 paragraphs. Petition.
Similar orders were passed in same order.
Deeply obliged.
Not this, the, which I have passed. They are there, same order. Look at that order copy. Yes, it is not there in this, in some other matters I thought. Yes,
41,
notice to the respondents in that. Yes, 41.
41, Rangaramu V.
Yes, office objection shall be complied with within a week. Yes, 42.
Number 42, Ashok Kumar HV.
My lords, appear for the petitioner, my lords.
Yes.
The office objection is related to serving copy to the caveator, but is not the party in trial court.
He has filed a caveat petition.
Yes, my lord, but he's not a party in a trial court, my lord. So hence we have not served the copy to him.
How will he file a caveat if he is not a party to the proceedings, and how the court will consider it? Give that.
He's just a SPI holder, my lord.
He is representing a party. Office objections shall be complied with. Next 43.
Then number 43,
For the respondent.
I have served the copy.
Yesterday I filed a wakalat for respondent 1 and 2, my lord.
On number?
A respondent 1 and 2.
1 and 2.
Yes, my lord.
So and so submits that he has instructions to file a
point,
wakalat.
my lord, in this
In respect
case.
of one, please wait. 1 and 2. Who are the other respondents to be served?
Already dispensed. Notice is,
All other respondents.
yes,
2.
madam.
3 to 16.
They are already dispensed.
He appears for VAR 1 and 3.
Prashant HM.
1 and 2.
Prashant MM.
1 and 2.
1 and 2, my lord, respondent. 1 week time
1 and
for.
2.
My lord, in this
You
case,
have an interim order?
no, my lord, only short point is involved, my lord. They got an
Short
expert.
point, I'll not hear it in orders. For short point, you should come in preliminary hearing, then I'll hear. List this matter for preliminary hearing on 11th of August.
My lord,
Then number 44.
my lord, in this case, ex parte order of interim injunction, they have not complied with the
I will hear it.
mandatory compliance, my lord.
I will hear it
My lord,
on-
maybe tomorrow or day after, only ex
possible.
parte order, my lord.
Not
They have
possible.
not complied with the
Yes,
order
next
39.
matter,
My
44.
lord, short date maybe next Thursday may be given.
I have
my lord.
lot of matters. I can't take it up now. Yes, 44.
Then number 44, YK Narayan Sharma.
Yes. What is this council submission?
There are 4 orders on 4 application, my lord. Common order has been passed.
What are those IAs?
One for reopening the case on the production of evidence and recalling the witnesses. That application has been rejected.
Office objection, but the council submission is accepted with regard to the office objections. If there are no other office objections, list this matter for preliminary hearing on Thursday. Yes, 45.
Then number 45,
My lords, objection raised here is regarding maintainability. So I had filed an application for reopen and recall for cross-examination.
Office objection or council submission is accepted. Yes, same like the other case.
All other
No
objections
other
are complied.
objections. List the matter on Thursday for preliminary hearing. 46.
Much obliged.
46, Rego LPE.
Paper the petitioner, my lord. It's for
For
notice to the
respondent, my
respondent one. I'll take it in the course of the day, my lord.
Kindly pass on. Senior is on.
Yes, the notice, the process shall be paid.
And also
During the
permitted
course
to-
of the day.
also
Or
permitted to
else the
serve the
petition
council.
shall stand dismissed as far as respondent number 1 is concerned. Interim order is there.
Yes, my lord.
Interim order earlier granted is extended.
I'm also be permitted to serve the council appearing the trial court, my lord.
Yes,
Thank you.
petition is permitted to take court hand
Please.
summons on the council. Yes.
Much
I
obliged.
shall file a memo to that effect
Certainly.
by 6th of August, or
Please.
else the stay granted by this court stands vacated.
Please, much obliged.
47, Suya Gerele. 47,
No representation. List this matter on 12th of August. Yes, 48.
Cell number 48. 48 dismissed as withdrawn. Cell number 49.
I appear for
48. What are? Which matter?
49.
my lord. My lord, I have filed the IA for amendment. My lord, there was only one by typing error. It was called for entire records in OS number 561 and which was disposed on 31/10/2015 by the Honorable Court, and we have to add there is also call for entire records in execution number 02 of 16, my lord. That's the IA I have filed for amendment. Then shall I come to the main petition, my lord, because there is an urgency.
Yes.
My lord, this is a respondent has filed the
eviction suit, my lord, before, in the year 2013. The petitioner was the tenant therein, my lord, and he has preferred the eviction suit for a recovery of 5 months rental arrears at the rate of 3,750 per month, my lord. Accordingly, he has paid the court fee also, my lord. And in the cross examination, he has agreed only there is a due for 2 months rent, that's all. And then the judgment was passed, my lord, and we have obtained the judgment copy also, my lord. And in the judgment copy, this is the original judgment copy I have obtained on 8/12, my lord. There in the order copy, it was stated as plaintiff is entitled to recover arrears of rent of rupees 7,000, and it is tampered at the 6% PA from the date of suit till realization after deducting the advance amount. And there is a decree, my lord.
What is the impugned order?
This is,
Please come to the impugned order.
I'll come to that, my lord. On this basis, execution was preferred, my lord. They have filed the petition, plaintiff has filed the execution petition, my lord, in execution number 02 of 2016. In that, I have filed a application under order 47, my lord. That 47 was dismissed, my lord. And on that, because, and it was ordered that you have to pay 1,70,000, my lord. For that, I have filed the preferred this CRP, my lord, on the basis of the.
Come to the order. Come to the impugned order. Where is the impugned order?
My lord, it is at the page number 92, my lord.
Yes, please come to that.
Order on IA under section 47 of CPC, my lord. This application filed by the judgment debtor under section 47 of CPC.
Why you have filed an application under section 47?
Yes, because it is not an executable. May I read my application under 47, my lord? It is at page number 48.
Yes.
Annexure G.
Yes.
It is here I have cleared all the points, my lord. It is submitted that decree holder has filed the eviction suit against the JDR in OS number 561 of 2013 before the Honorable Court, wherein the decree holder was arrayed as plaintiff and judgment debtor as defendant. It is also submitted that plaintiff was the owner of the premises which was let out to the defendant, who was the tenant in the suit proceedings. Both the parties admit their relationship. It is submitted that the plaintiff has not produced the latest agreement which was entered between the plaintiff and defendant. Deliberately, plaintiff has not produced the rental agreement dated 2012. However, the plaintiff in his cross-examination, he admitted that he was receiving rupees 3,750 as rent per month, my lord. And also he has admitted decree holder has received an amount of 50,000 as advance. And it is admitted the plaintiff was receiving 3,750 as rent, and the plaintiff has made false claims rental dues for 5 months, my lord, as per the per month in the suit, though the rent were paid up to the date. Plaintiff has not succeeded to prove the arrears of rent payable to him by the defendant, since the defendant has paid up the paid up to date rent to the plaintiff. It is submitted that the fact is that only 2 months of the rent were due, that is for the month of November 2015 and December 15. The judgment in OS number 561 of 2013 dated 31/10/2015 was passed, stating that the plaintiff entitled to recover the arrears of rent of rupees 7,000, my lord. Actually, the rent were as to be paid at the rate of 3,750. And
what
only
is executable?
It is execute. The order is, it is tampered, my lord. That is why I have.
That will be decided in the execution.
No, that is why this petition 47 was filed. That was dismissed, my lord. Because I have so many other grounds why it has to be.
Have you appealed against that order?
No, we have not preferred because I have filed the 47, my lord. Because this is not a executable decree, since there is because it was tampered, my lord, they have put the slash and M. There is no, it is not signed by the presiding officer. Any correction in the operative part of the order or judgment, it has to be attested by the PO, my lord. It is not so. And there is only 6% PA. What is that PA? And there is no word.
PA means what?
It is not coming up from reading of the judgment, my lord. There is only that much. Kindly 27 to 43, my lord. Judgment may be appreciated, my lord, at page number 47. My lord.
I have already appreciated all this when I heard it for the first time.
My lord,
But
it is
every day
tampered,
you're
my lord,
coming and mentioning that I should hear
one
it.
minute. I'll because and they have they are saying that the order is only for arrears of 2 months, that is payable at the rate of 3,750. It comes to 7,000, and the judgment is the idea of the judgment is only 7,000 is payable by the defendant, and out of the 50,000 advance, it is recoverable as that what it reads, and there is no interest, there is no word in the judgment interest, there is no whisper regarding the interest,
In
there is
that
no
case, what
word,
you will,
and
if
6%.
there is a difficult, if there is anything with regard to the calculation, you will say that this is not the amount, this is the amount. For that, anybody will file an application under section 47.
My lord, because they have filed, because there is a slash, my lord, 1 minute. Slash is because I have the original copy, my lord. In the decree, it is not there. My lord, please, it may be appreciated. Here, there is no order. In the order, M is there. In the decree copy, there is no M.
Yes, I'll consider all that and pass orders.
My lord, this may be seen, my lord, because there is no M. It is tampered one, my lord. The judgment is tampered, and and this is we have obtained by applying by
I'll consider, yes.
and and they have issued the arrest warrant, my lord. It is they have calculated.
Heard,
My
reserved.
lord, there is no interest.
Dismissed. Dismissed. Yes.
Sorry, my
next. Dismissed. Yes, next.
I'm sorry, my lord.
No, I'm saying I'm dismissing it. I'll pass a order. Now there is no time. Yes, dismissed.
My lord, I'm sorry, my lord.
No, no. Why are you not understanding? I do not find any merits on it. That's why I thought at least I'll reserve it and pass orders, but you're asking for an interim order. Ultimately, I'm going to
Because there is
dismiss it.
My lord, there is because
By today evening, you will get the order. Whatever you want to do with it, you do it. Yes, dismissed.
my lord, they have issued the
Call
at
the
least-
next matter.
My lord, please, my lord, it is not the executable order, my lord. 40 under 47,
Give
it
the
is
next
they
matter.
have stated the reason. Only it is
Yes.
it is attested. There is no attestation of the presiding officer,
Yes.
my lord.
Yes.
This is that matter which had come up last week, my lord.
Yes.
There's
I
no,
couldn't understand the logic in that. Now, you say that you have to pay the amount. I will deposit, but he should not withdraw it.
how much is the amount that has to be not
No,
paid by
If
me?
he's asking
Admitted.
more amount, then I can understand. For if it is 20
But I have
crores,
deposited more according to me, my lord, but I wanted to arrest, my lord, interest. Because interest according to them, my lord, is some 3 lakhs and odd per day.
what is the admitted amount according to you? Let's see from your objections.
Lord, I am yet to file. I will file it tomorrow or, my lord, the application is filed. Time is granted for me to respond to it. There is no order as such passed on the application.
We'll come to the.
And my lord,
Lord, please
it
see
is
his
posted on the first for consideration. Let court pass an order, my lord. They don't want the court to pass an order and they have rushed to this honorable court.
No, no.
Let's see what is the order now.
May I only
The
request
order
one
is
thing?
Annexure
Please
A.
see page 31. My learned friend can't make such a statement. Please see page 31. What do they say specifically to the court? They say permit the applicant, that is them, to deposit 95.55 crores
as per the memo of calculation attached herewith, being the amount payable to the opponent as per the arbitral award dated 16/8/2018.
That
Having
is-
made such a statement,
that
now my
is-
learned friend stands up in court and says that's not the amount.
The court, the application is filed by them for withdrawal.
Yes.
That is posted on the first, 2 days hence from today. Now they want this honorable court to allow that application today itself. Court has only permitted me to, my lord, respond to that application. I will do it.
No, what is
Kindly
the-
direct me, my lord, direct the court, trial court, to dispose
what
it
is
off
it?
on the first.
No, what is the impugned order? Let's see the impugned order.
Yes,
We will not
impugned
go
order
to-
is Annex
We
A.
will not travel beyond the jurisdiction and beyond the list before this court.
Yes.
What is the order?
Order, my lord, kindly see page 16. Page 16. My lord, there is order which begins from page 15, but 16, my lord. Again, case called out in the afternoon session. Counsel for defendant number 1 present and files a memo of calculation stating that after
The court has
deduction-
already passed an order. He sought for withdrawal of the amount. Court says issues notice.
No, he has asked me to
Request-
respond to that application.
For what? You've admitted it.
Lord, the adjudication with regard to how much is due, my lord, there are interest, counter interest, etc., my lord. This was preceded by a lot of discussion. We wanted to settle this, my lord, out of, my lord, not going to the execution, etc., my lord, because it has other implications of stamp duty, etc. We could not arrive at a, my lord, settlement of how much ultimately is the amount payable, because we don't agree on the exact figure.
You please
But
tell.
I have,
No. You can tell the court what is the amount.
but kindly
according-
see the prayer that is made in the writ petition. Writ petition prayer at page 12 is, set aside the impugned order of 27 and consequently allow the application.
It is an
That
obvious
application is for consideration before the trial court. There is no decision on the application. Application will be decided on the 1st of August. That is the date fixed, my lord. It is not some great amount of time that the court has granted. Kindly see, my lord, page 18.
That apart.
Yes.
The whole issue is why should the court, reject their request, or why should
It is
there
not
be?
rejected.
No, why should there be some?
It has not rejected.
it
my lord.
requires
It has not
hearing.
Rejected.
Consideration on that.
Lord, they, according to them, they have a claim of some 139 crores, etc. My lord, is what they claim. My lord, I have, my lord, deposited to show my bona fides, my lord, in the arbitration suit. Before even they filed the AS, my lord, the execution, in the AS I deposited. I advanced the
Pursuant to
case,
orders of the
took permission of the court to deposit in the disposed of arbitration suit under 34, what, my lord, I had filed, which was subject matter of subsequent 37 and, my lord, civil appeal, etc. I have deposited in those proceedings. Now he has made an application to withdraw it, and nothing, no order has been passed. My lord, court will pass an order on the 1st, but, my lord, they want that application, which court is yet to consider, to be allowed today.
Precisely, that is where you have to pause. Now, he made an application. You deposit the, he asked from 130 crores. You say that 90 crores, whatever.
Even
is the-
before he did anything, my lord,
Before that,
Yes.
he say you have deposit saying that 19 crores I'm depositing to show my bona fides, and you don't deny that 19 crores is not your liability. You admit 19 crores liability at least.
95 crores.
95 crores liability.
95 crores is, my lord, I have made some calculation and said that possibly that may be the amount payable, but
So-
there are deductions to be made out of that. I want the court to adjudicate that. Because I don't want to, my lord, have implication of further interest on that. Let the court decide, my lord, to release it on the 1st. Because kindly see the prayer.
I
Kindly
think,
see
my
the
lord,
prayer.
this is an extremely unfair way of making the submission. because
Kindly
if
see
you-
the prayer,
one
my lord,
minute,
in the
sir.
writ petition.
I think why I'm saying this is because of the application that they filed. In the application, they filed a memo of calculation.
Come to that.
Yes, ma'am. Please see page 37. And my learned friend stands up and makes these submissions. Please see the memo of calculation. They have calculated right up to the last rupee at page 37. This is accompanying the application. My lord, please see the amount awarded under arbitrator's award, amount dated so and so in commercial court while staying the award. The 60% interest is calculated, and ultimately they say total amount payable to NEC as on 1726 through DD bearing number so and so drawn on Bank of India Cantonment Branch, Bangalore, 95.55 crores. And in the application they say specifically at page 35.
Please come to that application.
Yes, Lord. This application starts at page number, my lord, 33. This is the application filed for deposit.
Yes.
And your lordship will kindly see the application is filed under Order 21 Rule 1A, which is the application, my lord, which you must deposit the admitted amount of money in order to avoid interest.
Hmm.
So order 21 rule 1A, my lord, is the application where they say that this is the amount of money that they must, that is the amount payable to the opponent in the application itself. And then in the affidavit, my lord, they say, can I humbly request, my lord, to kindly come to para 10 at page 35, para 9 and then para 10. Thereafter, the plaintiff deposited rupees 68.94 crores in the honorable court. This amount, together with the earlier deposit amount of rupees 28.11 crores plus interest accrued on the fixed deposit, together amounting to so and so, was withdrawn by first defendant from this honorable court 8921. The balance 40% of award amount plus interest thereon 12% from 16/8/2018 till this day, that is 1726, payable by plaintiff, will be rupees 95.55 crores. The plaintiff is herewith furnishing demand draft bearing number so and so for the amount above deposit of money would completely satisfy the award. Now my learned friend says I have to deduct from it. I mean, it's I can't understand. They don't have any faith on their own affidavits. And note is now between 95 and 139. That not the court will determine. Otherwise, not please see for public body the implications. If they prevent me from withdrawing, then they must pay interest as per the award till the date I withdraw it. Not just saying I deposited it, because you are preventing me from withdrawing it today. And the stand is I'm going to prevent you from withdrawing it. How can they prevent me from withdrawing it when you say so in your application? Specifically, your statement in the application and the affidavit filed not by a responsible officer is that this amount is payable to me under.
Petition, my lord, is at page 20. He has given a different set of computation, completely a different computation is given. And my lord, if he was now saying, my lord, he admits whatever statement is been made before, my lord, by me, and withdraws that amount, my lord, that will be the end of the, my lord, entire controversy. That he doesn't want to do. Now, my lord, to show my bona fides, I have deposited not in his execution. I have deposited in, my lord, the yes. My lord, court has only posted the application on the first. Now, my lord, he is aggrieved by the fact, my lord, that the court has is considering his application for withdrawal on the first. To consider, allow that application without a hearing.
Why should there be a hearing?
Is a case for hearing the matter without no objections or required. Admitted facts need not be proved. Now, he says 140, you say 90. Whatever is your admitted amount, what is the difficulty in withdrawing the amount? That I'm not able to understand.
Lord, if the court holds, my lord, that it's not 75 or 95, it is something 139, my lord, the court will pass an order, my lord, and the entire amount will be due and payable. Lord, I am a state and center controlled body. I have not deposited that money. Lord, I want adjudication, my lord, of the final amount that is payable ultimately. Lord, so far as this application is concerned, my lord,
to withdraw the amount, final adjudication not possible.
Lord, for Lord, the situation today is he does not want the trial court to, my lord, pass an order on the application. He is rushed through this honorable court without, my lord, the trial court passing any order on, my lord, either allowing him to withdraw or anything else. There is no order. It will be done on the first.
No.
Why should, my lord?
That is not the question before
Lord,
the first.
Then it, in effect, my lord, that application is being allowed without there being an order.
There could not
The
have been a hearing.
application filed by him for withdrawal is being allowed. He wants that application on the first day to be allowed. He advanced the matter and files an application and says, my lord, now you allow it. Court has posted it on the first. My lord, we are on 28th.
There are certain applications which require adjudication, certain applications which don't require adjudication. This is one such matter because it is admitted how you deposited that amount and they are claiming much. Now the court will decide whether he is entitled for 140 or, as you said, he is entitled for only 99. In that case also, no prejudice to you. That I'm not able to understand. If you make the court understand, like this is a prejudice for me, if you withdraw the amount, I'll appreciate that.
Lord, the prejudice is this. during the pendency of 34, I deposited, my lord, as per the 60-40 arrangement was made by the court, my lord. I deposited that money. Certain monies were deposited before that 37 court also. And my lord, to the other extent, my lord, as directed, my lord, I had given bank guarantees. Those amounts, my lord, have been in deposit, my lord, for since the order passed in the section 34, which was modified by this honorable court, again modified by the honorable Supreme Court, my lord, all that so far as interim order is concerned. Therefore, my lord, so far as the actual amount is concerned, my lord, even this so far as 95 is concerned, there is, my lord, I have mentioned, my lord, that 95 rough and ready, my lord, possibly if that is the amount paid, there may be no other financial implication so far as the, my lord, BMRCL is concerned. Because as an outer limit, 95 is something possibly which he is entitled to. I have deposited that entire amount before the honorable court. I want, my lord, the court to apply, my lord, its mind and decide, my lord, as to whether it is that amount which is payable, because there are interest, counter interest,
Ultimately,
etc.
the court will decide.
That has to be decided finally.
What is the amount?
Award amount is there. There are amounts which were deposited, my lord, historically before that court
All of that
and
is
this
there in the
honorable court.
calculation.
So, respondent is who?
BMRC.
But I am the metro project, my lord.
What does it matter?
Therefore,
My learned friend is acting like he's doing us a favor. The award has been upheld right up to Supreme Court.
no, I'm not doing any favor, my lord. He is not doing any favor to me.
Can you
I
deposit the
only
money?
want, my lord, the trial court to decide on the first.
Yes, I'll pass.
Matter is posted on the first. There is no order. It's an
I'll-
extraordinary writ petition, my lord, where he says that I will not, don't allow the trial court to pass an order on the first. It is not posted after some 1 month's time.
No, the writ petition is questioned on the ground that when admitted amounts are there, why why the court has not permitted them to withdraw? Why can't
But
can't he ask
it is not
No, can't he ask
prevented.
it? Had you been in this case, can't it be asked? Like when there is admitted amount,
They have asked.
why should it be
But
deposited in FD?
they have
Why
asked.
not I be given that amount? It's a very genuine
Correct.
request.
They have asked for it. The court has not rejected it for him to challenge it in a writ petition. And what matters,
Where the court fails to exercise the jurisdiction,
has
the
not.
discretion
but it
judiciously.
will be very extraordinary, would be my submission, my lord, because matter is posted on the first. For them to say that, my lord, if the court says that instead of today, I will consider it after 3 or 4 days. For them to, my lord, say that no, prevent the trial court from passing any order.
Why the respondents are objecting it? That is very, I can
But
understand.
I have filed, I'm also going to file my calculation and say, my lord, that
You already filed-
Memo is filed along with the application.
that is the only thing that is the, my lord, left to
The
be done in
difference
that
between
case.
95
those
and
proceedings.
139 is nothing else. I think very unfair.
I'll pass
And
on.
it's a huge amount, my lord, and there are implication of interest, etc. on me, my lord, which I may not be able to recover from them if I paid, because it is not, my lord, something which is covered by any guarantee. Therefore, my lord, I want an
Memo
adjudication.
is filed under which provision?
Lord, it is filed under 21. Lord,
What does 22,
21
21
rule
rule
1A?
1A
says?
Lord, I have shown, Lord, I have not filed it in their execution. I filed it in the AS.
Wherever you file
Lord,
a
even
21
before
1A
they
is the
filed
same
an
thing.
execution, I have filed it, my lord, I have deposited in the AS. And let there be an order, my lord. Kindly, my request is kindly direct the trial court to, my lord, decide that application finally on first. We will not seek any adjournment, my lord. I am saying that let it be decided on the first. If he, my lord, takes a decision that it should be, my lord, the entire amount should be dispersed, my lord, that will be the end of the application. But today there is no order on the application. And it does not warrant, my lord, an order at the hands of this honorable court, my lord, to allow the application which is to be considered on first. There is no order as such which could be challenged.
Heard result.
51 Sadhana S. Desai.
Yes.
This is a suit for bare injunction. I'm the defendant in the trial court, my lords.
Yes.
My lords, the issue is this: I have filed an application under Order 26, Rule 9 for appointment of the court commissioner, my lords.
What is the
For
suit
this
for?
purpose,
Injunction.
It's a bare injunction, my
At
lords.
what stage you have filed this application?
My lords, the trial was not yet started. I
the
filed
defendant or
it
the plaintiff?
even before I filed written statement.
You filed an application.
I filed an application. Later, I filed a written statement taking a contention that she has encroached, plaintiff has encroached upon my property. The issue is this, my lord. Now she claims she has purchased a suit shelter property in 2015. I claim the same property
So all the
having
disputes-
purchased in
All the
2008.
disputes shall be decided even before the trial starts
My
by
lords,
filing
no,
by appointing an advocate I mean, by appointing a commissioner.
My lords, the issue is a little different here. My lords, she quotes a different khata number, whereas my khata number is different. The problem is this, my lords, it's a revenue side. There is no layout plan approved by the local panchayat. my
Ultimately,
lords.
she has come to the court seeking injunction. She has to prove her case. And what is the urgency for a defendant, even before in a suit for permanent injunction, in a bare injunction suit, asking for an advocate commissioner, I mean, the commissioner's appointment.
My lords, may I please say this? The coordinate
But
bench,
that is
in the
correct.
coordinate bench judgment, my lords, it is observed that it is not state centric at any stage of the.
It can be done, but not in a suit of this nature. It is
Yes,
like,
there are
how-
apex court judgments, my lords, which says that it applies to also, because, my lords, the term used in order 26 rule 9 is
At any stage.
elucidating any dispute in any suit is what is, my lords, the.
That is all, this is all settled, settled law. There is no dispute on that. But at a stage, you don't even file your written statement and you file the IA. So that means in every case, first the advocate, first the commission be appointed, let him prepare his, the report, then the court will decide. That stage should come and that the requirement should be there. It is
Let's now-
ultimately for the court to understand the dispute between the parties.
My lords, can I prefer it now, my lords, with liberty to again?
That I always grant.
Because
That I'll grant. I
now
say
it
it
is
will
at
not, it will not preclude you, this order will not preclude you from making an appropriate application at a stage when warranted, and whenever you file application, the court will decide it in accordance with law.
But it's now the trial is going on of cross-examination
Will
of
not-
PW1.
No,
So
you file an application, that's for the court to decide.
let's, liberty may be reserved.
As if 2024, 2025 writ petition is coming up now. The present writ petition is filed. Agreed with the orders passed on I number 5 in OS number 257 of 2017, dated 29 February 2024. The respondent herein is a plaintiff, he has filed a suit for bare injunction. And immediately, even before the written statement is filed, I number 5 is filed. No, the application is filed at the stage of cross-examination of PW1 under orders 26 rule 9, read with section 151 CPC, seeking to appoint the court commissioner to survey the suit scheduled property. That came to be dismissed by order impugned. The court, while dismissing the application, observed that.
My lords, one submission, I'm
Yes.
very sorry. I did not see it earlier. My lords, application is filed in 23. Written statement I filed in
That's
2018.
why now I have, I have already dictated to her that this is at the time of cross-examination, not at the time of filing written statement. The court has observed that the defendant number 1, without cross-examining PW1, have filed this application only with an intention to drag on the proceedings and to kill the precious time of the court. Moreover, the defendant number 1 has not specifically stated as to why the appointment of court commission is necessary at this stage. The decision relied on the defendant number 1 is not applicable to the present case on hand and accordingly dismiss the application. Next para. Land counsel appearing for the defendant submits that an application for appointment of advocate commissioner can be filed at any stage of the proceedings. It is submitted that it all depends upon the case of it depends upon the facts of the case and the trial court. Without considering this aspect, I dismiss the petition. It is submitted that in the light of the controversy between the parties, the court had rightly, the court ought to have ought to have allowed the IA for appointment of commissioner. Next para, having heard the counsel for the petitioner, there is a material on record. This is a writ petition of 2025, questioning an order passed on 29 February 2024. It has come up before this court after complying with the office objections for the first time. in the year 2026. The suit is for bare injunction. The burden lies on the plaintiff to prove his position. When the suit is at the stage of cross-examination of PW1, the present application came to be filed. Court has rightly considered all the aspects and rightly dismissed the application. If after the entire evidence is placed on record, and it is all the more necessary to elucidate the court with regard to the about the issue in dispute, then there is no dispute about the proposition that the advocate commissioner can be appointed. However, in this case, without the evidence being adduced by the defendant has come with this application and the court has rightly dismissed the application. In that view of the matter, this court do not find any reasons to interfere with the order impugned. Accordingly, this court is passing the following order. The order impugned dated so and so is set aside. This court do not find any reasons to interfere with the order impugned. Accordingly, the writ petition is dismissed. Number 2, however, this will not preclude the petitioner from filing an application at an appropriate stage, and the court will consider the same in accordance with law.
52, Manu P, BP for petitioner. 52.
For the petition, right, seeking short accommodation in a week.
This matter in the month of October, a 2025 matter came up for the first time before the court in 2026. Again, the time is sought. It appears that the petition has no urgency. List is in the month of October.
Then number 53, Vishwas S. Reddy. 53.
No
Yeah,
representation.
I appear for the petitioner, your lordships. I appear for the petitioner. Suit for partition. May I, your lordships?
Yes.
Suit for
You
partition.
want me to hear it and pass orders or notice 25 matter?
Notice, your lordships. I'm not seeking any
Notice.
interim.
Yes, 54.
Then number 54. Case 3.
Previous
Hari.
occasion, your lordships had asked us to change the copy of the petition, my lord. There was an error in the petition copy, the pages were jumbled, but they require an oral order to give us the file to make a correction, my lord. So it may be-
Madam.
Previous occasion, there was a jumbling of the pages in the petition, my lord.
The petition, there is some discrepancy with regard to the page numbers. The petition shall correct the same. Let's this matter after 2 weeks. It's
Then
55.
number 55. Vinay keeps CM.
No representation. Let's this matter in the month of September. It's 56.
56. 56. Uni Krishnan M. 56.
Yes.
Chips, I appear for the petition.
You wanted to get instructions. Yesterday's matter.
Yes, my lords. Yes, my lords.
What are your
Yesterday's matter.
instructions?
My lords, it is that in the execution petition, there is an attachment order that is being made, my lords. My lords, I would like to take in a similar situation in another WP at page number.
No, what is the, how,
Yes, my lords.
what has happened yesterday?
My lords, my contention is that I have already paid a certain amount, that is 17 lakhs. The remaining amount is 9 lakhs odd, my lords. For that, in the execution petition also, they have given the total calculation. In that calculation, it's 9 lakh something. I'll produce it.
No, why it was adjourned yesterday?
My lords, it was adjourned in order to seek instructions, my lords, in
Right.
this matter. Yes, my lords. So
Instructions?
instructions with respect to this execution petition itself, my lords. I have bought the certified copy of the lower court's order in LAC number in that execution petition itself, my lords. So I would like to place that on record in order to show that we have complied with a certain amount that was ordered, that was
What
awarded.
is the impugned order now?
The impugned order is with respect to award that was being made, my lords, at Annexure A. I'm challenging with respect to, at page number
Oh, no,
38.
why it is adjourned is I wanted, what is the law on this?
Yes, my lords, on section 28.
I want you to show
Yes,
the judgment.
yes, my lords, section
Yes.
28. ma'am.
Yes.
Please.
Section 28 of the Land Acquisition.
Land Acquisition Act.
Do that.
Deputy Commissioner may be directed to pay interest. Can I read minutes?
Yes.
Yes, ma'am. Section 28 of the Land Acquisition Act, Deputy Commissioner may be directed to pay interest on excess compensation if the sum, which in the opinion of the court, the Deputy Commissioner ought to have awarded.
Section 28,
Minutes?
section 28.
28, yes, minutes.
It starts with if the sum which in the opinion of the court.
If the sum, yes, minutes. If the sum,
Uh.
which in the opinion of the court, the Deputy Commissioner ought to have awarded as compensation.
Collector,
Yes, minutes.
it says collector,
Deputy,
it says collector.
minutes. The latest edition says that it is Deputy Commissioner inserted, substituted for the word collector by Karnataka Act number.
Yes, that's the latest.
This is the latest, yes, ma'am.
That's the latest.
I suppose, Malaj, because right now it's.
Yes, it's a 2025 on Bear Act.
Yes, ma'am. 25 barrack, even I'm holding the same thing. Ma'am. 25.
Yours also 25.
25. And then it says it's substituted by.
Yes.
Yes, Malaj. Ought to have awarded as compensation is in excess of the sum which the Deputy Commissioner did award as compensation. The award of the court may direct that the Deputy Commissioner shall pay interest on such excess at the rate of 5% per annum from the date of.
It appears here 9%. One that is substituted by,
Is,
it's on 24/9/1984 substitution.
substituted for the word 6% by Karnataka Act number 17 of 1961 with effect from 24/8/1961.
It says 9%. 9% per annum.
It says 5%. Yes, ma'am.
Then we have to take that your book is unamended. Look at it.
Yes, Malaj. Malaj, however, Malaj, can I just
In that
place it
case,
before-
as far as 9% is concerned, you can't have any difficulty on that. 9% per annum at page 38.
Yes, Malaj. Malaj, but then my contention is with respect to, then there's an attachment order that is being made, Malaj. So, Malaj, for an attachment to be made of a railway property under section.
Now you have gone to now the
Railways.
submissions have changed. Now yesterday we were only on the interest aspect.
Interest aspect, that is one contention of it, Malaj. That's a one contention of it. However, Malaj, in order for the payment as well, if an attachment is being made,
Where do you get that attachment?
attachment order is at.
No, you have to question that.
Malaj, I'll place you the
No.
total order sheet minutes with respect to the
Listen,
execution
until you
petition. It's
question that
also there
order.
in this.
No, you have to question that order.
Yes, Malaj.
What is questioned is not that.
Malaj, my contention is with respect to it is there, Malaj. There's an execution petition, Malaj, for which there's an attachment
No,
that
there
has
is
been
one
made.
writ
There's
petition
an order
before
for
me.
attachment.
No, 11668. What is
Yes, ma'am.
questioned in this writ petition?
It
An
is with
order
respect to
dated.
the,
Order dated. Nothing, no order. Quashing the execution proceedings is the order.
Yes, Malaj, and also with respect to the statutory amount of 30% of solation that is being made, along with the.
What kind of prayer is this? What about
Malaj, at page
56.1
number
and
19.
what is 56.1 and 2? Same or praise?
Same, yes, Malaj. Malaj, I've already made the payment. I've already made the payment of 15 lakh rupees, total of
Attachment
28.
warrant is order.
Yes, Malaj.
Are you not supposed to question that order and seek a stay of the proceedings, or without questioning the order, you will just like that seek stay of
It
the
was
operation?
further on which it was made, Malaj. It was pending. However, they made an application and the application was allowed. Malaj can be shown at page number 21, Malaj. Can I request my lords to page
But that's
21,
not the
Malaj.
way, that's not the way how the proceedings can be stayed without even questioning it. So consequential proceedings should be stayed.
Yes, Malaj.
That we have to question
Malaj.
it. No, you're seeking stay of attachment. That attachment order should have been questioned here. And along with that, you should have also questioned you should seek.
By
for
way of
quashing
an
of
order
the-
sheet, it's been provided, yes, Malaj. At page number 21.
I'm asking
yes.
about the prayer.
Prayer.
We are not under
Yes,
226. You filed this writ petition on 227.
Yes, Malaj. The prayer had to be that.
Yes, this matter next week, the petition shall make carry out this necessary amendments. Yes, 57.
Cell number
Your Lordship,
57.
with kind permission, sorry, serial number 55. I came earlier.
Yes, call 55.
Cell number 55. Vinayak PM.
Your Lordship, suit is for partition, petitioner's writ petition. Your Lordship, first defendant initially filed the written statement, then issues were framed and all the evidence were completed. He was undergone with the cross-examination. When the matter is posted for argument, he was passed away. His LRs were brought on record. Your Lordship, then after once again matter is posted for hearing. On that time, Your Lordship, they filed the application with additional documents, board applications without explaining the reasons for the why they want to produce the documents which were in the year 2018-24. So the first defendant, when he was alive, he is not produced any of the document and he is not taken any such contention.
What stage they have produced it?
When the matter is posted for argument. When he was alive, first defendant.
So the evidence is over and the matter is for arguments.
Yeah, first defendant is already produced the evidence affidavit and he was undergone with a cross examination.
Please come to 54 is the order.
Yeah.
Second para.
Second, the plaintiff on the other hand filed the objection stating that.
No, before that.
Before.
In support of
In
the
support
above
of the above
application.
application, defendant's own an affidavit stating
On the
that
last date of hearing, issue was framed.
regarding repayment of the, it's not repayment of the loan, Your Lordship, it's a suit for partition. The question issues were framed long back, defendants were adduced his evidence and matter was posted for argument
According
already.
to you, this reason recorded by
No,
the court
that is the wrong contention, they are framed.
hence
repayment of loan.
Come to the affidavit. We'll understand from the affidavit what
Yes,
it is.
Your Lordship.
Page number.
There. Annexure E, Your Lordship.
I submit that last date of hearing issues were framed regarding the repayment of loan. Where is your objection to this?
Your Lordship, next. Annexure F, Your Lordship.
Where did you deny this?
Your Lordship. Application, I specifically stated defendant filed the first defendant statement pleading was there regarding the documents are in the absence of, it is submitted to lifetime.
No, with regard to this submission,
Yes.
that the said statement is not correct. Where did you say so?
In para 5, Your Lordship.
You don't deny anywhere. With regard to the
Nearly
issue.
5 years of defendant filed the.
No, that I have seen at para number 5. You don't deny the fact that recent issues are framed.
Your Lordship, 2016 suit. The
We
vendor
don't know. How can we presume something? We'll only understand from the material. If you want to, please get instructions. This is matter on,
I'll produce the entire order sheet.
this is matter on Thursday in the first list.
Cell number 57. 57. Prakash KA.
Is no representation in the month of September. It's 58.
Cell number 58. Swati
Your
Manjuna.
Lordship, it can be posted tomorrow. I'm convinced this honorable court as to why impleading application is necessary. It is with respect to impleading.
This is matter tomorrow. This is matter on Thursday. Yes,
Cell number.
the first list.
59. Cell number 59. Rupesh Kumar.
In another connected matter, my lord, this court has granted stay of further proceedings, my lord, in WP number 19193. Between the same parties, my lord.
What is this IA?
No, this IA is for staying of another suit, my lord, filed by the petitioner herein, my lord, which is a partition suit. Same IA is filed in this petition as well. There are two P&SC petitions, my lord, between the same parties.
So, no, by virtue of this order, which proceedings are stayed?
The P&SC proceedings, my lord.
Then now you want partition proceedings also to be stayed?
No, my lord. This is another P&SC proceedings, my lord. P&SC 65 of 2025. The one your lordship is
Then
holding
counsel for the
64.
petitioner submits that in respect of P&SC number
64.
60?
64 already stayed, my
64.
lord.
64, an interim order is passed. by this court in WP number 19193 of 2026 and between the same parties, this is P&SC number
65, ma'am.
65, considering the same, there shall be stay of operation of the impugned order dated so and so, passed in so and so by so and so. Notice to the respondent, same hand summons. Memo shall be filed by 6th of August, or else the stay granted by this court stands vacated. Yes, next.
Cell number
Great.
60.
Both matters may be listed together.
I'll tag this matter along with that.
Great.
Cell number 60.
Here for the
Shivashankar K.
Let's petitioners are the plaintiffs before the trial court. Let's suit for partition and separate possession. Let's the earlier suit came to be dismissed. Then let's the appeal has been filed. In the appeal, let's some documents have been produced. By filing an application under Order 41 Rule 27, appeal has been allowed and remanded the matter to the trial court. During the pendency of the suit, notes an application under Order 1 Rule 10 to application has been filed to implead notes some of the purchasers because they have purchased the properties through the defendants on the basis of some created GPS. Impleading application filed by the notes the plaintiffs has been rejected by the trial court, being agreed by the order. Notes the present.
No, after, when did they purchase the properties?
Notes GPS defendants. Notes we are claiming.
Whenever it is, when are the documents?
Yes, notes. All minutes subsequently after filing of the suit minutes on the strength of GPA.
No, not after filing. While the suit is subsisting or after the remand, it is, they have purchased the properties.
Minutes after the remand, after verifying the documents, if the plaintiffs came to the knowledge that the defendants have executed the sale deed in the form of sites in respect
Original
of.
suit is of which year?
Suit is of year 2000, minutes the 15. Suit is of year 2015.
When was it remanded?
Minutes remanded on in the year 2020, minutes 21, 22nd April
And when are the
2020.
sales?
Minutes now the stage has been commenced.
Sales, when the sales have taken
Minutes
place?
after filing of the suit. Right, some transactions have been made.
Please come to
Kindly,
the-
minutes the
come to the
reason
impugned
is, well, it's the impugned order at page 54. It stands minutes 55. Merely because we have not stated with regard to the transactions is concerned, notes only on that ground the application has been rejected. Plaintiffs filed the IS seeking permission to the court to implead proposed defendant number 3 to 13 as defendants as they are the proper necessary parties to adjudicate the matter in dispute. Defendant number 2 swearing an affidavit that the plaintiffs have filed the suit for partition and separate possession that the proposed defendants based on
Please
the
come.
legal and created GPS.
When counsel for the petitioner submits that after the remand, when an application is filed under Order 1 Rule 10 to implead the subsequent purchasers of the suit scheduled properties, the court has dismissed the same only on the ground that there is no narration in the IA under what instruments the proposed defendants acquired the. You didn't even tell that, the dates and all.
But documents have been produced while filing an application notes in detail they are
It
not
is,
stated.
So when
Documents have
counsel
been produced.
submits that, in fact, in the documents are produced by them before the court only on the ground that the dates are not stated in the document, in the IA.
Correct.
The court has dismissed the application considering the same. The operation of the order dated so and so. Then what is now, that's your suit for partition.
Partition and separation. Otherwise, minutes it leads to multiplicity of precedents because minutes all now the property
No,
comes.
We'll just, then you can take out notice, we'll decide it.
Yes,
Let your
please.
CO go on. Notice to the respondents. You don't have to say all this. Just say notice.
That's now the court is not till then next minutes. Otherwise, court is not granting time to let's the 2015 so. Now the court is insisting to lead evidence. Otherwise, court
But that's where the
is
bona fides
direction
of
to
the
the trial
party
court
comes.
not to dismiss the suit. Otherwise, minutes the court is insisting to lead evidence. Otherwise, suit may be dismissed. And that is the.
Why can't you lead evidence on other aspects?
But well, suppose all some say transactions have been made minutes without the subsequent purchasers or minutes these transactions.
No, apart from that, there would be other evidence to prove your case for partition. That you
Partition,
prove.
but minutes some sale deed shows minutes some of them purchase the properties in
But
the
that is a
form of
different
sign.
aspect. Your entitlement for partition will not depend upon their sales.
But minutes now after suppose in case if the court decrees the so.
I'm saying that I'm not, the court has not expressed any view that they are not necessary. I'm only saying why should it be stayed at this stage?
Otherwise, minutes if.
What is the present stage?
Minutes evidence now we have to commence the.
Commence, you have to adduce your own evidence first.
Then minutes,
And then within 10 days it will come. The petition shall take out hand summons on the counsel appearing for the respondent. It shall file a memo to that effect by 12th of August. If it is filed on 12th, list on 13th. Yes, next.
Cell number 61, Gajendra S for petitioner.
Short accommodation is taken it.
Why accommodation?
Senior counsel is out of station.
List the matter on 18th of August.
Publish.
Cell number 62. N. Vagisha.
Plaintiff's writ petition.
Yes.
Suit is for partition and separate possession. Suit filed by the sister against the brothers. But 7 and 8, defendant 7 and 8 are the purchasers of joint family property. But now cross-examination of PW1 is completed. When the matter is set down for further cross-examination by other defendants, there are 25 defendants. Now this IA number 48 is filed by the defendants 7 and 8 to include a plea of oral partition which is prior to 2003.
Amendment is filed.
Amendment application is filed.
Come to the IA that's filed.
But IA is annexure K, my lord, page 126, my lord. Plaintiff and defendants 1 to 5 are brothers and sisters. The defendants 1 and 2 had entered into registered partition deed dated 10/3/2003 prior to execution of the said registered partition dated so and so. The defendant 1 and 2 had orally partitioned in the presence of the plaintiff herein and the
No,
defendants.
not the proposed amendment application. That's the affidavit.
Affidavit, my lord. Page 128. my lord.
Suit of the year 2009.
2009, my lord. This is IA number 48. It is, as far as possible, my lord, the suit is been dragging on. Paragraph 4 is, my lord, the relevant portion. I submitted the time of filing my written statement due to oversight. Some vital aspects were left
What
out.
is the present stage of the suit?
Cross-examination of PW1 by other defendant from defendants 17 to 27.
2009 suit.
2009
Now
suit.
coming up for cross-examination.
Yes, my lord. That's
Come to the order.
page 137. Reason set, my lord, page 138. The plaintiff has filed a present suit for partition and separate possession. Defendant number 8 has filed his written statement. The proposed amendment is about explanation of facts to prior execution of registered partition deed. The registered partition deed is the contention of the defendants 2/3/2003. Now they say there was a oral partition 20 years prior to that partition, because now they found that the property what they have purchased is not.
When counsel for the petitioner submits that in a suit of 2009, the present application is filed seeking amendment of the written statement by taking in by introducing a new case and by taking inconsistent pleas, and still the court has allowed the same, considering the same, there shall be stay of all further proceeding pursuant to so and so. Notice to the respondents.
Well, and may I seek, my lord, dispensation of notice to R3 to, my lord, 27, because it's only
Notice to
7 and
R1 and R2. Hand summons, memo shall be filed by 6. Yes,
Well, I have sought for stay of this particular order.
stay of operation of the order dated so and so.
Published.
63. Devaraj HV.
For the petitioner, that the line was drawn were that in the year 1985. The transmission line was drawn in the year 1985. That claimants that property was purchased in the year 1994. Before that, that line was in existence. That after the lapse of that in the year 2016, submitted a representation claiming compensation. That has been rejected. This Honorable Court reconsideration has rejected. They have filed a 16(3) petition. So the 16(3) petition that it is gone to the extent examining under the land acquisition, it is prevailing market value 90% and solution 30% and 9% interest which has been granted in the
For
land
this
value. Yes.
laying of the electricity line.
That-
This is for laying of the electricity
Yes,
line.
yes, ma'am. Electricity.
And compensation is given as per the land.
Land acquisition.
Please come to that. Let's
The
see.
operative portion may kindly be look at. Page 194.
194.
The respondents are directed to pay compensation to the petitioners. 1023 square meters of the land affected 60 CK, 90% of prevailing
Forgetting
market
about
value.
this solatium and interest.
Together, solution 30%.
No, forgetting about it. What is the amount?
So the amount here, that what it is, that our contention before the land trial court, 1985 line was drawn.
That we will see.
Yes.
As far as the solatium.
That as per that Doddaka judgment, 30% or that they are entitled so far as that is concerned. 30% with interest it requires to be calculated. But as on the prevailing, that the rate which has been said here in the prevailing, that rate which has been line which has been drawn in so far as that is concerned.
According to you, what is the amount?
But that has not been determined in the,
Calculate it. Calculate it and tell the court.
that I'll.
Tomorrow.
Get it.
Tomorrow in the first list, AGA takes notice on behalf of respondent.
1 and 2, my lord.
1 and 2. Yes.
Then number 64. Kiran B.
I filed this writ petition for direction for speedy disposal, my lord. My lord, the suit is, I have filed, I am the plaintiff. The suit is filed for eviction and recovery of arrears of rent, my lord.
Which year?
2021, my lord. 2021, and the defendant is due of rupees 1,75 lakhs as on date, my lord.
So, why? What
And-
is the? Why should there be a direction?
Please, my lord.
Why should there be a mandamus?
No, my lord.
What is the exceptional nature of this case that this court should direct the trial court to dispose it of
Lord,
out of turn?
My lord, he is not paying the rent also, and he is not vacating the premises also, and the
He's just 58 years old. The party is 58 years old.
Please, my lord, and the defense of the defendant is also struck down, my lord, by
Whatever it is, we can't direct the court.
my lord, and the property also comes under commercial courts act, my lord, and the suit is filed before the regular civil court, my lord. And I have also brought to the knowledge of the trial court that this comes under.
Then if you file an application, the court will decide.
My lord, and the court is giving longer dates, my lord, and he is not paying the rents also, my lord, and he is not paying electricity charges also.
Please come. The present petition is filing the following prayer. The case OS number 2527 of 2021 is pending before the Additional City Civil and Session Judge at Bangalore, Mahal, and considering the pendency of the said court, and also considering the fact that this is not an exceptional case where the court has to issue mandamus to the trial court, this court do not find any reasons accordingly dismissed.
My lord, within.
5. Arun Kumar R.
For the petition, your lordship, I am the plaintiff. This suit is for partition and possession. I am for the plaintiff. An age-old lady. I filed a order 3 rule 2 under order 3 rule 2 through a GP holder to prosecute the suit through my son. The trial court has rejected the same, stating that the application, like, she has not produced the medical documents, and
What's her age?
It's around 68, your lordship. And I filed the medical records also, your lordship.
You should have filed it before the trial court, not before this court.
Like, yeah, I understand. But another point is only based on the self-serving statement of the defendant number 2, stating that she has attended some function. Based on that, the order has been rejected.
Take out notice to the respondents. Petition
Your
permitted.
lordship, only defendant number 2 has contested. Rest of the defendants have not
The
contested.
memo.
Maybe dispensed. Yeah.
The notice to defendant, counsel for defendant number 2. Memo
Maybe
is filed
dispensed.
seeking dispensation, dispensed with. If
By hand, your lordship,
if the
summons.
memo is filed by 11th of August, list of matter on 12th. Yes.
Number 66.
Much obliged.
Sir, memo is for dismissal.
Plaintiff's petition, my lord. Plaintiff filed a suit in the year 2008 in OS number 541 of 2008 against respondent for injunction, which came to be dismissed. Thereafter, he filed an appeal in RA, which came to be allowed. The same has been challenged before this honorable court.
What is that?
My lord,
Please.
initial suit has been dismissed.
You are the,
I am the plaintiff.
what is the suit for?
Suit for bare injunction, my lord. That is dismissed. Thereafter, we approached the appellate court, which came to be allowed and restrained the respondent from interference. Thereafter, he filed an appeal before this honorable court in RSA, which came to be allowed and remanded the matter, and liberty has been given for both parties to adduce evidence by producing the documents. Because at the time of hearing the appeal, both parties intending to produce some documents. To that effect, this honorable court has allowed the appeal and remanded the matter. My lords, after remanding the matter, we made an application for seeking amendment regarding intervention of court to consider the pleadings and documents, because there was no pleadings regarding documents which we are going to produce by both parties. To that effect, we have filed an application under Order 6, Rule 17.
No, because the court has permitted you to produce the evidence, you want to produce the evidence without there being a pleading.
Yes, ma'am. That's why we have requested the court by filing an application, allow the plaintiff to insert the pleadings regarding the documents which we are going to produce. But the trial court comes to conclusion that,
Order. I understood. Come to the order.
my lords, may kindly peruse the reason stated in the page number 22, may kindly peruse. The order in the petition, page number 22, annexure A is the impugned order.
Yes.
In the given facts and circumstances of the case, the applicant has failed to establish that despite of due diligence, they could not plead those proposed amendments much prior to commencement of trial. My lords, the case has been remanded only in the year 24/4/2025. Initial while dismissing my suit, there was no such documents. Those documents have been come into effect only after 2018. Therefore, both parties,
Come to your application.
my lords, make it.
Page number.
Page number 98, annexure H, may kindly peruse.
Let's see your affidavit.
My lords, affidavit is annexed at page number 102.
102 is order 41, rule 27.
My lords, it is 98, page number 98, annexure H.
No, 98. 98 is your proposed amendment.
Yes, my lord.
Correct. Then what is, where is the affidavit? In
Affidavit
support?
annexed to this application, 102.
102 is application under order 41, rule 27.
I think some wrong document has been. In the said application, the pleadings is very clearly says that after 2018 documents recitals, my lord.
You don't say anything in your application. Without filing an application, how can, what is the purpose of, there is a purpose for filing an affidavit in support of an IA, to understand what is that you want to introduce or why you want to do it. Why are you doing it now?
I will check it out, my lord, because
This is matter on Thursday in the first list. The petitioner shall file the application that's filed before the trial court. Yes.
Cell number 67, Nandini B for petitioner.
So in this matter, the suit is for the partition and separate possession, my lords. And the petitioners herein are the daughters and the plaintiff. And we had filed an application for 39 rule 1 and 2, my lords. My lords may kindly see page 20, my lords. The trial court has only issued notice, my lords, and thrice we have genuinely taken steps. And the defendants are purposefully evading the notice, and they are trying to alienate the property, my lords.
Agreed with the order dated 23/1/2026, whereby the trial court has issued notice
On 28/10/2025.
28?
28/10/2025.
28/10/2025, whereby the trial court has issued notice, has issued suit summons on an IA seeking injunction. IA number?
IA number 1 of 2025.
IA number 1 seeking injunction, and whereby the defendants are thereafter the defendants are evading the summons and are proceeding with what they're doing.
Trying to alienate the property.
And they're trying to eliminate the property. The land council submits that when an application is filed seeking ad interim injunction, the court has to consider the application on its merits. If in this manner, if the suit summons are issued, and by that in the meantime, if third party rights are accrued, it would cause a lot of hardship to the party. This aspect was not considered by the court. She has relied on a judgment of the coordinate bench, same order, 1 week.
My lords.
Notwithstanding the fact that.
My lords, until then.
No, until then. Yes, next.
Much obliged.
Cell number 68. CP Muktana.
My lord, yesterday your lordship has directed me to produce a record to show that approved BD approved plan has been filed before the court or not.
Take that.
Is
You
art-
given him a copy?
Yes, my lord. Yesterday only I served on.
Copy has not been given to me, sir.
Allah, this is copy.
What is this, Mr. Muttanna?
Writ petition copy is
Where
not-
is the copy? You say that something you filed, where is
No,
that?
that's order of the court, my lord.
Huh?
Order of the court, learned court, they said, OS
Plaintiff
submit.
respectively submit the certified copy of the layout plan is herewith enclosed.
Yes, my lord.
May please to take the same on record.
Yes, my lord, this order.
Lord, now please look at the application that is being filed now to summon the official from the BDA. Previous High Court order was specifically said that the document, whatever he wants to produce, that can be produced. And marking of not marking, it
It
is
will be
left for the
subject
court.
to the.
So now again, this application will be filed for summoning of the BDA official. When the document is already been produced, there is no question of summoning an official from the BDA.
My lord, earlier also the two applications were
Unless
filed, my
this is the
lord.
second time, third time the application is being filed. Similar
Now-
application, but it is not progressing from thereafter.
No, my lord, that is why yesterday also I submitted before the court within 3 months or 4 months, that entire this will be over. And your lordship said if it is not, again application is filed, that original suit will be dismissed. For that also agreed. Because unless this document is produced, my lord, this entire case is revolving around that document.
No, you have produced it
I
already.
will produce now, it is to be marked now. Without marking, what I can do, my lord, because without marking the
It's
document.
not on marking of the document. It is about the present IA is about calling the BDA official.
Calling
Oh,
the
that is
BDA
all,
official
both.
and reopening the
This order, my lord.
recalling the witness and reopening
My
the
lord, this
document.
order may kindly.
What we do is, as far as reopening the matter for marking this document is concerned, we'll.
That is not, well, that is not been objected also with that. He is free to
No, no,
produce
no.
the document.
Come to the impugned order, we'll see what did the court say and
Yes,
what
my
is the
lord. Annex
application.
A, my lord.
Page number,
Application or order, my lord? Application.
order,
Order, my lord. Annex A,
page number,
page number 22.
yes.
Both these applications are filed by the applicant, plaintiff, under section 150 and another IA filed under section so and so to recall the order dated so and to summon the BD official to produce the documents and give evidence upon the.
What he
Same.
is saying is, you have produced the document. Why should the BDO officials?
No, my lord, this exactly, my lord, this now, this matter, my lord, only 1 second I will take, my lord. Earlier BDA, they are directed to demolish that building. And then they came to the court. Then because of the OS is filed, that BDA is keeping quiet now. Now BDA person will come and BDA official will come and tell that this 2-3 sites belong to the Canara Bank Employees Housing Society. That is only the one question, my lord. The 3 sites now, according to the BDA, that are earmarked for CS sites.
So, to put a quietest to
These
all
two, kindly permit, my lord, that ultimately.
all this, will say, except this, the petitioner undertakes before the court that he will not come up with any
Yes.
kind of application.
Yes, my lord.
And by calling so and so,
Yes, ma'am.
will allow this within 3 months, the suit has to be disposed of.
Please, ma'am, that could be done.
But both these are, both the prayer may be considered.
Now, both will
Yes, ma'am.
will consider and will say that if you, and it is undertaken, file an affidavit before
I
the.
have undertaken, that is true, my lord.
No, you advocate can't undertake.
No, I will file.
You file an undertaking affidavit, tomorrow I'll dispose of.
No, today only I will file afternoon, my lord, because the day
yes.
after tomorrow, the case is there.
2:30, you please call this, an affidavit that you will not file any other applications and you will cooperate with the court to dispose of the matter within
4
3
months. 4 months, because that you do not, 4 months.
3 months, you said, within 3 months.
Yes.
And if any applications further, if it is filed, the
OS will
the
be
court
dismissed.
can dismiss the
Yes,
suit
that-
itself,
that is
is your
true.
undertaking.
4 months your lordship can give, because now we do not know.
Yes.
4 months.
Yes, 4 months.
Yes, ma'am.
Come up with an undertaking afternoon. Yes.
Cell number 69. Subramanya Bhatt, 69.
Backbilling of the installation of the petitioners. My lord, what happened is that, my lord, the petitioner is running a charitable trust. My lord,
Take notice on the council who is, where is that list? Bescom? Mr. C. Chennegowda is directed to take notice on behalf of the respondents. Petitions are the copy of the, say, writ petition on the council, print the name of so-and-so. List this matter on Friday in the first
my lord,
list.
can I just seek my lord's indulgence to grant me an interim order, because my lord now.
No.
My lord,
If
there
you
is a-
want it tomorrow also, I'll take it up, but I'll not grant interim order without hearing them. Tomorrow or on
Friday.
Friday.
Great.
Print the name of so-and-so.
Praveen HP for petitioner.
Was appearing for the petitioner in this matter, my lord.
Yes. Lord, since I'm appearing for the caveat respondent.
Yes.
My Lord's permit, I have my objections are ready to file. I'll file it today itself.
You have to serve on
I've
him.
served, I
Just
but
now
I've
it is
only served on
served.
them
One
now.
submission, my lord. On previous occasion, my lord, there's an oral undertaking given, my lord, not to precipitate the matter.
I requested court, my lords, to record the same. My lord said it is not necessary.
So the advocate
We did
said.
not, my lord.
Because, my lords, when we appeared before the trial court, outrightly it was rejected, my lords, saying that there's no instructions. We have not given such undertaking, my lords, and
I'm
pressure was
surprised to
built
hear
on the
this, madam.
court.
I will look into this immediately.
Then-
From our side, we have very clearly informed them. In fact, our instructions are that the matter has gone to 31st of August. I'm surprised to hear this, my lords. We have
I'm
given
not
very clear
blaming my learned friend,
instructions.
my lords, it
Now
might
the
have been.
matter is posted to 31st August.
31st for charge,
31st of August.
for charge. Now, my lords, attachment warrant is issued. If I may, please. my
No,
lords,
argue,
Please,
because the
please.
other day there was no
Please.
time, that's how it is.
Please, please.
Yes.
I'm grateful. My lords, impleading IA, my lords, is filed under Order 1 Rule 10, read with Section 18 of the Industrial Disputes Act. Now, my lords, I will submit the facts, my lords, in brief. My lords, what happens? In 2003, my lords, I purchased.
To order.
My lords,
Because
Annexure A.
that's we have to look at the best way which will save the court's time. That is reading the order. Where is the order?
My lords, Annexure A, my lords.
Page number.
May I draw my lord's attention to operative portion at page number 28 and 29. 28 and 29, my lords.
No, it's a small order, we'll read.
Please, my lords. Para 5, I may be permitted to read, my lords. In view of the contents of the affidavit of averments, it is found.
It starts at page 26.
Please, my lords.
We'll read it from the beginning, we'll understand.
From 26, my lords.
Yes.
Please. My lords. The learned counsel for the applicant filed the present application under Order 1 Rule 10 2 CPC, read with Section 18 of the ID Act, seeking prayer to implead the proposed judgment debtor in case in order to execute the award passed by the Honorable Labour Court in reference number 20 of 2002 on 15/5/2009, accompanying the affidavit duly sworn by the applicant. It is averred by the applicant that the proposed judgment debtor is the purchaser of the company by the judgment debtor through a registered sale deed on 28/11/2003 during the pendency of the dispute before the Honorable Labour Court. However, the judgment debtor has not informed this fact to the Labour Court. The cause notice on this execution petition itself could not be served for a number of years, and death of the managing director who was representing the company came to be known only through print media. Then only efforts were made to know the ownership, and then he came to know that the company has been sold for a consideration of 1 crore 10 lakh to this proposed judgment debtor. It is further averred that the application filed to bring the legal heirs was dismissed on 16/4/2019 by observing that since the company is a legal entity, he has to proceed against the company only. Thus, another application seeking issuance of summons to this proposed judgment debtor was filed on 5/8/2019, and the service of the same was rejected by this proposed judgment debtor on 21/9/2019. In the affidavit accompanied to that application, it was pleaded that as per Section 18 of the ID Act, award is binding on the purchaser being the successor in interest. Thus, the attachment of movable was ordered, which could not be executed as this proposed judgment debtor obstructed. Thus, on 16/11/2019, an application seeking police protection was sought, and the same was allowed on 7/12/2019. But for the some or the other reason, he could not reap the benefit of the award passed by the learned Honorable Labour Court. Being purchaser and doing the business in the same premises as per Section 18 of the Industrial Dispute Act, the proposed judgment debtor is bound by award passed by the Labour Court in reference number 20 of 2002 by stepping into the shoes of the original judgment debtor. Hence, the new incumbent is a necessary party, and being bound by the provisions of the ID Act is a proper party to answer the award which is being executed in this petition. Hence, prays to allow the application. On the other hand, the proposed opponents filed the objection resisting the application filed by the decree holder. It is contended by this opponent that the subsequent to death of Manoj R. Mehta, the decree holder, instead of proceeding against the company, has made legal heirs of the late Manoj R. Mehta as proposed opponent, which is not legal. The decree holder, if at all, has any legal right, has to go against the company and not against the legal heirs of the managing director of the company. These opponents are no way connected to the business of the judgment debtor when it was functioning.
Yes, I've seen that. Order 1 Rule 10 is allowed.
Please, my lords. No, my lords.
Who are you?
My lords, I am the purchaser of the land and the building, my lords, which is constructed on that. I have not purchased the goodwill. I have not purchased the machinery. I am not running the same business. The earlier business, my lords, was in the manufacturing and selling of the umbrellas. I am in the manufacturing of electronic equipment to the automobiles.
When was the attachment of the property?
My lords, sir, on 10/7/2026, my lords, at page number 30, it is there.
When did you purchase the property?
2003, my lords. On 28/11/2003, I purchased the property. award was passed, my lords, against the decree holder, judgment data 1 on 15/5/2009. My lords, 2014 they filed the execution. 2026, my lords, I was impleaded. My lords, I appeared before the court. My lords, I submitted. My lords, may kindly see the sale deed, my lords, which I have produced at page number 74. My lords, the property which I purchased, my lords, was mortgaged to a federal bank. The entire sale consideration, my lords, has been paid to the federal bank, which is forthcoming, my lords, from the governments in the sale deed. My lords, may kindly see the schedule to the sale deed. My lords. Schedule clearly prescribes, my lords, I have only purchased the asset, that is land, and my lords, a shed which is constructed thereon. I have not purchased any of the machineries. And my lords, the Supreme Court and our own High Court, my lords, in plethora of judgments have clearly said, my lords, if at all, my lords, it has to come to a conclusion that there is a transfer of business, please.
Yes.
What are the things to be considered? My lords, first thing which has to be considered is, my lords, whether it is an ongoing business. My lords, it was not an ongoing concern, my lords, when I purchased it. In 2001 only there was a lockout. Then, my lords, completely different business I am running, my lords. And I'm running it in my own name, not in the name of the company which was closed. Then, my lords, I am a partnership firm. I was constituted in 1983, reconstituted again and again. Annexure B series, my lords, is my partnership deeds which I have produced before, my lords. My lords, how can a partnership firm, my lords, become a successor in interest to a company without complying Chapter 9 of the Companies Act?
Yes.
My lord, may just see the award that has been passed. It is, the award is passed in reference number 20 of 2002. The conciliation was raised, my lord. What had happened was that they were all employees of this company called Fuji Private Limited.
Award is passed on 2015.
It's passed
by
in
2009.
Yes.
By that time, the property is already sold to him in a public auction by the bank.
Please, my lord, I'll just make my submission on that. It is, the award is passed in a reference that has been raised, in a conciliation that has been raised in 2002. It goes back, the award, my lord, goes back to 2002 when the reference is raised. The date of reference is 9/1/2002. It's at page number 87, at the first page of the award. On 9/1/2002, the reference is raised. The reference is raised in respect of the illegal lockout that has been done by the employer. The award that is passed is that the lockout that has been done is illegal, and directing the employer to pay the back wages for the entire period till the date of the award.
Yes.
Now, my lords, insofar as Section 18 of Industrial Disputes Act is concerned, Section 18 of Industrial Disputes Act, if I may just read that out. Persons on whom settlement and awards are binding.
Yes.
My lord, only C, Section 18(3), a settlement arrived at in the course of a conciliation proceeding or an award of a labor code which has become enforceable shall be binding on C, where a party referred to in clause A or clause B is an employee, his heirs, successors, or assigns in respect of the establishment to which the disputes arise. Our submission is that this particular, the petitioner herein, they are the successor in interest insofar as the establishment is concerned. Now, insofar as a question of goodwill, insofar as a question of that it should have been a going concerns, these aspects have been considered by this honorable court. There is a judgment of a division bench of this honorable court where it has been categorically held that it's not necessary that goodwill has to have been purchased. It is not necessary that it had to be a going concern at that point of time. They have purchased not only the land, my lord, land, the machinery, all that was there.
If the property is with the bank, what should be done?
I'm sorry?
He has mortgaged the property to
Please.
the bank. If the property is with the bank, what would be how you will execute it?
Ultimately, my lords, insofar as the workers are concerned, their rights are protected, and even though the award may have been passed subsequently, it goes back to the date of reference,
correct,
which is
but I
prior.
understand. No.
Please.
This property is mortgaged to a bank.
Please.
Assuming that,
Yes.
as on today, the property is with the bank.
Please.
Because it's a secured creditor, it is with the bank.
Please.
Then how would you realize it?
What would have happened if it was still with the bank is that the workmen are in fact secured credit, are deemed to be looked at as secured creditors. If, for example, it had gone into winding up, for instance, then workmen are also considered as secured creditors, and they will get it pari passu with the bank and other secured creditors. That would be what would have happened if it was still mortgaged and if it had gone into winding up. Then workmen are placed on par with secured creditors, the rights of workmen. This is how it would be if
No,
it
he has
was.
purchased a property in a public auction.
Please. Please, my lord. So the question before the court ultimately is whether he becomes a successor in interest as mandated under section 18(3)(c). That would be the question before the court. If it is held that he is a successor
But
in
by
interest.
interpreting it in that way,
Please.
it is an injustice to the petitioner.
I'm sorry?
It is an injustice to the petitioner. And what is happening to the company, their successors who have enjoyed the fruits of it?
My lord, insofar as what section 18 prescribes, it is no doubt different from other statutes. But section 18 specifically provides that even a successor.
So we can understand, provided he has purchased a property from the company.
Please.
But he has not purchased a property from the company.
Please.
In a secure, when the property is mortgaged,
please,
the securitator has conducted the auction.
Please.
The auction, he has purchased the property. So no, the debts, it has become it's a secured debt to the bank.
Lord, the absolute sale deed which they have produced, it is between the company and them, not bid by the bank. My lords may just see page 74.
My lords,
This is the absolute sale deed.
You said you have
company and the
purchased it
bank.
from the federal
My lords,
bank.
it was mortgaged to the bank, my lords. It was, the condition was that entire amount has to be given to the federal bank to satisfy the loan. My lords may kindly see page number 81. My lords may kindly see page number 81, my lords, of the sale deed, registered sale deed, my lords.
Yes.
My lords, last paragraph I may be permitted to read. Last second paragraph. And whereas the seller has obtained a loan from the Federal Bank Limited, Mysore, and the said loan is not cleared, hence seller requested the purchaser to pay the entire sale consideration of 1 crore 10 lakh in favor of the Federal Bank Limited, Mysore, in order to discharge the loan and to redeem the mortgage, for which the purchaser has agreed to pay the same and to the Federal Bank with the consent and knowledge of the seller, for which he has no objection. And whereas the purchaser has paid the entire sale consideration amount of 1 crore 10 lakhs in 2 tranches, my lords, I have mentioned, my lords, in favor of the Federal Bank. My lords, entire sale consideration has been paid in favor of the Federal Bank. Now, if one more submission, there is
Any judgments you're relying on? Take that.
My lord, page. Just before I go to the judgment, just one page 74.
74.
This is, please, of their petition, which is the absolute sale deed. What understanding is there between the purchaser and seller, my lord? That is between them. But that under no circumstance this was sold in an auction by the bank. Page 74, only to point this out, absolute sale deed. It's made between Fuji Umbrella Private Limited and between this multi-link, which is the firm here.
Yes.
My lords may just see this judgment which I have passed on.
Paras, which paras you're relying on?
I'm relying on para 15, my lords, para 15 onwards. ILR 2013, Karnataka 1861.
Yes, yes.
May I request my lords to please see para 15.
15.
Yes. It looks at at section 18.
Yes.
Having regard to the aforesaid dicta, what needs to be emphasized is that the award is enforceable against the employer or his heirs, successors, or assignees in respect of the establishment to which the dispute relates. The expression establishment, as per advanced law lexicon, having regard to various legislations concerning regulation of business and labor, means any office or any place where any industry, trade, business, or occupation is carried out, which includes a commercial establishment, forum, or any other place of public amusement or entertainment. The expression in respect of gives a wider meaning to the term establishment, which has been interpreted in several judgments by the Apex Court. My lords, I'll just, if I could then take my lords to para 17.
Yes.
This para 16 is relevant insofar as to say that the word establishment has a wide connotation and it has to be given a wide meaning.
So let's understand from 17.
Please.
Some of these tests can be applied.
Some of the tests can be applied to in the instant case. Did the purchaser purchase the whole of the business? Is the business
No, pausing here. What is the answer to this?
My lord, insofar as this is concerned, the entire concern was taken over.
Business premises are two different things.
Please.
So the first is, did the purchaser purchase the whole of the business?
Please.
No. As far as this fact.
If my lord would permit, if I could read 17 entirely, because what the Honorable Court also says is that one test does not stand
That's
like
why we will take
independence.
one by one.
Please.
So test one, no.
No.
Then?
Yes, my lord. Is the business purchase carried on at the same place as before? Yes.
No, this is, you have to read along with this.
Please.
That is, business is purchased and the same business is run in the same premises. So if you have to look at it, is a business purchased? No. Carried on the same place as before, the same business is a no.
My lord, insofar as we are concerned, our submission is that it was entirely purchased. What they have produced over here is a sale deed, which shows that which shows the purchase of the land and the
No, to show that.
other aspects.
To show that.
Yes.
Is continuing the same business
Please.
as that of your employer. What is the material before the court? Any
No,
material?
that actually, in fact, insofar as that is concerned, before the court, there was an impleading application that was filed. That application has been allowed, in fact, Malad, just to be fair, in that application, in the end, they say whether this is a running concern or not is an aspect that will be considered subsequently. That is an aspect that has been left open in that sense. So that was not actually looked at. But it is our submission that they are.
No. Why can't you raise all these issues before the trial court?
Malas, for two reasons, Malas.
No.
In
When an application is filed under Order 1 Rule 10, all these intrinsic things will not be gone into by the court, like the trial will not be conducted at this stage. Now, once you're impleaded before the court, then you will be telling the court, like, I do not fall under any of these exceptions. I'm not doing the business. For that, evidence is required.
Please, Malas. Under section 47, Malas, I can approach. Malas, the difficulty is this, Malas. At para 5, there is a clear-cut finding, Malas. And the claiming, while giving the finding also, there is no application of judicious mind. I will only take 30 seconds.
No.
Malas, because
Going forward, when we are looking at this judgment, now to give any findings on that, evidence is required. At this stage, we cannot. So what I'll tell the trial court is, you are only impleaded, and all issues pertaining to whether you are liable to pay that amount or not, everything should be decided by the court. And after you let in your evidence.
Malas, in that case, Malas, I request Malas. Malas, may I draw my law's attention to page number 29, operative portion of the order. After considering the application for 2 years, 29, Malas. Para 2 may kindly be seen. The applicant is permitted to implead herself. The applicant is permitted to implead page number 29, Malas, operative portion of the order. Para 2. The applicant is permitted to implead herself as proposed judgment debtor in the above petition. In para 5, Malas, it says, after that, the property is followed to the decree holder number 2. These are the findings which is given by the trial court. Malas, I am not the person, Malas, who has filed impleading.
No, probably what the order is. So application is allowed, and he is impleaded as the so and so. Instead
Malas,
of that,
I will take it.
So what we do is, I'll clarify all this and let the court do the exercise.
And page number 31 also, Malas. 31.
Hmm.
Malas, then I file the objections, Malas. Then the operative portion at page number 31. At this stage, this court finds no reasons not to proceed against JDR2. If JDR2 has grievance against the said order on I number 1, it is open for him to question it.
As long as that issue is decided, you can't proceed with the execution. The court, that I'll record.
Malas, my only humble request is, Malas, let that option, Malas, to decide whether I am a successor in interest or not should also be kept in open, Malas.
Yes.
Because I have to lead evidence, Malas, to show that I have not purchased the business at all.
Yes.
Please, Malas, I will be with.
My lord, let it be open on all sides. And we will also lead.
Meanwhile, Malas, there should attachment warrant should be.
You shouldn't do anything.
Please.
Yes, my lord.
Because
this
that's
issue
his property.
My only request is some time limit may be given, because we have been out from 2002.
Yes. Agreed with orders passed on I number 5 in execution number 501 of 2014 by the principal senior civil judge and CJM, Mysore. The petitioner who is the petitioner who is impleaded as a judgment debtor is before this court. The respondent herein, who is a decree holder, filed an application under Order 1 Rule 10(2) of CPC and Section 18 of the Industrial Disputes Act, seeking to implead the proposed judgment debtor in order to execute the award passed by the Labour Court on 15/5/2019. It is the case of the judgment debtor that the proposed party is a purchaser of the company through a registered sale deed on 28/11/2003.
Not the company, my lords, asset. Only the land I have purchased, not the.
No, that is, I'm recording something from the order. That is their case of a company by the judgment debtor through a registered sale deed on 28/11/2003 during the pendency of the dispute before the labor court. And he has not informed the said fact to the labor court. Thereafter, the award was passed. No, it is a case that the reference is on line 1/2002 and an award was passed on 10/7, on 15/5/2009. The petitioner has purchased the property, the petitioner herein has purchased the property in the year 2003. The court, by order impugned, has allowed the application. The court observes that in view of the contents of the affidavit appearance, it's found that the deceased JDR was managing director of the company. After his death, the estate followed to the legal representative of the said deceased. Hence, it is found just and necessary to allow the application in the interest of justice and equity. Whether the opponents are liable to perform the decree or not has to be decided at a later stage.
My lord, I'm sorry. I think my lord has a wrong order. Yeah, it's a different order that is challenged by them.
It is not on IA number 5.
Sorry, my lord. I apologize.
Yes. At the latest allowed the application. Then counsel appearing for the petitioner submits that he has purchased a property in 2003. The original owner of the property has mortgaged the property to the federal bank, and the entire consideration of 1 crore 10 lakhs he has paid to the bank. It is the case that he has purchased only the land, and thereafter he has established his own business. He has not continued the earlier business. Hence, he cannot be termed as an assignee of the
successor
in interest.
Successor of the original employer. It is submitted that he is not a proper and necessary party to these proceedings, and he is not a judgment debtor, and the amount cannot be recovered from him. Failed to consider all these aspects, but simply allowed the application filed under Order 1, Rule 10. Next paragraph. Then counsel appearing for the decree holders submits that the court has rightly considered the scope of the application and has conducted an inquiry that is required under Order 1, Rule 10, and rightly allowed the application. The court has also observed that whether the opponents are liable to perform the decree or not has to be decided at a later stage. Then counsel submits that High Court in case of M.N. Karyappa, dead by Large versus Srimati Rosamma and Anuja, reported in ILR 2013 Karnataka 1861. It is submitted that the petitioner is a necessary party, and the court has rightly allowed the application, and no interference is called for with the order passed by the trial court, with the executing court. Next pair, having got the counsels on either side, there is a material on record. According to the petitioner, he cannot be termed as a successor. He has not taken the business. He has only purchased the premises, that too by paying the entire amount to the bank, which the original employer has mortgaged to the federal bank, and this is in the year 2003. According to the land counsel for the respondent, that he is continuing the business in the said premises, he has to be, as per the law laid down in the by the division bench of this court in the judgment referred to supra in M.N. Karyappa's case. is he is a successor in interest. And as per section 18 of the Industrial Disputes Act, is bound by the award. In the light of the respective contentions raised by both the parties, unless and until a detailed inquiry is conducted by the court with regard to whether the petitioner is liable, can be termed as a successor as per section 18 of the Industrial Dispute Act, and as per the judgment of the division bench of this court in M.N. Karyappa's case, whether as discussed at para number 17 of the order, whether he would fall in any of those categories, all these have to be decided by the court. In the considered opinion of the court at this stage, the unless and until is impleaded, and unless and until evidence is placed on record, the court cannot go into all those aspects. Further, court has not given any finding about the liability of the petitioner. In the light of the same, this court do not find any reasons to interfere with the order impaired. Accordingly, this court is passing the following order. The order impugned do not warrant any interference of this court. Number 2, the trial court shall conduct a necessary inquiry, giving a reasonable opportunity to both the petitioner and the respondent to substantiate their respective cases, and shall pass and shall conclude this inquiry within a period of
6 months,
3
1
months.
year.
3 months.
No, section 47, I have to file it
within
now.
a period of 6 months from the date of receipt of the copy of the order. Both the parties shall cooperate with the inquiry, shall cooperate, and shall not take unnecessary adjournments accordingly disposed of.
Malas, the finding that I am the successor in interest for legal representative has to be successor because the order has been confirmed.
No,
To that extent, Malas, it should be mentioned.
Any of the, as number 4, as the court has left it open to decide about whether the liability of the petitioner, any of the observations contrary to that will not bind the petitioner.
My lord, the judgment, my lord, is referred para 17. It's para 17 to 21, my lord. Is
17 to 21.
Grateful.
Yes.
Number 71.
My lords, I am appearing for the petitioner, my lords. The petitioner herein is seeking for writ of mandamus, my lords, to consider the application for grant of CL7 license, my lords. As per annexure B, my lords.
In accordance with my consent. Let them give a representation.
Without giving a representation, they are coming here.
Yes, my lords.
How can they
No,
come?
my lords. The application is annexure B, my lords. May kindly see, my lords.
That is the application. Representation is
That has to be considered, my lords. Annexure B, my lords.
What is the submission, Mr. Rishi?
I'm saying, my lords.
They're seeking a mandamus to consider their application. You
Please,
say that
please, please. I'm
representation should be given.
I'm sorry.
How much time you want?
4 weeks, my lords.
The writ petition is filed. Seeking the following prayer. Then counsel for the petitioner submits that they made an application on 4/3/2026, seeking for grant of license in form CL7, but it is a grievance that the the respondents have failed to consider the same. Hence, petitioner is before this court. Then an AGA who takes notice on behalf of respondents 1 to 4.
Please, my lords. All the respondents.
1 to 4 submits that they'll consider the same in accordance with law. Considering the submission on behalf of both the parties, this court is passing the following order. The writ petition is disposed of, directing which respondent has to consider?
My lords, 2, 3, 4, my lords. The respondent CL7, my lords.
Why will all consider? There will be one
My lords,
authority.
it is a procedure, my lords. So, they have
Respondent
to.
number 3.
The respondent number 3 shall consider the application of the petitioner within a period of 4 weeks from the date of receipt of the copy of the order.
Please, my lords. Oblige, my lords.
With my lord's leave, my lord.
Yes.
My lord, serial number 84, this matter was heard yesterday. Lord, 88. Lord, I am seeking leave to withdraw the writ petition, my lord. I have informed the other side also. Kindly permit me to withdraw.
Yes, a memo is filed seeking to withdraw the writ petition, accordingly dismissed as withdrawn.
Grateful.
My lord's kind permission, One matter, end of the list, my lord, because the matter pertaining to excise matter, my lord, the action to be held on day after tomorrow, my lord.
It will come tomorrow.
Submission. Kindly have it tomorrow itself, my lord. Today I have filed it. Tomorrow it may be
What are
considered.
you doing till now? You please tell the
Today,
court.
today
You-
we have filed it.
You file it in the morning, every
Allah,
matter
it is
that
covered
filed
by
in
the
the morning.
judgment of this
Whatever
honorable
it is,
court.
why
It is
should we
kept in
take
abeyance, my lord.
out of the way?
Sorry, apologies for that. My urgency is that, my lord. Tomorrow, your lordship.
What were you doing in the morning?
Morning, today we have filed the writ petition, my lord. That's why the time was taken. That's why. I requested, my lord. That's why.
1:30, I don't take up the mentionings.
Tomorrow, your lordship.
No,
Kindly.
1:30, I don't take up the
Sorry,
mentions
sorry for
at
that.
all.
I requesting your lordship for that purpose. Urgency is there, my lord.
If you file it, it will come tomorrow. That is what all I'm saying. If you comply with the office objections, it will come with tomorrow.
If I give the memo today, my lord, they will take it.
That is the old story. Now
That
it is not.
that is
They
the
don't
my lord.
work
My
like that.
request is not, my lord. I am not. I'm not disturbing the procedure of the court, my lord. This is the only
Submission, my lord.
tomorrow, your
My lord,
lord.
submission.
ಅದು 84 ಅಲ್ಲ ಅದು
ಕರೆಕ್ಟ್ ಮಾಡೋದು ಸರ್ ಸರಿ ಕರೆಕ್ಟ್ ಮಾಡಿ
Madam? Madam? Court officer?
ಹೇಳಿ ಮೇಡಮ್.
Madam, B group ತಗೋತಾರ ಮ್ಯಾಮ್? B group.
ಮೇಡಮ್ ಅದು ರೀಚ್ ಆಗೋದು ಲಿಸ್ಟ್ ಗೊತ್ತಾಗಲ್ಲ ನೋಡಿ ನೀವು.
ಬರ್ಲಾ ಇಲ್ಲೇ ನೋಡ್ರಿ ಇಲ್ಲೇ ಇಲ್ಲ ಬರ್ತೀನಿ ತಡೀರಿ.
ಅಲ್ಲ ಎಷ್ಟನೇ ಸೀರಿಯಲ್?
133.
ನಾವ್ ಹೆಂಗ್ ಹೇಳೋದು ನಿಮ್ಗೆ?
ಬರ್ತೀನಿ ಏನ್ ಮಾಡೋದು ಬೇಕಾದ್ರೆ ಬರ್ಬೇಕಲ್ಲ ಬರ್ತೀನಿ ಬಿಡಿ. ಇಲ್ಲ
ನಿಮ್ಗಿಂತ ಮುಂಚಿಂದ ಏನಾಗುತ್ತೆ ಅಂತ ನಮಗ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
ಅದ್ ಸರಿ.
ಅದೇ.
ಸರಿ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು.
ಇವ್ರೆ ನಾವೇನು ನೀವೆಲ್ಲ ನೋಡಿ ಹಿಂಗೆ ಏನ್ ಗೊತ್ತಾ ದಟ್ ಪಾರ್ಟಿ ಪರ್ಸನ್ ಏನ್ ಗೊತ್ತಾ ಸರ್, ಪಾರ್ಟಿ ಪರ್ಸನ್ ಹ್ಯಾವ್ ಯು ಸೀನ್ ಇಸ್ ಮೆಮೋ ಕಾಂಟ್ಯಾಕ್ಟ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್ ಅಂತ ಒಂದು ಮೆಮೋ ಹಾಕಿದಾರಲ್ಲ. ಈ ಮೇಕಿಂಗ್ ಅಲಿಗೇಷನ್ ಆನ್ ಎವ್ರಿಬಡಿ, ಕೋರ್ಟು, ನಾನು, ನೀವು ಎಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ ಎಲ್ಲರ ಮೇಲೂ ಈಸ್ ಮೇಕಿಂಗ್ ಅಲಿಗೇಷನ್ಸ್. ಅದಕ್ಕೆ ಮೇಡಮ್ ಹೇಳಿದ್ದು ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ದಿ
submission. I being a citizen of the United States facing a life threat by a mob created by a white collar criminals, being colluded with the internationally organized white collar mafia involved in human trafficking law. I'm in India chasing that mafia. So consequently, the situation hence the matter may be most posted tomorrow. My lord.
What does that matter?
There is a,
What is that matter?
there is a, the IA under the CPC IA filed to consider filing the writ petition. Written statement. The written statement I failed to file.
No, first, why are you making a mention now?
Sorry,
Have you seen the cause list? Nobody can make a mention at this time. It's only at 10:30.
My lord, there is a criminal situation where I'm facing life.
It is a CPC matter. Where is a criminal situation?
There is assault. There is a gang.
No, how does it, if this matter is decided?
This matter created by the criminal intention, this matter has been created, my lord. You base.
Give the memo to the court officer, LC.
My lord,
Yes.
Serial number 94, it has rendered infructuous, my lord.
Take that.
94.
Memo is filing to withdraw the writ petition. Dismissed as withdrawn.
Objection.
How many, yes, Mr. Huh? Oh, I'll call that. No, how many 230 matters are there? This 230 matters I'll not be taking up today. The list is more. I'll continue with this, with the list. Yes. Yes, Mr. Vignesh Shetty, yes. I'll take up this matter. Where is the?
1152.
Huh?
Is for the
Yes.
purchase.
Where is the
petitioner.
counsel for the petitioner?
Petitioner, kindly put some senior.
Money is, DD is there or not?
DD is there.
Huh?
DD is there.
It is there? I'll take it up at the end of the list, this matter. Yes. Call the passwords first.
Passover, serial number 4.
Appear for the petitioner, my lord.
Yes.
We'll go back. We'll go back before the same court. Now, let there be an observation, my lord, that
Yes.
uninfluenced by whatever has transpired.
The present writ petition is filed. Agreed with the order dated 13 July 2026. Even civil miscellaneous number 46 of 2026 by the Principal District and Session Judge Bangalore. The petitioner herein, who is plaintiff in the suit, filed a suit for permanent injunction. While the suit is pending before the court, he has filed the application under section 24, read with 151 CPC before the Principal District and Session Judge Bangalore, seeking transfer of the case to any other competent court, seeking transfer of the MA number 10 of 2026 on the file of the second additional senior civil judge and JMFC Anikal, Bangalore, to any other competent court to adjudicate the matter in the interest of justice. Before that, they have filed an IA seeking interim injunction, and the same was allowed on 23/2/2026. That order is assigned before by filing MA number 10 of 2026 before the first additional senior civil judge Anikal. In that, the present application came to be filed under section 24, read with 151 CPC to transfer MA number 10 of 2026 on the file of the second additional senior civil judge and JMFC Anikal or to any other competent court. That came to be dismissed by order impugned. While dismissing the application, the court has observed that according to the petitioners on 7/4/2026, they were very much present at the court hall from 10:45 AM onwards. The matter was not listed and the case was not called called out, and after first round, the presiding officer asked about their case and with regard to their memo. The court observes that hence the set facts goes to show that by the time the case was called, the petitioners might not be present in the court hall, and hence a trial judge might have passed the orders. Therefore, it appears that there is no such denial of reasonable opportunity to the petitioners in conducting their case. As such, the relief as sought cannot be granted, and accordingly dismiss the application. Land counsel appearing for the petition shall record all that, or without that?
Not
Land
necessary, my
counsel
lord.
appearing for the petition submits that they have sought for transfer, stating certain reasons, and the same was not appreciated by the principal district judge, and has just on assumptions and presumptions, the order came to be passed. It is submitted that when an application is filed under section 24, the court has to consider the same in accordance with law. Hence, the order needs to be set aside. Next paragraph. Having heard the land counsel of the petitioner, produce the material on record. It is a grievance of the petitioner that a fair opportunity was not granted, was not being given to the petitioner while deciding the MA by the which court?
The appellate court, my lord. Second additional, my lord, senior civil.
By the second additional senior civil judge, and by the second additional
Senior. And JMFC Anekal, ma'am.
Anekal. This court has perused the writ petition and also the order passed by the court. Considering considering all this, and also balancing the interests of the parties without going into any of the merits of the matter, this court is passing the following order. The writ petition is disposed of, directing the learned so-and-so MA. 1 minute.
May 10 of 2020.
Yes. The directing the second additional senior civil judge and JMFC to consider AMA number 10 of 2026 in accordance with law by giving a reasonable opportunity to both the parties, and shall dispose of the same as in accordance with law, and not without considering all these aspects of that the petitioner has sought for a transfer from the said suit. The learned judge strictly shall pass the order in accordance with law by giving reasonable opportunity to the parties.
Obliged, ma'am. It's
Yes,
not a
please.
writ petition, my lord. WP, it's been mentioned in the writ petition. It has to be CRP. ma'am.
Yes, CR.
Please.
Yes.
Obliged.
Cell number 68.
Yes, Mr.
Putana.
Where is the other side?
Ken Vasudevan.
Take the copy. Where is the impugned order?
Input order is annexed A, my lord.
Page number.
Page number 22.
Petitioner is before this court, agreed with the order dated 6/7/2026, passed with the principal city and session judge in OS number, in IA number 12 and 13, in OS number 17060 of 2006, dated 6/7/2026. The petitioner herein is a society has filed a suit to declare that the plaintiff is a lawful owner of the sue scheduled property. In the said suit, two applications were filed. That is I number 12 and I number 13. One is filed. IA is filed under order 14 rule 2, read with section 151 CPC to recall the order dated 3/5/2025. And another IA is to summon the BDO office officials to produce the document and give evidence upon the same that came to be dismissed by order impugned. While dismissing the application, the court has observed that it is an admitted fact that the plaintiffs had filed similar applications earlier also, which came to be rejected. The said order was challenged in the writ petition before the High Court, which was allowed, and a time limit was fixed to dispose of the suit within an outer limit of 6 months. The suit of the plaintiff is for declaration that he is the absolute owner of the suit scheduled property and for permanent injunction restraining the defendants from encroaching the suit scheduled property. The plaintiff has also sought for recovery of vacant portion of the property and for mandatory injunction to remove the unauthorized construction as well as for mean profits. When the similar applications were rejected, the present application are not at all maintainable. And on perusal of the entire order sheet, it reveals that the issues came to be framed in the month of June 2010. And since then the case is being adjourned on one or the other pretext, in order to drag on the proceeding, the present application is filed. Land counsel appearing for the petitioner submits that, in fact, when in the earlier when he has come before the court by filing WP number, where is that? WP number 21958 of 2025. That came to be disposed of on 14th November 2025, wherein the court has allowed the writ petition and consequently an application filed under order 7 rule 14 read with section 151 CPC is allowed, and the document, that is the map.
Yes,
what is that?
That's BDA approved plan.
And the BDA approved plan shall be taken on record. The court has further observed that it is open for the court either to accept the document or reject it if the plaintiff relies upon it in evidence, both on the basis of the legality or admissibility of the document. If the plaintiff is inclined to produce a original approved layout plan sanctioned by BDA as submitted by him during the course of arguments, he is permitted to do so, and the same shall be considered by the trial court in accordance with law. In view of the fact that the original suit is of the year 2006, it is almost 2 decades from the date of filing of the suit. The trial court is directed to dispose of the suit within an outer limit of 6 months. Then counsel for the petitioner submits that immediately thereafter, they have placed by way of a memo, they have placed a certified copy of the layout plan before the court. It is submitted that earlier with respect to this property, BDA has taken certain steps for removal of the encroachment,
Including demolition of the constructed building.
including the demolition of the unauthorized structures.
Yes.
In the backdrop of this, examining the BDO officials is very much warranted, and also to produce the approved layout sanction plan by the BDA is also necessary. In those circumstances, the petitioner has filed this application, and only on the ground that already earlier applications are filed, the court had dismissed the same. It is submitted that unless and until these applications are allowed and the petitioner is permitted to examine the BDA official, and unless they produce this layout plan, that would cause a lot of prejudice to the plaintiff. It is also submitted that they have filed an undertaking affidavit before this court dated 28/7/2026, whereby once this order is passed, once this writ petition is allowed, they will not file any application before the court, before the trial court, and also undertake that they will cooperate for the early disposal of the case within 4 months from the date of the receipt of the copy of this order. In case any application is filed by the petitioner, the court may pass appropriate orders, including dismissal of the original suit number, OS number 17060 of 2006, pending before the court. It is submitted that the writ petition may be, the order, the application number, IA number 12 and 13 may be allowed in the interest of justice. Next para. When counsel appearing for the respondent submits that this is a suit of the year 2006 and they have been dragging on the matter. And though in the earlier writ petition there was an order to dispose of the matter within a period of 6 months, thereafter they have come up with this application, which clearly shows that they have the only intention of the plaintiff is to drag on the matter, and they are not interested for a disposal of the matter. It is submitted that the court has rightly passed an order and there are no grounds to interfere with the order. Next para. Having heard the counsel's on the material on record. As rightly submitted by the learned counsel for the respondent, the suit is of the year 2006 and undoubtedly several applications are filed before the court and the matter is pending for almost 2 decades before the court. But at the same time, the court cannot lose sight of the fact that the entire issue revolves around the approved layout, and already the copy which is there with the petitioner as permitted by the court is placed on record. In those circumstances, and that earlier the BDA has taken action with regard to the unauthorized constructions and demolition. In those circumstances, it is all the more necessary that the applications under Order 12 and 13 needs to be allowed. Probably the court, looking at the manner in which the matter is dragged on, had dismissed, it appears that the application is dismissed in that view of the matter, and also considering the affidavit that is placed before this court and balancing the interests of both the parties, this court is passing the following order. The writ petition, the order impugned dated so-and-so, so-and-so is set aside. Consequently, I number 12 and 13 are allowed. He has given you a copy.
Not yet, madam.
You should give him the copy at least, Mr. Muttan.
No, this copy I have given, my lord. This,
No, undertaking affidavit.
Undertaking affidavit. Yes,
That was
no.
the petition
He's
copy
also,
just given.
he's entitled to look at it.
Just now.
Consequently, I number 12 and 13. No, yes, everything what the court has observed is there.
But it is on by the council unnecessarily.
Huh?
It's the council's affidavit, madam, not for the party.
Why, how can you file, Mr. Vittana? That's
No,
what.
on behalf of the, now, my lord, we have to get those people 230.
That is why
No,
I said so.
That is what, my lord, I have said that I am representing the petitioner. Because this undertaking on behalf of the petitioner, I told them, these are all the undertaking I am giving, then they have agreed. I talked to them and then only I prepared this.
So what is the purpose of me adjourning? I said, you cannot file. I can't take your undertaking on record. It should be filed by the advocate. I mean, by the client. I was under the impression that it is by the,
They are not, they are the
to
far off,
file,
my lord.
never file these kind of affidavits before the court. It's not, it is not good for your, this thing. Anyhow, we'll dispose it to.
Please.
How do you do it? And the consequentially, I number 12 and 13 are allowed. Number 1. Number 2, the petitioner shall cooperate with the proceedings and as undertaken before the court, no further application shall be filed. If any application is filed, that would be the ground for the court to dismiss the suit. Number 3, the court shall ensure that the suit is disposed of within 4 months from the date of receipt of the copy of the order. Yes, accordingly disposed.
Any adjournment is taken, my lord, that is the problem. Exemplary cost, that also you can mention, my lord. Because other side, if they take adjournment, then within 4 months,
Then
it will
I
not be over.
say, no, first of all, for filing this application, again, costs also I was thinking to impose on the petitioner.
No, not this, my lord. This is, it is This is a genuine application, my lord, because even though that's honorable court in the previous writ
No,
petition order.
right, whenever the petitioner takes adjournment, cost shall be imposed. If respondent takes adjournment, no cost. Yes, Mr. Vasudevan accepts, don't write that. Vasudevan accepts notice for suit.
This is not uploaded, my lord, today.
Hmm?
So orders may kindly be uploaded today,
Tomorrow.
tomorrow.
Cell number 72. K.S. Chandrahasa for petitioner. List continuation, list number 1, 72.
Your Honor, serial number 72, I may be permitted to take notice for the first respondent bank. I have received copy of the writ petition yesterday, Your Honor, so I could not get the wakalat in time.
Are you ready?
Yes, Your Honor. Please.
Yes.
The suit is for the recovery of security.
What are these two writ petitions?
One is recall PW1, another one is to recall the order of the court.
To recall PW1 is 22766.
The recall PW1 is IA4, IA5, IA4 is to
I'm
reopen.
referring to the writ petitions, WP 22766.
66 is first one.
For?
To reopen the case.
Other is to recall the order.
Recall where the witness.
Recall the witness. Please come to the order. Where is the order?
The order is at page 38, my lord. Annexure G.
Let's read the reason. Come to the reasoning part.
Reasoning part is, Your Honor, my lord, it is at para
Page 42, para 6.
Yes, para 6 and 7, my lord. Plaintiff bank has instituted a present suit for recovery of the money of on 2/5/2025 upon entering appearance. Defendant number 2 filed a written statement and issues were framed, and the chief examination of PW1 was completed on 1/12/2025. On that date, request of the defendant number 2, the matter was adjourned to 17/12/2025 for cross-examination. On 17/12/2000, PW1 was not present, and cross-examination was deferred. Thereafter, PW1 tendered himself for cross-examination of 2/2/26, and defendant 2 sought time submitting that she was willing to settle the matter. It is not willing to settle, but she said she will try to convince that party if possible, because 15 loans were given to him, my lord. Accordingly, the cross-examination was deferred.
Yes, I have seen.
On 17/2/2026 and 17.
Counsel, I've seen. Will ask him. Yes. Yes, counsel for the respondent.
Yes, Your Honor, may kindly peruse para 7 and 8. It's a
I've seen
detailed and reasoned order, which my humble submission is it does not call for interference, Your Honor. The learned court below has noted that PW1 has remained present before the court and tendered himself for cross-examination as many as 5 occasions.
No, we'll fix a date. We'll ask them to complete it on that day. No further adjournments.
Yes, fine.
Your Honor, there is a practical difficulty. PW1, whose evidence was taken on record, has been transferred. So we have to file application for discarding his evidence and start afresh.
He is here only in Bangalore, only, RT Nagar branch.
Why he can't depose?
Your Honor, now that he is transferred out of the branch, it will cause practical difficulties.
No, only one day. One date it can be done.
Very well, Your Honor. I'll instruct them accordingly.
Yes. Please come. 2 writ petitions, WP 22766 of 2026 and 22647 of 2026. Agreed or filed. The present writ petitions are filed agreed with the order passed on I number 4 and 5 in commercial OS number 668 of 2025. Dated 13 July 2026 by the CCH-19 Bangalore. The petitioner herein is a defendant number 2. The IN number 4 and 5 have been filed. praying to reopen the case and recall PW1 for further cross-examination. It is the case of the defendant that when the matter was set down for defendant evidence, further evidence of the plaintiff, for further cross-examination of the plaintiff, he was present before the court. What is your case? That you are present and you came to High Court?
Yes, I said that I am ready. I went 5 minutes late, my love.
In the morning session, by the time he went to the court, the matter is passed over. And in the afternoon, from the High Court, by the time he reached the court, as
Forenoon only I appeared.
Hmm?
Forenoon only I appeared once again.
In the
And by that time it was,
and he appeared, but the court has taken the cross-examination, has posed the further cross-examination of PW1. It is submitted that when the application, it is submitted that when an application is filed to recall the, to recall PW1 for further cross-examination and to reopen the court without considering the case of the petitioner and also the difficulties that are expressed, has dismissed the application. It is submitted that if one opportunity is given to the petitioner, on one day he'll complete the cross-examination of PW1. Next parallel, and counsel for the respondent submits that so-and-so, so Mr. So-and-so submits that he has instructions to file wakalat on behalf of the bank. First respondent here. It is submitted that the court has given enough opportunities to the petitioner, and as he failed to avail the same, the court has rightly passed an order closing the cross-examination of the plaintiff and posting the matter for the defendant's evidence. It is submitted that now the concern is transferred and it is difficult for the bank, for the said person, and the court has rightly considered and dismissed the applications, and there are no grounds to interfere. Next para, having other counsels on either side, peruse the material non-record. A perusal of the order shows that there are lapses on the part of the petitioner, but at the same time, the court, while the courts have to look at the substantial interest of the parties. In these circumstances, this court is of the view that if one opportunity is given to the petitioner to cross-examine PW1, it will serve the ends of justice, and no prejudice will be caused to the defendant plaintiff. In that view of the matter, this court is passing the following order. The order impugnated so-and-so is set aside, and consequently, I number 4 and 5 are allowed. Number 2, the petitioner. What is the date?
13/8, it is posted now.
On that day?
Yes.
Yes,
I'll
yes,
say
please.
on 13, on 8, 2026, the PW1 shall be present for the cross-examination. On the very same day, the defendant shall conclude the cross-examination and no further opportunity will be given.
I know.
Accordingly, if petitions are allowed,
Then there must be 73.
upload this order also urgent, right? Day after tomorrow. Yes.
For the
73, yes,
petitioner,
Ketan
Lord.
Babu, 46.
Lord's petitioner. Lord's,
Come.
Lord's petitioner is tenant under respond number 4, running clinic and
Take
laboratory.
notice on Mr. Devraj.
Lords, I have submitted copy, tried to submit serve copy. He said to serve copy in the office. I have served a copy in the office 3 days back.
Why the court asked you to serve on him?
Lords, before filing, I made my
No,
efforts.
the court is ordering the petitioner to serve the copy of the writ petition on the counsel appearing for the respondent, Mr. Devraju.
That's tomorrow.
Registry is 1 minute. Registry is directed to print his name. List this matter tomorrow in first list. Preliminary hearing. Yes.
Then number 74.
And you shall get instructions by that time. The 74. Inform him.
Now,
Yes.
defendant's petition.
Mm.
More than 400 days since the plaintiff obtained the ex parte order ad interim, the trial court has not taken up my application for vacating ex parte ad interim.
When was the interim order?
Not on 20, not the ad interim has been obtained 21/6/2025. Not, we have all pleadings are complete. Objections to the ad
When did you
interim.
file your objections?
21/6, not when did we file our objections? Objections were filed in January of 26.
No, you say when was the injunction granted?
Not injunction ad interim was granted on 21/6, 21 June 2025.
2025.
2025.
So from January, the matter is not taken up.
No, not merely because they say the trial court, every time the matter comes up, defendant number 1 to 36 is the partition suit. I am defendant number 36. I claim from defendant number 1 to 35 because D1 to D35 are not served. Not the trial court does not take up the application at all. For 1 year, not a rank stranger files a suit.
What is the injunction that's granted?
Freeze on title. Complete freeze on title, no ex parte ad interim.
Not to alienate.
Not to alienate, not this. Not it's a rank stranger. I will persuade the court.
Come to the cost title.
Yes, ma'am.
Cost title of where is the plaint?
Not your lordship will find the plaint. Copy of the plaint is at page 26 to 39.
26.
Not if your lordship may just see my prayer once, ma'am.
Who are you? Which defendant are you?
Defendant 36, ma'am.
In the plaint, what did they say about this defendant number 36? That you are a subsequent purchaser?
No, your lordship will just see their plaint prayer, ma'am. Plaint prayer is at page 32.
G Corp Space Private Limited.
Yes.
A company.
Yes, ma'am. Page 32, your lordship will see the prayer.
Yes.
Partition by meets and bounds. Declare the sale deed. They admit that D1 to D35 executed a sale deed in 2018. The suit is filed in 25. Now please see, my lord, at 32, prayer B. Lordships are there, my lord.
32, prayer B.
Prayer B, my lord. There's the stamp.
32 is running into paragraphs. Prayer is at
34.
34.
Lord, I'm sorry,
Yes.
34, my lord, I'm sorry. 34. Prayer B, your lordships have it not. Declare the sale deed dated 26/9/18 in book so and so got executed in favor of G Corp, a private limited, and having its so and so in that is defendant number 36 registered in the office of senior sub registrar. Respect to the suit.
Come to the order of injunction.
Yes, my lord. Your lordship will find that at page 17. No reasons as such, just a one-line order, my lord. Plaintiff has filed.
Page number 17.
17. On the same day the suit is filed, the application under 39(1) and 2 is taken up for hearing. Plaintiff has filed so and so on perusal of document, notice of very object of suit. Lordships have it not?
Issued an order of parent against the defendant from alienating the suit schedule. Now virtually this order is against you.
Yeah, that's what I'm saying. I'm only saying, Lord, let the application be heard finally. My objections have been there on record. I filed a vacating. Lord, your lordship will only see my prayer, Lord. Just please see prayer.
Prayer where?
Prayer is at page 11, Lord, of my petition prayer.
Yes.
Your lordships have 11, Lord. Prayer A is for setting aside that 21/6. I'll not press on that note because notice will have to go. I'll go there and argue. Just please see prayer D, Lord. In the alternative to A to C, direct the so and so court to finally hear and dispose of IA 1 and 2 within a time frame to be fixed, notwithstanding that 1 to 35 is served. Your lordship may accordingly in terms.
Please come.
Not because in terms of rule 3A, 30 days is the time limit within which it has to happen. Therefore, your lordship may.
The petitioner is
36th defendant.
the prayer in the petition has come before this court. Sing the following prayers, extract all the prayer. Then counsel for the petitioner submits that the suit is filed for partition and also sought a relief that the sale deed that is executed, declared the sale deed dated 26/9/2018, executed in favor of the petitioner herein, who is a defendant number 36 in the suit, is invalid, not binding on the plaintiff, and null and void, and also sought for partition. The trial court, by order dated
21/6/2020.
the order dated 21/6/2025 has granted an ad interim injunction, temporary injunction, ex parte temporary injunction, restraining the defendants from alienating the suit scheduled property till the next date of hearing. Land council appearing for the petitioner submits that they have filed their objections on, when did you file?
Lord, objections are filed. Both objections were filed, Lord, on 21/26, 20th January 2026.
2026. It is submitted that the matter is pending, the court, only on the ground that all the defendants are not served, is not taking up the matter. It is submitted that in sum and substance, the order is in fact operating against the petitioner as he is the one who has purchased the property. It is also submitted that the order that's passed on I number 1 dated 21/6/2025 is not a reasoned order. By way of a one-line order, the court has granted temporary injunction without even being satisfied about the prima facie case balance of convenience and irreparable loss. It is submitted that Order 39 Rule 3A contemplates that the court has to, once the objections are filed, the court has to consider the same and pass orders within 30 days. It is submitted that the court has failed to follow the provision, failed to follow the procedure as contemplated under Order 39 Rule 3A. It is submitted that in these circumstances, this order is, as it's causing a lot of hardship to the petitioner plaintiff, he has come before the court seeking the above prayers. Next para. Having heard the land counsel for the petitioner, peruse the material on record. As submitted with the land counsel for the petitioner and as seen from the record on 21/6/2025, an order is granted and on the face of it, of the order, it is a cryptic order and no reasons are stated, be that as it may. This court is not going into the legality or otherwise of the said order. When objections are filed, it's a duty of the court to consider the same, particularly in the facts and circumstances of the case, where this order, where the further stay of alienation is granted, particularly in respect of the property which the petitioner has purchased. And as he is affected by the same, the court ought to have heard the application. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the court to consider IA number
1 and 2.
IA number 1, 2 is for what?
For Order 39 Rule 4 for modifying the
Order shall consider IA number 1 and 2 in accordance with law within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the suit summons are not served on the other defendants.
Deeply obliged.
So number 75, Shruti C, for petitioner.
Yes. No representation list in the month of September. Yes, 76.
Number 76, Subba Reddy KN for petitioner.
76, court has issued, and this is Lord, page 23, court has issued notice, Lord, my IAs are not considered. Next date, they filed objections.
Why he is getting a senior counsel for this?
Your lordships would pass.
No,
yes.
even if he comes also, I'll pass the same order.
7 days.
20?
23. 4/8/26. Lord, on that day.
20?
Still number 23. Lord.
Hmm.
23. They filed the written statement, but court grants further time to 4/8/26.
Oh, it's coming up 4/8/2026.
They filed the, no, next Tuesday, 4th will be next Tuesday, Lord. At least from that day, let the court decide the IAs, Lord. Because they've encroached on the property and they're trying to change the nature. We have filed a suit for possession.
No, he filed common objection. This IA number 2 and 3 is not considered.
Not considered.
Please come. The petition is before this court. Agreed with the order dated 4/8/2026, whereby the court has failed to consider IA number 2 and 3 filed by the petitioner and issued the suit summons to the defendants. And as the suit summons are not served on the defendants, the court is adjourning the matters. Then senior counsel appearing for the petition submits it and an application is filed seeking ad interim injunction. The court has to consider the same in accordance with law. But and has to pass orders on the merits of it. and the court keep on adjourning the matter, that would cause a lot of hardship to the plaintiff if any, in the during the pendency of the suit. If any, IA is for what?
Restraining alienation and not to change the nature.
If any property, if the property is alienated and any constructions are made, it would cause a lot of hardship to the plaintiff. And there may be a direction to the court to dispose of the matter. Considering he has also relied on the judgment of the coordinate bench of this court in so and so. Considering the submission of the Lancina Council and the fact that the IA number 1 and 2, which is filed long black, was not considered by the court, this court is passing the following order.
Please.
Disposed of.
Obliged.
77, R.B. Sadashivappa.
Yes.
My Lord, writ petition by the plaintiff in the trial court. Suit is one for declaration and for possession.
Suit for?
Declaration of title and for possession. The subject matter is 1 acre 20 guntas. In survey number, my Lord, 2 survey numbers, 28/2 and 28/3. Totally measuring 1 acre 20 guntas. The defendant claims that he got it under agreement to sell. Till today, no suit is filed for specific performance and the like, and he is not in possession. However, he has occupied illegally. Therefore, we have filed a suit for possession also. Now we filed an application for appointment of the surveyor or commissioner of the court commissioner to find out the length and the breadth and how much is the encroachment.
What is the present stage of the suit?
It is for argument, my Lord.
It's coming up for argument.
Argument. So at this stage, we filed the application for appointment of the commissioner that is rejected by the trial court, against which, my Lord, the present writ petition is filed.
Let's see the order.
Yes, my Lord. I may straight away take my Lord's attention to paragraph 9, last portion. The purpose of appointing commissioner for local investigation of the spot is not to help the party to establish the case. I may say with respect, it may not be correct proposition. After all, it is to help the parties appointment to find out exactly what is the dispute between the parties. Then I take my Lord's attention to last paragraph, that is 12 on page 17. In view of the above, I am of the considered opinion that there is no necessity to appoint a court commissioner, and the plaintiffs must independently prove their case with the assistance of relevant documentary evidence in a suit of this nature.
When counsel for the petitioner submits that, when an application is filed, when order 629 seeking appointment of the commissioner in a suit for declaration and recovery of possession, and when the matter is posted for arguments, the court has dismissed the application on the ground that the appointment of the commissioner for local investigation of the spot is not to help the party to establish a case. It is submitted that court has to fail to consider why the application is filed and the relevancy of the same, and without considering the same, it has dismissed the application. Considering the same, it shall be stay of all further proceedings. You want stay of all further proceedings or
Further proceedings.
Further proceedings.
Further proceedings. Notice to the respondents. Permitted take out hand summons and shall file a memo to that effect by 6th of August, or else a stay granted by this court's transfer case. Next.
Great.
Number 78, Raghavendra K. for petitioner.
For the petitioner in this case, suit for specific performance came to be decreed in favor of the respondent, my lords. My lords, against that order, my lords, the petitioner herein within time, my lords, he has prepared a regular appeal before the first appellate court, my lords. Along with that appeal, my lords, the petitioner has filed application and under order 41 rule 5 for stay the operation of the judgment, my lords. My lords, the first appellate, my lords, your lordship may kindly come to annexure F, page number 60, my lords. Without hearing the application, my lords, was proceed to pass to issue notice, emergent notice to the respondents, my lords.
What is the suit for?
Suit for specific performance, my lords.
What will happen now?
My lords, for that I will come, my lords. After this, my lords, taking advantage of that issue of emergent notice, the respondent herein has filed an execution petition, my lords. Execution petition came to be filed against the judgment, my lords. Now, the trial court, even in the execution petition, my lords, I have filed a wakalat. On the same day, your lordship may kindly come to.
What was the judgment and decree?
My lords, judgment and decree on 17/11/2025, my lords.
When did you file the appeal?
My lords, 18/12/2025, my lords. Within 1 month, I have filed.
What's the EP file?
EP filed, my lords, after in the January 2026, my lords.
Please come.
31/1/2026, my
The
lords.
petition submits that.
And one more.
Specific performance.
One more submission, my lords. In the execution petition, my lords, I have filed wakalat in the last occasion, my lords. On the same day, my lords, without considering the pendency of the appeal, my lords, the executing court has proceeded to pass the order to appoint the commissioner to execute the sale deed, my lords, without afford an opportunity.
After the suits for specific performance is declared, immediately an appeal is filed. And in the appeal, petitioner sought for stay of the execution proceedings. The court has issued the suit summons, and now the execution petition is filed. And in fact, the court has issued the warrant. Considering the submission, there shall be stay of all further proceedings pursuant to the judgment and decree in so and so.
Much obliged.
Notice to the respondents, hand summons, memo by 5th, oral stay granted by this court stands vacated. Yes, next.
79.
Much obliged.
Superior Atreya.
My lords, I filed the suit for partition. Trial court has rejected my 39(1) application mechanically for restraining the defendants from alienating the suit schedule properties. So regarding ad interim injunction, the present petition, I just take your lordships. Kindly come to page number 5 of the petition, my lords.
Where is the order?
Order is at page number 58, my lords. Impugned order is at page number 58. Heard advocate for plaintiff on IA number 1.
Come. The petition is agreed with the order dated 17/7/2026 by so and so. Whereby the court, without hearing an application under order 39 rule 1 and 2, that is IA number 1, has issued the suit summons. See, it is submitted that if the petitioner is not able to make out a prima facie case and there is no balance of convenience in favor of the petitioner, there is no irreparable loss, court ought to have passed orders on the merits of the matter. But just observing that there is no prima facie case, the court has granted suit summons and no orders are passed on I number 1. Next, the land council has relied on so and so disposed of, notwithstanding the fact that the suit summons are served. Yes, within 1 week. Next.
Cell number 80.
Much obliged.
Cell number 80. PM Sidmalappa.
This case, paper.
Today morning, my lord, I entered appearance for respond number 2 and 3. I filed wakalat before the registry by today. Because last occasion, when the case is posted for cross-examination, it's taken as nil and is posted for their evidence.
My humble submission in this case, please, Lordship.
Where is the impugned order?
Impugned order, please, Lordship, in page number 164, with respect to preliminary issue number 4 is concerned. In this case, please, Lordship, the plaintiff filed this
So
suit.
questioning this order.
Please, Lordship.
Where the preliminary issue is dismissed.
It's given a finding as negative.
Hmm.
On the basis of that, I have before this honorable court, please, Lordship. In this case, please, Lordship, the plaintiff filed the suit for declaration and permit.
There is no urgency for this.
What will happen, Lordship, once the plaint was rejected, there is a arbitration clause. The plaint was rejected, first instance. He has filed the RFA.
No, anyway is here. I'll hear both of you, serve him the papers. Notice to the respondent so and so submits that.
And we make one submission, Lord, insofar as R5 is concerned, Lord, he is none other than the father. He is no more.
No more.
To appear for whom?
Lord, I'm respond 2 and 3, Lord. 2 and 3.
2 and 3. So
And also, my lord, because one is the firm. Maybe name may be shown, my lord, for respond number 1 to 3.
Respondents 1 to 3.
1 to 3, please.
1 to 3 as instructions.
And
to
I
file
may be
wakalat.
permitted to dispense the other.
4 and 5. Memo is filed seeking dispensation of notice to 4 and 5.
No, 5 is concerned, Lord, he is no more. He is dead, my lord. His own is father. He died,
He
my
will
lord.
say that he will say in
Yes,
that
sir.
the
I
dispensation notice.
will file a memo with that.
Give that.
So
The list is matter on.
Copy may be, sir.
on 5th of August.
I'm requested, the matter was posted on 5th itself, the leading evidence of the defendant.
When is that?
4th.
4th,
List this matter on 3rd of August.
Minimal copy may be served.
I will serve, please.
The copy of the
Please.
petition on the council. Yes, next.
Cell number 81, Chandrasekhar K.
Respond number 1, plaintiff has filed a suit before the trial court, suit for partition and separate position. She is a stranger to that, she is not, she is no way concerned to the family of the,
Present आइए.
my lord.
What is the
This
present?
plaintiff, this petitioner has filed application before the trial court for summoning the document from the society, my lord. The plaintiff obtained a copy, certificate copy and NOC from the society. Actual properties that belong to Ramamani, mother of the plaintiff.
Come to the imprint order.
My lord,
Look
in
at-
page number 13, my lord. May I read?
Yes, para 5.
Para?
5.
Please, ma'am. It is to be noted that the present suit is filed by the plaintiff for partition claiming one third share in the suit property. It is the case of the plaintiff that the plaintiff and defendants are children of Ramamani and CLV Iyer. It is further the case of the plaintiff that the mother of the plaintiff and the defendant was a government teacher. During her lifetime, she purchased the suit properties. As such, the suit properties were her self-acquired property. After the demise of mother of the plaintiff and defendant, they succeeded to the suit property. However, despite demand, the defendant did not allot the share to the plaintiff. Hence, the
Hear the other side and pass orders. Notice.
my lord, in this case, my lord, may I make one submission? I filed application. She is a stranger to the, I made a contention in the written statement. Kindly take page number.
I've seen that. I've seen the order also. I'll hear you once the respondent comes.
My lord, kindly take, my lord, the reason trial is fixed on 2/8, my lord.
Why
Kindly
should we
take
stop
page
the
number
trial?
in 16, my lord.
His purpose, why should we stop the trial?
My lord, for the purpose of cross-examination, my lord, there is no, these documents in the custody of the society, these documents are relevant to confront the witness. My
Of which year?
lord, 22, my lord.
Notice to the respondents, petition shall, same hand summons, shall file a memo to that effect by 10th of August. If the memo is filed, list it on 11th August.
My lord, kindly dispense the notice to respond number 2, my lord. She is no.
Memo is filed second dispensation to R2.
My lord,
Dispense
interim.
I would have given, no, I'm not convinced. Please leave it there.
Please, my lord.
Respondent number, notice to? Only one.
Dispense 2, my lord. Only one, my lord. Respond
Notice
number
to
1.
R1. Yes.
Cell number 82, yes, Ramakrishna.
Lord, in the suit for partition, the respondents not included these petitioners and compromise was recorded. The same compromise was, decree was challenged before the appellate district judge, my lord. District judge dismissed the RA, directing these petitioners to file writ petition.
You're a party to the
No,
compromise.
I am not a party.
The compromise is recorded by the civil court or the legal
Civil court. Civil court recorded the compromise, my lord. It was challenged by these petitioners before the district judge in RA. RA was dismissed, directing these petitioners to file writ petition. Strictly speaking, this writ is not maintainable, but since the district judge observed and directed the petitioner specifically to file writ petition.
So you have filed.
Please.
No, I'll say.
Otherwise,
it is
civil judge may not entertain the
not- I'll say that
application.
this
necessary
petition is not maintainable.
Same court they have to approach to file necessary application, giving liberty to the petitioner to file
The
necessary
petition is
application.
filed. Questioning an order dated.
The judgment of the
2026 and RA
district
number
court is
501
annexed C.
of 2024 by the third additional district and session judge Manya. It is submitted that when he has questioned the compromise decree that was dismissed, the court
Recorded.
has dismissed as not maintainable. they're entitled to challenge the compromise decree in an appropriated petition. And hence the petition is before this court. The petitioner is not a party to the proceedings.
Yes.
And the compromise is recorded by a competent civil court. In those circumstances, the petition before this court is not maintainable. Accordingly, the order, according to the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy for the appropriate court.
Humble submission, Lord. Till then, the stay may be granted.
Till then?
Staying the compromise. In the appellate court, I have.
Sorry. Yes, next.
Much.
Cell number 83.
For petitioner members,
Suman Tel
was seeking a direction to the lower court not to draw final decree only with respect to item number A and B properties. This writ petition has been filed, my lords. My lords, the item number A and B properties already included in the earlier suit which filed by me seeking declaration on the basis of will. The suit is of the year 2019, my lords. In the year 2021, my lords, the contesting respondents 1, 2, 3 initiated FDB proceedings and included item number.
Can you file a petition of this nature?
But the two prayers are there, my lords.
No. What happened to the appeal? The judgment and decree has attained finality.
Yes, my lords.
And then in that case, why should there be a direction to the court?
No, my lords. The suit filed by the respondent number 1, 2, 3 came to be decreed. I filed an appeal, my lords. In appeal, my lords, the lower appellate court held that item number 5 and A B properties are self-occurred properties of my mother. It's not available for the partition. They challenged it before this honorable court, my lords. This honorable upheld the findings of the lower appellate court, holding that my mother is the absolute owner of the 5 and A properties. But what happens, my lords, during the pendency appeal, my mother dies. So this honorable court further held that in view of subsequent events, even these the plaintiff also entitled to the properties that are held by the mother. Yes. Later, my lords, these findings are already been attained finality. But later, my lords, we found a registered will that executed by mother in favor of me. I filed a suit seeking declaration on the basis of will, my lords, in the year 2019. The contesting respondents entered appearance. Now that suit is for further cross-examination PW1, my lords. Such being the case, my lords, in the year 2021, they initiated FDB proceedings. In that, my lords, they also sought the scheduled properties that covered under suit, my lords. If parallelly, my lords, even FDP is also final decree passed with respect to item to A5 and A, my lords, my suit will render infructuous, which was filed much earlier than the FDP proceedings, my lords.
Yes.
My lords, that apart, my lords, they have also filed an IA number 8, seeking court commissioner
as
to.
As far as B is concerned, you can argue. This I'm not inclined to
Please,
pass
my lords.
any orders.
Item.
Come to the impugned order. Where is that?
My lords, that is at Annexure P, page 274, my lords. The reason for allowing that application is, my lords, that I have not produced the plaint of my suit and I have not informed the pendency of the suit and will at the earlier point of
The
time.
common order on IA number 8 and 9.
Yes,
What is IA number 8?
8 is their application seeking court commissioner for demarketing the item number 5 and AB properties.
IA number 9 is?
IA number 8, rest of the properties I have no objections.
Oh, when there is no, on what basis we should stop this?
Because for item 5 and AB properties, my suit is already pending in the year 2019. They have actively participated in the suit. Now it is for further cross-examination of PWM from their side. My grievance is only with respect to item number 5 and A and B and properties. Rest of the properties, I have no objections. They are entitled. That's the finding that I finally.
And also the executing court cannot consider.
Millers?
Objection, the executing court cannot consider.
No, not like that, Millers.
When the judgment and decree has become.
No, not like that, Millers. Because only with respect to these two properties, suit is pending, Millers. Rest we have not challenged it, Millers. Millers, when suit is pending, Millers, my registered will is there. If pending the pendency of suit, Millers, the FDP is done, even with respect to these properties, Millers, my suit and will both get subjudized, Millers. My interest.
High Court passed the order. You were not aware of the registered
No,
will?
Millers. My mother was executed it, registered will. That's why we filed a suit subsequently, Millers.
We'll hear the other side. Notice to the respondents and someone's memo shall be filed. If memo is filed on 12th, list on 13th of August.
Cell number
Yes.
84. Shashidhara K. Shashank K.
Yes.
My lords, on the earlier occasion, my lords, after hearing the matter, my lords, court find that there is a caveator is not present for the court.
Though the caveat is filed on behalf of the respondent, no representation on the data. Papers were served. List this matter on 22/7. Yes.
Malars.
Yes. Arpita.
Yes. The writ petition filed by the defendant, Malars. The plaintiff, the respondent has filed a suit before the court, Malars, saying that the defendants are interfering in the suit schedule property. Malars, after hearing the application, trial court, Malars, they dismissed the application because both the parties are different. Afterwards, Malars, the plaintiff, means the respondent, filed a MA before the first appellate court, Malars. MA, Malars, allowed and held that, Malars, they permit the order passed by the trial court, Malars, are dismissed.
So come to the order in MA.
Malars. MA, page number, Malars. Malars, 9. Sorry, 16, Malars. The reasons, Malars.
Come to para 15.
It is relevant to note that the trial court, while passing an order, stated that the property claimed by the plaintiff and the defendants are different. But both the claimants are their possession of their property, and hence there is a clear dispute with regard to the identity of the property. The trial court lost its sight with respect to, with regard to the Hakkupatra produced by both the parties. Though the Hakkupatra have been issued in the same year, the month, but the vendor of the plaintiff obtained on 21/10/1992. The said Manjula, a wife of Dasegoda, obtained on 23/10/1992. Moreover, the claim of the property, the defendant have not produced any document to show that the plaintiff schedule property and the property.
If it is filed, only one respondent.
Yes, ma'am.
Yes.
Noted in the sale deed are one and the same. When the Hakkupatra issued to the original allotted to the defendant's property does not contain the survey number or site number, on the basis of the on what basis the defendant claiming his possession over the associated property has not been explained. Even the gift deed produced by the defendant has
no, I remember this
no
case.
mention about the yes, ma'am. The last date of hearing.
Yes, you have argued.
Yes, ma'am. The issue with respect to Malars, the Hakkupatra, what they issued by the authority Malars, it is not bearing the site. I have I requested my client to send.
So in your Hakkupatra, there
yes,
is no mention about the property, which
yes,
is the plot number.
Malars, no Hakkupatra is mentioned the site numbers, Malars, except the plaintiff or the claiming, Malars. I have requested my client to get another any other property belongs to adjacent site owners, Malars. I have, but he has sent only the pages, Malars.
No, we
Here
will
also
not be appreciating all that evidence now.
Yes,
We'll go by what are the findings of the
yes,
both the courts. The court said in your Hakkupatra, there is no mention about the property. Whereas in there, and you have not even shown that both properties are one and the same. When the plaintiff, by placing the documents, prima facie established, is entitled for
we are
injunction.
disputing that there were no existence of plaintiff property, Malars, because they are mentioned the site number.
Problem is, where is your property? Where is the site number?
Malars, in that area, Malars, the site number has not been provided. Only the assessment number has been given, Malars. I have obtained the one document.
But in plaintiff's case, it is there. Plaintiff's Hakkupatra number is there.
Malars,
the court records it. Come to the order. The Hakkupatra produced by the plaintiff clearly shows that towards eastern side of her, there exists site number 271, western side 273, and her site property is site number 272.
Even Malars, the plaintiff has not produced any document to show that there was a formation of layout or whatever. Malars, at the moment there were no layout have been formed.
That will be eventually decided during the course of the trial.
Malars, that is why Malars, because he's trying to put up the construct. That is why Malars, only that limited interest can be for the honorable court, Malars. Till disposal of application, at least plaintiff may be restrained for the construction. That is why, Malars.
On the ground of identification dispute,
yes.
With regard to the property of defendant, the plaintiff should not suffer. Prima facie document clearly shows the position of the plaintiff and a vendor also. She has purchased the property with clear identification, and hence balance of convenience also lies in her favor. The trial court come to the conclusion that the plaintiff is having prima facie case, but added in holding that the principle of balance of convenience and irreparable loss lies in favor of the defendant.
Malars,
Come to the trial court's order.
page number, the reasons, page number 42 minutes. Before that, minutes, the points whether the plaintiff has made out the prima facie case against the defendant, whether the plaintiff further no. There are reasons. There are 3 points interlinked with each other. Hence, the above points are taken together common consideration. This is the suit filed by the plaintiff seeking relief permanent injunction against the defendant for restraining them to interfere in peaceful position over the suit schedule property. The case of the plaintiff is that she is the absolute owner and the possession over the suit schedule property. She has purchased the suit schedule property from her previous vendor named Jayamma, the son of the Ramanna alias Naganna, by way of a registered sale deed dated 8/4/24, which is registered in the office of Sub-Registrar Shivamogga. The original owner of the Jayamma acquired the suit schedule property by way of Hakkupatra issued in the year 1991 by the competent authority. The site formed giving a serial number 272, measuring east to west 30, north to south 50. The Kata of the suit schedule property still running in the name of vendor of the plaintiff, that is Srimati Jayamma. Now the plaintiff applied the transfer of Kata before the competent authority. The defendant, without having any right, title, interest over the suit property, has been trying to interfere with the suit schedule property. When the plaintiff, in order to construct a house, when she took up the cleaning the schedule property on 11/4/2024, the defendant, along with Gunda elements, come to the suit schedule property and try to dispose of the plaintiff by claiming that he is the owner of the suit schedule property and threaten her, he will dispose of from the suit schedule property. Whenever
the petitioner is before this court, agreed with the orders passed in MA number 34 of 2024, dated 10th of September 2025, with the second edition senior civil judge and JMSC at Shivamogga, whereby the court had set aside the order of the trial court and granted an order of injunction restraining the defendant from interfering the plaintiff's peaceful position and enjoyment of the suit schedule property. The respondent herein, who is the plaintiff in the suit, has filed a suit for bare injunction. In that I number 1, I is filed seeking ad interim injunction. The trial court had granted an order of, has passed an order directing both the plaintiff and the defendants not to put up any construction in the suit schedule and written statement disputed property till the disposal of the suit. The court, while passing such an order, has observed that on perusal of the sale deed of defendant, the measurements shown in 13 to 40 feet, bound by east by vacant site of Jayamma, west by house of Srimati Kamalamma, north by vacant site of Elivanjanna, and south by road. The boundary shown by the plaintiff for his property and the boundary shown in the defendant property in their respective sale deeds are different, but both are claiming physically the same property as their own property. Therefore, there is clear dispute with regard to identification of the property. The court observed that the plaintiff established the prima facie case by furnishing title and revenue documents of the suit schedule property, but the defendants also claimed the written statement property as per the sale deed. Therefore, both plaintiff and defendants claim title and possession of the same property by stating that different property numbers and boundaries. In those circumstances, the court felt that unless the trial is commenced and the evidence is identified by the parties, it would not be possible for the court to come to any conclusion, and balancing interests of the parties, the court has passed an order directing the defendant not to put up any construction, or both the parties not to put up any construction till the disposal of the suit. Plaintiff has carried the same in appeal, and the appellate court had allowed the appeal and granted injunction. While allowing the appeal, the court had considered that both are relying on the Hakkupatra, which were issued on 21/10/1992 and 23/10/1992. The court came to the conclusion that the Hakkupatra produced by the plaintiff clearly shows the plot number and also the boundaries. Whereas the defendant's Hakkupatra does not disclose the correct boundaries. In that view of the same, the trial court went wrong in not granting injunction and allowed the application. And the court felt that there is a prima facie case balance of convenience and irreparable loss in favor of the plaintiff. When counsel appearing for the petitioner submits that the trial court has rightly balanced the interests of the parties when the identity of the property is in dispute. If the plaintiff proceeds with the construction, it would cause a lot of hardship. And in fact, the trial court had passed a recent order where both the plaintiff and defendant are restrained from making any construction. It is submitted that the appellate court has failed to consider any of these aspects and granted injunction. Having heard the counsels on either side, there is a material on record. Both the parties, both the plaintiff and the defendants, before that, caveat is filed on behalf of the respondent plaintiff. On the last occasion, this court has observed that though papers are served, there is no representation on behalf of the caveat, and the matter is listed today. Today also, there is no representation on behalf of the caveator. Next part. The properties, both of them are claiming ownership basing on an Hakkupatra. And according to the appellate court, as the boundaries are not mentioned in the Hakkupatra of the defendant and the same are mentioned in the document of the plaintiff, hence the court has granted injunction. This court has perused both the orders. The trial court has also considered about the revenue extracts in favor of the defendant. When it comes to the appellate court's order, that is silent. In the light of the contentions of both the parties and also the pleadings of both the parties, one aspect is clear that both of them are claiming the same property. In those circumstances, the trial court has rightly balanced the interest of both the parties, and appellate court, only basing on the fact that the measurements are clear, has passed an order of injunction. In that view of the matter, this court is of the view that the appellate court has failed to consider, has passed an order without any basis, accordingly. The order impugnated, so and so, passed in MA number so and so, is set aside, and the order of the trial court is affirmed.
So number 85, Ravi Shankar CS, petitioner.
Yes.
The respondent has filed a original suit before the trial court for relief of declaration and permanent injunction. Meanwhile, he has made an application for appointment of commissioner for local investigation, the surveyor for identification of the properties. Subsequently, that application has been allowed.
What is the other writ petition?
Connected matter. All are connected matter, different parties, but same order.
Advocate commissioner. Appointment
Advocate
of
was
advocate.
same, the copy is served on the advocate by hand and parties by post.
Yes.
So then what happened, my lord? He files, the commissioner submits the report, and again is that the
No, but
respondent.
the petitioner is one and the same in all the writ petitions.
Yes, ma'am.
Suits are different.
No, suits are same, different parties.
Different?
Parties are different, plaintiffs are different, defendants are same. And the common, the different order is passed, but a similar order in all the 4 cases.
Yes. Please come to the order.
Yes, ma'am. Then subsequently, my lord, there's an order has been passed rejecting the objections to the commission report by the trial court by dated 6th January 2026. Wherein the honorable trial court has observed that the commissioner report is only, it is not a conclusive proof, and hence the application is dismissed, hereby dismissed. The objection filed by the
Court
first
commissioner's report is discarded.
No, subsequently, what happened, my lord, he submitted for the cross-examination. The respondent number 1 has went through the detailed cross-examination of the commission. Subsequently, he files an application under section 151 for his prayer, my lord, kindly the application in page number, my lord. He has
So the
not even
order
a
is
short-
at page 36, operative portion of the order.
Yes, my lord. The application, my lord, you run, get it, my lord, you get it on 84, annexure J. The plaintiff files an application that for the reasons stated in the accompanying memorandum of facts, this honorable could be pleased to recall the order, posting the matter for final arguments in the interest of justice and equity. He is not sought for discard or anything. The affidavit is sworn by the advocate himself. And nowhere it has stated that the commission report is discarded. On the basis on that application, my lord, I filed an objection and the impugned order came to be passed and discarding the commission report.
Yes.
So this is very contrary to the earlier order passed by the same, the trial court, the rejecting his objections to the commissioner report. Ultimately, commission report, my lord, it is not a conclusive proof of evidence. It is only an administrative evidence is assisting to the court. That has been observed by the same trial court, while its order, earlier order, passed by the trial court against the objection by the respondent number 1. Subsequently, on the application filed at the time of argument, and even though he has not sought for any discarding of the commissioner report, the trial court assumes itself and discard the commissioner report. And if the both orders are contrary to each other.
In all the cases, same order is passed.
Yes, my lord.
Please come. When counsel's petitioner submits that an application is filed under 151 CPC, praying to recall the order, posting the matter for final arguments, and the court by order impugned as allows the application, and also the court commissioner report submitted on 28/7/2023 is discarded. It is submitted that it is nobody's case and nobody has asked for such a relief, and the court has passed the order by order impugned. In all the matters, same order upload. Considering the same, there shall be stay of all further proceedings.
Interim order may be extended.
Pursuant to the order. Huh?
Interim order may be extended.
Yes. Till
All the
until
matters.
This is matter in the month of September. Yes.
Cell number 87,
Much obliged.
86. Cell number 86, Idappa BM for petitioner. Sagar B. Shastri.
Before respondent, the last occasion, my lord, petitioner was asked to place few documents which were produced before the trial court.
Interim order is there.
No,
This is matter in the month of October. No representation on behalf of the petitioner. Yes.
Cell number 87, Raghunath K for petitioner.
Yes.
The suit for judgment filed by the respondents against the petitioner hearing. And as far as the version of the respondent, during 1991, Mr. Chankama Shetty entered.
All
into
those facts not necessary. First, you have to tell me what is IA.
IA,
What is
order 11 rule 14 filed by the petitioner in for the taking the production of the document which was in the exclusive custody of the respondent.
Yes.
During the cross-examination, the respondent number 2 have clearly admitted that the original agreement is with her and there is no impediment to.
We'll read the order.
16, madam. Page number
Yes.
16, annexure
Come
A.
to the reasoning part.
Reasoning part at 16, para number 7. madam. The settled principle under the Indian Evidence Act is that facts which are admitted by the parties need not to be proved by independent evidence. When a particular fact is not in serious dispute, insistence on formal proof of such fact serves no useful purpose and does not adduce the adjudication of the controversy. In the present case, a careful reading of the entire cross-examination of PW1 indicates that there is no substantial dispute regarding the fact that Chankama Shetty was a tenant under the plaintiffs. On the contrary, the specific case of the defendant number 1 is that Puttanna derived possession from the possession of the suit property traces the chain of possession back to the tenancy of Chankama Shetty under the plaintiffs. When the defendant himself predicates his case upon the existence of such tenancy, the existence of the landlord-tenant relationship between the plaintiffs and Chankama Shetty cannot be said.
Please come to your The affidavit filed in support of the IA.
Page number 21, madam. Paragraph number 3. I state that during the cross-examination of PWQ, dated 3/12/2025, paragraph number 5, clearly and voluntarily admitted the agreement of Shankam Shetty is with me. That apart, she also agreed that she has no interest to produce the same in case if not produced. I further state,
Why you want this document?
my lord, in this matter, the Shankam Shetty and Puttanna was not made as a parties before the trial court, madam. And apart from that, I'm the one who is paying rent since from 15 years upon the instructions of the Puttanna. And the Chakam, according to the version of the respondent number 2, the Shankam Shetty is the original tenant who possessed the premises.
The court records the finding that that fact is already admitted by the defendants.
You see, the consolidated opinion of the trial court, my lord, when the tenancy between the Shankam Shetty and the
It's
landlord
admitted.
was admitted, there is no dispute or the formal.
Why do you want the document?
Formal document is not required. She further, my lord, the deposit, whatever the amount which was paid by the Shankam Shetty during 1990, which was repaid by the Puttanna as far as what I know. And apart from that, since 15 years, my lord, I'm the one who is regularly paying the rent upon the instructions of the.
From that document, all these aspects will not come. For what purpose you want that document? That is what you have to say in your affidavit. Where did you say?
Source of the possession and chain of the possession, terms governing occupation, and the security deposit, rights and obligations arising from the original agreement, madam.
These are all admitted.
These are all not admitted, madam.
Tenancy.
Tenancy, only the tenancy.
That will only be there in the document.
No, my lord.
Original rental agreement is not denied.
No, one submission, my lord. Shankam Shetty was the founder of the Shivapriya movies, wherein the distribution of the
Notice
films
the
was-
respondents petitions.
Respondent notice was already served, my lord. Caveat has been filed. And on 13/7/2026 itself.
She is the only respondent.
Respondent number 1 and 2, my lord. Respondent number 3 is a formal party. She is not the exclusive custody of the document, is in with the respondent number 1 and 2.
Shall I pass orders?
Please.
Yes.
And 3rd August is the matter posted for arguments, my lord. Final arguments. And they have admitted the existence of the agreement as well as the.
I'm going to
possession of-
dismiss your writ petition.
And one more submission, my lord. They have not substantiated the contention that the document was misplaced. In case if the matter misplaced, they have been supported by the substantial document.
I want to dismiss the writ petition. Shall I pass orders or shall I adjourn the matter?
Then the matter with interim mark.
No.
Because on 3rd August.
Dismissed. I'll pass order. Yes.
Cell number 88 disposed. Cell number 89. MD Raghunath for petitioner. Subramanya CR for capital respondent.
Yes.
Lord, in the FDP proceedings, the first respondent files an application under Section 2 of the Partition Act. After the court commissioner gives a report saying that the property is not divisible. Lord, our contention as far as Section 2 application is concerned, it's a dwelling house. We are interested to stay there. The first petitioner before this honorable court is 90-year-old lady. She is in her last days. Instead of selling the property, we will purchase the share at the market. In spite of these stating so in the objection statement, the court holds it is better that property goes for public auction. There we can participate in public auction. One problem will come here, please. This property is just opposite to Alsur Lake. Please. It comes under buffer zone. Not if we sell the property in public auction, we will not get good price, please, because no construction activity can happen in that
Come
buffer
to the
zone.
order. Where is the order?
Please, one second. The impugned order starts from page 132. The points for consideration is at page 134. Whether petitioner has made out grounds for allowing application in section 2. It is not in dispute that the court commissioner has been appointed in the present final decree proceeding, and court commissioner has submitted a report stating that petition schedule item number 1 is not capable of convenient and equitable division by meets and bounds. Though the said report is not a conclusive, it is relevant and important piece of material to access the feasibility of division. From the nature of the property and Commissioner's report, this court is satisfied that the property cannot be conveniently divided without affecting its utility and value. In the final decree proceeding, the primary duty of the court is to ensure that right declared in the preliminary decree are effectively worked out. When the division by metes and bounds is not feasible, the court is empowered to adopt an alternative mode of sale and distribution of proceeds as to do complete justice between the parties. In the present case, if the property is not divisible, compelling the parties to remain in joint possession would lead to further complication and
What is the procedure available to the court?
not, say, if section 4 is taken into consideration, not dwelling house, they should only sell it to other co-owners.
No, about the price.
About the price, will not, that they should give an offer. We should also give an offer. Then the court can accept it.
Present market value, if they are agreeable, I'm ready to accept.
Let them
Here
also.
Fix my share and pay me. Therefore, there ends the matter.
How many are the parties?
Not, totally it is 1/7 share she gets. First respondent gets 1/7 share.
There are another two respondents.
The other two respondents. Only one more person.
They appear
will
only
get
for
it.
one.
He
I appear for first respondent. She is the plaintiff and she has filed the decree and
When is the auction?
the
IA
date
is
is
allowed.
not fixed.
It is not fixed.
Then why don't you
The
take
court is
notice to this
vacant.
2 and 3 and let,
Yes, I
in the
understand.
meantime, let them give their offer.
Let them give their offer. Let them not precipitate the.
What is there to precipitate now?
Not if the court commissioner issues a notice and fix the date for auction. Mila.
Still court commissioner is
Will
not
take,
appointed to auction the property.
The land council, the petitioner submits that the property cannot be divided and it's a dwelling house where the petitioner is residing and he is ready to purchase the property without giving an opportunity to the petitioner to purchase the property. Court has passed the order impugned whereby the property has to be sold in public auction. Land council, the petitioner submits that he is ready to purchase the property. Land council appearing for the respondent number 1 submits that if they are ready to if they are ready to purchase the property as per the market value, they have no objection. Land council for the petitioner submits that if they come up with their with the quotation with whatever is the price, then he will also get an opportunity to respond to the same. In that view of the matter, the second respondent, the first respondent herein shall come up with the price, the quotation as agreeable to them. And by the next date of hearing, the petitioner shall come up with the response. In the meantime, the petitioner shall take out hand summons on the council appearing for respondent number 2 and 3 and shall file a memo to that effect by 5th of August. If the memo is filed by 5th, list the matter on 6th.
Then number 90. Yes.
Please let them not.
Linda.
What they will do?
No, suggest the name of the commissioner and all those things. That
Nothing will
procedure-
happen. 6th it is coming up. How many days?
Please, please.
Yes, Linda for petitioner. Harish, yes. Harsh.
Well, also I filed a memo for withdrawal in counter.
Appearing to the respondent.
Land council, the petitioner submits that he wants to withdraw the writ petition. Already a memo is filed in the registry. The writ petition dismissed as withdrawn.
Then number 91.
Record.
Yes, next.
91. The Prakash M for petitioner.
For
The
respondent.
copy.
Give the file. No representation on behalf of the petitioner. Also, the respondent is present. This is matter in the month of October.
Then number 92.
The petitioner is.
Gurudat
The
PS.
petition. Two application have been filed, order seclusion.
That mic is not on. That's
petition.
hassle to mic.
21123 of
It's not on. You'll ask him to whether it is on or not. Give that. Yes. Next matter also. Yes.
My lord, insofar as I appear for the cavator. So first.
Papers are served. Papers were served.
Served on me. My lord, first writ petition, will you ask me kindly allow that writ petition?
First one, second one. Mr.
2123.
21123. The
Can
reason
be
second.
allowed,
That
because-
is 92.1.
Yes, my lord. 21123. This is a matter in which, my lord, the plaintiff wants to incorporate, to add one more scheduled property. I have no objection. The second.
And you are the
matter-
only respondent?
Well, the other respondent is attested by me alone. Okay.
Well, he is contested.
I am the contesting your respondent. Dependent.
No, basing on his submission, if I have to allow this, whether notice to the other
It
respondents.
can be
and is-
dispensed, my lord. It can be dispensed.
I'll file a memo for that. I'll file.
It can be
To
dispensed.
appear
no
for
problem.
respondent,
13.
respondent number 13.
Yes, madam.
You are the only contesting respondent.
I'll file a memo
is
for
filed
dispensing others, madam.
Seeking dispensation of notice to respondents 1 to 12 and 14 to
23,
23.
madam.
Same memo is taken on record and dispensed. The writ petition is filed. Where is the impugned order?
Impute number, page number 61, madam. Yes, order number 11.
The writ petition is filed. Agree if the orders passed on I number 2, invoice number
Item number 11, madam.
Item number 11,
11.
madam.
I number 11, invoice number 1158 of 2012, clubbed with OS number 882 of 2013. What is the date of order?
Date of order is 26/3, madam.
23/2026, whereby the court has dismissed an application filed by the petitioner herein under Order 6 Rule 17 CPC. By virtue of this IA, the petitioner wants to amend the plate.
No, to include the one more scheduled property.
So by amending the plate, they amend the plate by incorporating another item number 3 of the property, as it's an ancestral property, and at the time of filing of the suit, the item number 3 of the property has not been included in the suit due to oversight, and hence come up with an application. The court had dismissed the same.
The reason for, my lord, since it is merged with the another suit, which is also pending consideration for partition.
Which is filed by
By 13th.
Who has made, who has raised objection?
The plaintiffs.
Same.
13th defendant opposed that application. 13th defendant is a
You are
plaintiff.
representing.
Yes, ma'am. 13th defendant.
Independent means 16
is a
dependent in
plaintiff- is a
the,
plaintiff
in the
another
plaint.
suit.
16 dependent in the plaint and 13th respondent in this petition. He is the 16th dependent in the original suit, in that suit. Here is the 13th respondent.
16 defendant has raised objection to the same. Considering the same, the court has rejected the application. Now the land counsel appearing for the 16th, the 16th defendant in the suit, and the 13th respondent herein submits that he has no objection to allow the application. It is submitted, the next part, it is submitted with the land counsel for the petitioner that except the 16th defendant in the suit, no other defendants are contesting the matter. Hence, he has already filed an application and already on his memo, notice to the other parties in the suit is dispensed with. Next part, considering the fact that both the parties have no objection for including item number 3 of the scheduled property. Accordingly, the order passed by the court is set aside, and consequently, IA number so and so, IA number 11 is allowed, and the petitioner shall make, the petitioner plaintiff shall carry out necessary changes. Then what about 92?
There, Melon made an application for implementing Mysore Urban Development Authority. When they contend, Melon, it is an ancestral property.
1297. Yes. Yes.
Papers. When they contend it is an ancestral property and wants the share, they want to impede Mysore Urban Development Authority, because this property has come to the family from Urban Development Authority, then CITB. Now, my lord, they are not necessary, institution is not necessary in a suit for partition. Therefore,
What is the purpose? Let's see the order.
Purpose, my lord,
this is at page 65, my lord.
65. I want to make one submission, my lord.
Yes. You are the counsel for the petitioner.
I'm going to.
Yes.
Yeah, in this, except para 7 and 8, no discussion or no reasons.
Before we go to the reasoning part, please come to your affidavit, why you want this party to be impleted.
One second, my lord, I'll come to that, my lord. One
Yes.
second.
Yes.
My lord, why? Because the, this corporation, Mysore Corporation has issued a notification for acquiring the property. For acquiring this property some 10 years back. So why, so that is why we wanted to implement him. Tomorrow it will not be complicated, that's all, my lord, no other reason.
They've issued, they've acquired the property.
No, they have not acquired the property.
Then?
They have issued a notification, notification. Not necessary, my lord, it may be.
Please come.
It may be this person.
Where is the order, page number?
Page number 65. Even then, the reasons are not being correctly.
Page 65, my lord.
Because there are no reasons from you, so there are no reasons from the court.
Just only
also.
one para, just simply, they have done it.
Agreed with the orders passed in.
In both the applications, there are no
The
reasons.
reasoning is page 68, para 5.
12.
Ah.
An application is filed by the plaintiff. The petition is agreed with the order passed on IN number 12 in OS number. So it's the same like in the other cause. So it's dated 10, dated, what is the date of the order? Unfortunately, we have to look for the
Same date,
issue.
same date, my lord.
Huh?
Same date,
Calm
same
on
date.
order.
Dated-
Calm on order it
dated
is.
So and so. The petitioner filed an application order 1, Rule 10 of the CPC seeking to implead the Mysore
Urban Development Authority.
Mysore Urban
Mysore Urban
Development
Development.
Authority as defendant number 22
Muda.
that came to be dismissed by the court by order impugned. The court, while dismissing the application, has observed that on perusal of the materials on record in a suit for partition separate position of the scheduled properties, the implement of the Mysore Urban Development Authority is not required. And the only reason stated that about 30 years back, they issued a notification. And that cannot be a reason for the court to implead the Mysore Urban Development Authority. When counsel appearing for the petitioner submits that the court has failed to give any reasons and without considering the case with the petitioner has simply dismissed the application. Then a senior counsel representing the counsel appearing for the respondent number so and so. Respondent number 13, who is defendant number 16 before the court, submits that the court has rightly dismissed the application as the Muda has nothing to do with the dispute that is pending between the parties. And even the plaintiff has not stated any reasons for impleading Muda. Next para, having heard the counsels on either side, there is a material on record. This is a suit for partition. The present application is filed seeking to implead the Mysore Urban Development Authority. As rightly observed by the court, the only reason why the petitioner has stated want to implead is that some 30 years back a notification is issued by Muda. If a notification is issued about 30 years back, why should the Muda be included in the present impugned proceedings? The affidavit of the petitioner is silent. Whether the court has given reasons or not, this court is convinced that without any basis, this application is filed. And in that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
Then number 93. Naveen Kumar.
Appear for the respondent landlord, my lord.
Notice is not yet ordered. Anyway, and you have filed wakalat. The question here is, when the legal notices and there is a discrepancy in the legal notice and the agreements. Rental agreements totally do not mention what is the size of the property, whether in square meters or whether it is in square feet. At that point of time, I'm just placing some documents because at the time of filing,
Before that, let me understand, what is the IA that is
they
filed?
have made it look simple, saying that
But I only wanted to change square meters to square feet. By mistake, there was a typing mistake. I wanted to make it from square meters to square feet so that there's no
No,
problem.
the IA is filed under order 6/2/17.
Yes.
So what is, let's look at the affidavit filed
Pardon?
by them. Let us look at the affidavit filed by them in support of the IA.
Paragraph 3, I have said that there's a typographical error where the
and I'll place the documents along with the IML. The colleague could not file it at the time of serving copy on the others. In that set, my lord, kindly turn to page 9 to 14. Page 9 onwards is the lease agreement. It was in 2003-16 October. No, I know, my lord. Lordship is asking.
And because of the time constraint.
It's the IA is.
He has produced the copy, my lord, but I have a copy. Can I just hand it over to your lordships, my lord? Copy of the application for amendment.
That is at
Just one
page
paragraph, my lord, I have
42,
said.
page 42 of the first set, the IA set. Or page 42, IA under order 6, rule 17. The plaintiff named reason so and so prays to permit the amendment of schedule of the plaint by rectifying metric measurement of the scheduled property from 8,290 square meters to square feet. The affidavit, they say that it has now come to my knowledge that there is a typographical error at para 3.
So now please come to where is the amendment? That is the affidavit, and where is the proposed amendment?
Right, that is the proposed amendment they have sought.
Square
They just
meters
want
to
to
square
change
feet,
it from.
that's all. Only to change meters to feet.
The word meters.
After affidavit, before affidavit, you must have filed the petition.
Yes,
This
Milord, that
the-
is at page 42, Milord, annexure D.
Yes.
Amend the schedule by
Plaintiff
rectifying.
named reasons to so and so in annexed affidavit place
8,290.
square meters.
Square feet.
That's all. Only that word meters instead of meters to make it feet. That's all.
That matter is at the stage of final arguments. It's not at the stage of trial. I would have no opportunity at all. Trial on both sides is over. Matter is for arguments. Once the evidence has commenced, amendment cannot be allowed. Moreover, the legal notice itself talks about square meters. And the legal notice of termination is based on, the suit is based on that 106.
What the rental agreement says.
That's what. That's why I pointed out the rental agreement, page 9 to 14 and the second set, which I had filed just now. Lease agreement 9 to 14. Kindly come to page 13. I won't take your lordship through all the pages, only the schedule. All that piece and parcel of land and building bearing number 11.
He has produced a
east by
copy which is blank,
Chetty
my lord.
Road,
I have that.
measuring dash. There's absolutely nothing
Here I have,
mentioned in
I have a
that
copy which
portion.
has, I have the copy which has the figure in
me-
it. He has produced a blank copy. What is to be done?
Sir, please wait, sir.
No, sir, what is this? You
Let
don't
me
take.
complete my submissions, please. In page 19, kindly see page 19.
But this is written with hand, some approximately square feet.
8290 square feet.
Is it filed along with the suit?
No.
It is produced along.
Along with the written statement?
Pardon?
No, along with the suit, it is filed along with.
Yes.
No.
Yes.
It's a part of the pleadings.
It was marked by confrontation to defendant.
They are not denying it.
They
Lord.
have confronted and marked it. How you entered possession is through this. Basically, they don't, it is an unregistered document. They don't want to pay stamp duty or penalty. They chose a method of putting the defendant in the box. When he is in the box, they confront it and mark. Now they want to say that as why they want to amend is in the, kindly see the legal notice. They mention notice scheduled property, which always we adopt the notice scheduled property in the plaint also. The notice scheduled property under 106 assumes importance because that is where the termination has taken place. That is in square meters. Now you want to alter it and say square feet. The whole thing requires fresh evidence, fresh termination. Moreover, this is a commercial unit. It should have gone to the commercial court. Cannot be dealt with by the civil court. It's a commercial property. We rented out for commercial purpose. Suit itself, jurisdiction itself was not there. They have suppressed all these facts and they are proceeding.
Now, please come to the order of the court. What did the court say?
Yes. Then the same set of papers in the second set I have produced. Pardon?
Impugned order
Page
must be in the-
27. Page 27 of which set?
Impugned order is also not there in the first set.
I think so, madam. That's just.
Then how come they have numbered this writ petition without an impugned order?
On the urgency of the matter and because of the fact that there is a order sheet available. Order sheet last portion, operative portion was filed, madam. Only on that portion.
Hundred and 112, my lord. Page 112.
Page 112 ಇಲ್ವಲ್ಲ?
So WP copy ಕೊಟ್ಟಿಲ್ಲ.
ನೋಡೋಣ.
WP copy. ಇಲ್ಲಿ ಬರೀ papers ಮಾತ್ರ. ಅಲ್ಲ, WP copy.
But what is this order? There is no separate order.
There is. He has not produced it.
Yes, madam, it is there. I produced at page 3 in the second set.
Page?
Orders on interlocutory IA, page 3. Orders on IA 7. IA number 7, interlocutory application. The plaintiff submitted, she has filed this suit against the defendants to recover possession, so and so. But due to typographical and oversight mistake, measurement of the scheduled property in metric measurement has been wrongly mentioned in square meters instead of square feet. Thereby contended that the proposed amendment is necessary and fair to allow. Defendants filed objection stating that the application.
There is no sale deed for this. There must be a sale deed document.
It's I've got it under a will, my lord, registered will for my grandmother.
No, there must be some other document.
My lord, your lordship sees I am not the owner of 8,290 square meters. I am only 8,290 square feet. That's the only thing, whether it's metric measurement or square feet. He's a tenant of the entire property. He takes a defense saying that you have not produced any material to show that you are the owner. Please look at his objection statement. Now he is disputing my ownership of the property. And he hasn't paid rents for, no, your lordship sees he has not paid rents for 6 years.
No.
There may be
There
other
must be a
owners.
document.
Pardon?
Which there must be a document in with you. It would clearly show what is it. It's square meters or square feet. So that is enough. That's what I'm asking.
Very well, my lord.
My lord, my humble submission.
Your lordship
Kindly
may have
turn
it,
to
my lord.
page 19.
Your lordship may have it day after tomorrow. I'll produce it.
Kindly turn to page 19 before we close this matter.
19.
Page 19.
Yes.
See, the confusion, my lord, is created by them, not by us, and they are blaming us. Part of second floor Gangadhar Shetty Road.
No, you are the tenant.
Please, madam.
What is the extent of the property you are in
History.
possession of? At least that you can say. What is the big confusion on this?
My lord, because of the nature that
Don't
the,
try to take, advantage of this kind of on a technical
no,
issue.
which is ground,
No, you are in possession of the property. That is an admitted fact.
but I am
What is
in
the
possession of second floor. They have filed in suit for against first floor. That is what I am trying to point out. my lord. Second floor is the lease. They have issued notice to first floor and they want to get me evicted. I am trying to bring it to the notice of the honorable court that the evidence is over, cross-examination is over, valuable admissions are there. Now this whole thing will change the nature of the suit. They should file a fresh suit now.
Where did you say that you are residing in second floor but not in the first floor?
Kindly see page 19. That's why I said the
Look at the
lease
written
agreement
statement
is,
at 36.
lease agreement shows schedule is second floor. Page 19,
So you are in first floor or second floor?
second floor.
Give me the cross examination.
Now they are saying, no, you are in first floor. Then they say, no, you are part of second floor and the entire first floor. They themselves in their evidence, they confuse the whole thing. They are not sure. But there is a dispute among that bill and there is a suit. We are not going to that aspect. It's a matter to be dealt with between co-owners of that property. We are only pointing out that they had no right legally vested with them to dispute. That is why they are confused whether we are in first floor, part of second floor, or only ground floor. They are issued notice for ground floor also. And the next lease doesn't even say which schedule. Kindly see the schedule. It doesn't even speak. Kindly see page 25. All that piece and parcel of land with building number 11, part of first floor. Right, part of first floor, then part of second floor. Which part? Three unregistered lease deeds.
You are in which part?
Well, depending on my statement,
No, I will answer that question. In cross examination, this is what he says. It is true that the entire suit property is a single schedule and the three defendants for convenience have divided it into three parts and are paying separate rent. Although there are three agreements for the suit property, the property is not actually divided. The witness further states that the defendants have divided it into three parts for their convenience. It is true that the three defendants are in joint possession of the entire suit property. The three defendants are equally entitled to the three parts with possession, but they are paying rents for the entire property. This is the cross examination of the defendant.
Now kindly see the legal
my
notice.
friend's ingenuity.
Kindly see the legal notice of termination. That legal notice
No,
of
we are not concerned with
termination
that now. We are
is
only
at
saying it is
page,
square feet or
is
square
at,
meters.
no, please let me just complete my submissions. At the page number 36, Manad. Legal notice is common to all three, but the schedule shown is together with amenities at measuring 8,290 square feet at page 40. Joint, composite, consolidated, occupants, all of you should be specific.
Please come. The petitioner is before this court. Agreed with the orders passed on I number 7, filed under order 6, rule 17, dated 4th July 2026 by the 14th Additional City Civil and Session Judge, Bangalore, dated 4th July 2026. The suit is one for eviction. In the said suit, the plaintiff has come up with the present application seeking amendment of the plaint as far as as it is mentioned as 8,290 square meters, as it is a typographical mistake. They want to convert it, they want to amend it as 8,290 square feet. That came to be allowed by order impugned.
I may be given opportunity to file rejoinder at least.
Additional written statement
Can always.
Taking up all contentions.
With this submission, we could have saved another 15 minutes, 3 cases by this time.
That may be recorded.
The proposed, the court has allowed the application. That the proposed amendment is necessary for just decision of the case. If not allowed, probably the plaintiff will be put to great loss and untold hardship. It is well settled that in a suit, identity of the disputed property has to be proved, both in respect to the property number and also measurement, including the boundaries. The square meter area is larger than the square feet in metric terms. Therefore, just and necessary to permit the plaintiff to amend the plaint and accordingly allow the application. Then the senior counsel representing counsel for the petitioner submits that in the notice that is issued, the plaint and the subsequent pleadings, when they are specifically stating it as 8,290 square meters without any basis, now they cannot be permitted to amend the same. It is submitted that after the trial has commenced, it is not permissible to amend the plate. And the entire evidence is also let in by the parties. It is submitted that the court, without considering all these aspects, had allowed the application. Learned senior counsel representing the respondent number 1, who has filed the wakalat even before the notice is issued, submits that in the evidence they have categorically admitted about their possession and also payment of rents to the defendants. If as on the face of it, it is a typographical mistake. Instead of mentioning square feet, it is mentioned as square meters. And this would not cause any prejudice to the plaintiff or to the defendant, only with an intention to harass, drag on the proceedings. The present petition is filed. It is submitted that while passing the order, court has considered all the aspects. No interference is called for as per the learned senior counsels on either side. Produce the material on record. The suit is filed for eviction, and according to the plaintiff, the defendant is in possession of 8,290 square meters. It is a case that it is a typographical mistake. Instead of mentioning square feet, they have mentioned it as square meters. The trial court has appreciated this fact and had rightly allowed the application in the considered opinion of the court. While the court has to look at the substantial interest of the parties, and while allowing an application for seeking amendment of pleadings on these kind of typographical mistakes, the court has to construe the same there should be a liberal approach in view of the same. In the light of the above discussion, this court is reviewed that there is no informative the order impugned, and accordingly the petition dismissed. However, the petitioner is at liberty to file his additional written statement.
Obliged.
All contentions may be kept.
All contentions are left open.
Much.
Call that matter.
230 matter, cell number 152. 152.
Lord, just one matter, my lord. There's a item 95, my lord. I am appearing for the petitioner. My friend is appearing on the other side. There's a little urgency in. Yeah, I'm sorry.
Flip side.
I'll take it up tomorrow. No time now. This matter I have specifically said I'll be taking it now. The list will continue as it is tomorrow.
My lord, would your lordship kindly have it on? Because it was yesterday also, it did not reach. Today also.
It's already like it's already 4:40.
No, I know. If your lordship could kindly have it on top of the list tomorrow, my lord. That's all.
It will come. Yes.
Because yesterday I was 57.
What has happened is there are so many matters, matters. They're repeatedly coming, and every day I have to sign 150, 200 order sheets. That's the reason for the first time I've taken all the orders on the top.
Very well.
So that at least 50, 60 matters will go out of.
No difficulty. If your lordship kindly.
No, today.
Tomorrow.
No. Today tomorrow it will continue from there. From where it stopped.
Very well. Very well.
Wait. Yes. Sorry. Yes, Mr. Senior Counsel.
Sorry, my lord. I took.
Yes.
Mentioned it out of.
Yes.
We are paying 12 crores.
Yes. What do you say? What is your case?
Milords, my instruction is, Milords, I have objections in terms of the judgment of the apex court. Milords, may I just pass on? Your lordship may kindly.
Take that.
Milords, the Honorable Apex Court had an occasion to consider the exact same situation of the present case. Milords, the law has laid down, Milords, post amendment of 13(8), that it would be from the date of.
Now here there is a difference.
Please.
Now, in the said facts and circumstances also is paying the same amount.
No, my lord. Your lordship may kindly see the conclusion.
No. Facts I'm asking. What was on what price it fetched in the auction? What was the amount he was ready to pay?
Lords, in this facts, my lord. Please, my lord.
No, that is precisely I've also taken a similar view.
Please.
That's precisely the distinction that I want to take now. Saying that when 1.5 crores
Please.
is if the bank is getting more, then why not?
Then your lordship may take my submission objection, lords. The alternative submission which I would like to make is, lords, I'm a genuine auction purchaser. But since your ladyship is looking in on equity, your lordship may also look at me through equity and direct the bank to pay me enhanced interest.
Why did you pay that when there was an order not to finalize? Why did you pay the entire amount?
Lords, lords, because they have asked me to pay.
That is what the rule says. Unless and until the auction is finalized, you need not pay the money. Why did you pay them?
Lords, that's not how this judgment reads, lords. Lords, it said, lords, the moment I pay. Lords, sale confirmation should be an ancillary. The word used is should in this.
Because there is an order by the court not to finalize.
Please.
This is a case. Now, if at all there is a problem with the bank which has not informed you about the proceedings.
Therefore, lords, I'm asking direction from the bank, not from the. Lords, the bank would have to pay me enhanced interest because, lords, they are taking.
They should pay you what?
Enhanced interest.
Enhanced interest.
Please, lords, with interest I will have to get back because, lords, I have deposited my money.
When did you deposit the money?
Lords, your lordship may kindly see, lords, I have deposited the money on, my lords, lords, on 15/5/2026.
15/5?
2026.
How many months now?
Lords, 7 crores. Lords.
8 months. 8 months.
No,
I mean,
2 months.
3 months.
15/5.
1 to 3 months.
Please.
That, my lord, I think, my lord, my friend, my lord, petition should undertake that, my lord.
That's what I'm.
Great. I'm so sorry.
3 months. So what is the interest on that?
On 25% is what the interest which to be calculated because they were required to pay 25%, lords. If voluntarily they pay some additional amount, on 25%, what your lordships suggest, lords? I am bound by your lordships orders.
How much it comes?
Whatever, my lord.
What is the 25% of the amount?
I'm sorry, not on 8/5/26, I'm sorry, 8/5/26, when I receive a letter not from the bank, not asking me to deposit the entire amount, according to which I have deposited. It's not the bank, not which has asked me to deposit.
Why did you ask him to deposit when the court has asked you not to finalize the auction?
Not to confirm the auction, my lord.
What does it mean?
Confirm, my lord.
They can't
No,
play with
when
not,
will the entire amount be paid?
After confirmation.
Once I conducted the auction, there is no impediment or, my lord, bar for me
Please
to.
tell.
No, I have not confirmed.
You can make the submissions basing on your rules.
Lord, as per the
Take
order.
take the act.
As per the
Rule
order.
9 also say,
I have not confirmed the sale.
but they also say, not, can I just read one line? Please be informed that in case you fail to deposit the due amount by scheduled date, the sale shall be cancelled and any amount deposited due related to this bid shall be forfeited. By then, I had already deposited 3.5 crores.
And at any point of time, they didn't tell you about the pending litigation.
No.
They didn't tell you
No.
about the orders that are passed by the court.
No.
Point out, my lord. In the initial, my lord,
No,
when the
no.
petition came before the
How
Honorable
many
Court,
times the court has to repeatedly tell the bank
Authorization Act.
that you have to inform the parties that about the pending litigation. Now, if they're okay with it, they will participate. Otherwise, they will not.
this matter, when, my lord, interim order, my lord, initial writ petition filed, sale essay, this Honorable Court refused to grant an interim order.
By the time the auction was conducted, interim order was there.
But subsequently, my lord, they preferred a writ appeal. In the writ
That's
appeal,
what,
I was not the party. It was ex parte interim order has been obtained by them.
Even after that, you have asked them to pay the money.
Lord, when it is communicated.
should-
I don't know what is.
It should
what
straightaway
is-
attract not 406 and 409 of IPC. They can't, may not deal with public like this.
That is what the banks are doing.
Please, exactly. This virtually amounts to an offense.
No fault of my lord, that cannot be, my lord, that
No, when was the order by the division bench?
5/5, my lords.
5/5. When was it communicated to the bank?
Same day.
How?
Lords, it's by email as well as by personal communication.
And when was the auction?
my lord, the order is, my lord, not to confirm the auction. Bank may go ahead with the auction.
That's
Not
what.
to confirm, I'm not
Correct.
confirm the auction.
No, we'll come to that. Now, 5/5/26 on the same day email. And when was the auction conducted?
On my lord.
8/5.
8/5.
8/5. So by the date when you're conducting the auction, you were aware, bank was aware about the interim order that is passed by the court that not to confirm.
Not to confirm. Yes.
Not to confirm. So whoever is participating in the auction, don't they have a right to know about it or not? It's a question.
And they say that if you do not deposit the money, I'll get my
You
3
wouldn't
crores
have,
will
you
get
wouldn't have
forfeited.
participated in this.
my lord, in respect of my lord, kindly see, my lord, whether the interim order, whether I am complied or not. I am complied, fully complied this interim order. I am not confirmed the auction. As of my lord, the impediment only for me, not to confirm the auction. I am not confirmed.
That is one aspect. I'm asking the next one. Do you have any obligation, responsibility to inform it to the purchasers or the probable persons who are participating in the auction about an order? Why should you not disclose it? You are not a commercial part like
No,
any
that I
other
agree, that I
party.
agree, my lord. In fact,
Public sector banks
no,
not
that
giving
I agree. In
this.
fact, that is the reason, my lord. I have not confirmed so far. In fact, I made a submission before this honorable court also as well as division bench. I have not confirmed the auction in view of the order made by this honorable court. I'm not, it's a matter of fact, my lord, I may not inform the option purchaser.
Why?
Because the matter, my lord, subject to, my lord, I'll just point out, my lord. When, my lord, initially the matter came up before this honorable court, the contention or, my lord, the argument cannot.
Okay, let us say on 5/8/2026, you have not informed him. That is fine. Then when was the letter addressed to you?
Not on 8/5, no, this is a letter not that I read to your lordship. So 8/5, they give this notice and they also say.
But
please
8/5 is the auction.
Please, my lord.
8/5 is
No,
the
by
auction.
then I had deposited, 25%, that's 2 crores 58 lakhs.
Mm.
On this day, not on 8/5, they say, if you do not deposit the remaining amount, by scheduled date, sale shall be cancelled and any amount deposited by you relating to this bid shall be
Give the
forfeited.
act. Which rule?
Rule 9(4), my
It is
lords.
only sale intimation letter. My lord, kindly see, my lord, the sale took place. I intimated to them, said that, my lord, kindly see the language which employed in the letter, my lord, dated, my lord, 8/5/2026. I intimated them, you are the successful bidder, you have to pay the remaining money.
If you don't pay, I'll forfeit 2.5 crores. This is a classic case where banks should not be made answerable to people. But I have paid 10 crores. But I also would have borrowed money.
Let's look at the rule.
9(4), my lords. The balance amount of the purchase price shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the immovable property or such extended period as may be agreed upon in writing between the purchaser and the secured creditor, in any case not exceeding 3 months.
So, question of paying the remaining amount will
Will
arise
be
once
only after confirmation.
confirmation, which is stayed by
Confirmation was
this
already
court.
stayed.
Only 24%, no? Not entire money.
Entire money, entire.
My lord, what, my lord, my client is transferring, my lord, that we said that 25% of the money, which is a mandatory requirement under rule 9(4).
9(3).
9(3).
Can I just pass on this letter? You can't say something and.
Let's see. Take that.
What they say is something different from what is not contained in the letter.
You bid for the purpose so and so. In terms of the sale notice issued so and so, you're required to deposit the balance amount as per the detail mentioned below. Your bid amount 10 crores, 25% 2 crores.
That is done.
EMD amount so and so, balance amount is so and so.
The next page, my lord will find
25% of the entire bid amount is 7 crores so and so.
They say, you do not.
Be informed that in case you fail to deposit due amount by schedule, the sale shall be confirmed. You have asked them to pay the entire amount.
It's a normal
by
letter, the
20
sale intimation letter which you inform.
23/5, no, you have mentioned the dates.
No,
You said 23/5/2026, you have to pay the entire amount. This amount they will be paying after the confirmation.
My obligation, my lord, as per the order passed by this honorable court, not to finalize the auction. Kindly see the interim order passed by the division bench. I'm not, my lord, I'm not issued the confirmation, I'm not issued the sale certificate. I completely abide the, my lord, order passed by this honorable court.
Yes, sir. That is the first limb of your this thing. Second is, the second case is.
I'm obligated to inform to auction purchaser.
Number 2. Number 3, you shouldn't have taken this money when there is a, when you are not, when the, unless and until the court passes an order, unless and until you confirm the sale, question of taking the remaining amount will not arise. As per section rule 9(4). Why, and what is, why this hastiness by the respondent bank and why they want to do this? You are bound by your own.
According to me, my lord, he was fully aware in respect of the writ petition pending.
I'm sorry, I'm extremely sorry.
My lord, now, my
Extremely
lord,
sorry.
Those kind of things you can't say before
no, I
the
agree.
court.
my lord, now, my lord, he wanted to pay the money. In fact, some solution, my lord, he's undertaking.
Oh, he's anyhow paying 1.5 lakh crores more than
My
what
lord,
he's supposed
don't
to
put me,
pay.
my lord, to the, my lord, paying some, my lord, interest to, my lord, auction purchase. It is, I have no fault of it.
They will pay for 25, no.
Let them pay.
What they do
On
is, they will
25%.
pay for 25%.
Yes.
That is what they are supposed to pay. 75% you pay the
Then at
interest.
the most, my lord, bank interest will be able to pay. Bank interest will be able to pay.
What is the bank interest?
What is the bank interest normally? 6%. 6 to 6%. My lord, if the court directs, it's not undertaking. Huh? If the court directs, my lord, we may.
Yes. I'll pass order.
Lordships.
Oh, that.
Can I hand over the demand draft?
Heard the Senior Counsel, represent the counsel for the petitioner, counsel referring for the bank, and also the auction purchaser. Auction, a different expression on Mr. Vignesh Shetty.
I know. No, I was under the impression of I'll get money and I'll go.
He's happy,
In addition to that,
he's
my lord,
happy, he's unhappy, he's confused. An amount of rupees, the DD for an amount of rupees, how much?
12 crores.
12 crores is handed over to the council appearing for the bank. Heard, reserved.
Please, Miller.
Grateful.
So your Lordships may direct the title documents to be
Hmm.
released
No,
forthwith, my
that
lord, so
will-
that.
While passing the order, that
Yes,
I'll pass.
the reason
No.
is, my lords, we have a backup commitment, my lords. Within 1 week, I'll have to.
Yes, I'll
Lots.
pass orders. List this matter for pronouncement of orders on 4th of August.
So grateful, my lords.
Please.
Yes.
Your Lordship, kindly consider not imposing heavy cost on not.
And Mr. Vignesh Shetty.
No, that is not something new to, is it Canara Bank? Is it Canara Bank?
Yeah, please, Canara Bank.
That's not something new to Canara Bank.
At the receiving end, my lord.
I would put it that Mr. Vignesh Shetty has been defending Canara Bank very effectively. So grateful, my lords.
ಅಲ್ಲೇ ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್ಗೆ ಅಲ್ಲೇ ಜಸ್ಟ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ ಅಲ್ಲಿದೆ ನೋಡಿ ಸರ್ ಸ್ಲಿಪ್ ಅಲ್ಲೇ
ಸರ್ ನಾ ರಿಪೀಟ್ ಆಗುತ್ತಾ
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸರ್
ಇಲ್ಲ ಸರ್
ಅಲ್ಲಿ
ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು ಸೈನ್ ಕೊಡಿ ಅಂತೀರ
Sir, court officer.
ಮೇಡಮ್
ಮೇಡಮ್
List one matters from remaining 95 to whatever they are in preliminary hearing and admission. Those matters will be repeated tomorrow. The orders.
Madam, 230 matters as
A
well.
orders and B group matters will be split up before different dates.
Madam, 230 matters as well. Madam, list 2 matters.
Serial number 48 ಅಲ್ಲಿ ಕೆವಿಟಾರ್ ಇದ್ದಾರೆ ಇವ್ರೆ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ಆರ್ಡರ್ಸ್ ಐ ಆರ್ಡರ್ಸ್ ಅಂಡ್ ಬಿ ಗ್ರೂಪ್ ಐ ವಿಲ್ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಟು ದ ಡೇಟ್ಸ್ only preliminary hearing and B group matters preliminary hearing admission matters will be repeated tomorrow and other matters will be date assigned ಅದು ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ನಿಮ್ಮಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಅದು ಶಾರ್ಟ್ ಡೇಟ್ಸ್ ಬರುತ್ತೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಇರೋ ಮ್ಯಾಟರ್ಸ್
Madam, 230 as well ಅಲ್ಲ 230 matters.
ಏನಂದ್ರೆ ಇವಾಗ ನಾಳೆ ಡೇಟ್ ಆಗಿತ್ತು ನಮ್ಗೆ ಬಟ್ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀಲ್ ನಂಬರ್ 6
ಯಾವ್ದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅದು ಹೋಗುತ್ತೆ ಸರ್ ಅದು ಅಕಾರ್ಡಿಂಗ್ ಟು ದಿ ಇವಾಗ ಈಗ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಇರೋದೆಲ್ಲ ನಿಮ್ಗಿಂತ ಒಂದು ತಿಂಗಳು ಮುಂಚೆ
ಇಲ್ಲ ಮೇಡಮ್ ನಾಳೆ ಡೇಟ್ ಆಗಿರೋದು ಇವತ್ತಿಗೆ ಲಿಸ್ಟ್ ಐತೆ ಅಂತ ತಿಳ್ಕೊಳ್ಳೋದು
ಆಯ್ತು ಬಿಡಿ ಈಗ ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ ಆಯ್ತು ಸರ್ ಇಟ್ ವಿಲ್ ಬಿ ಅರ್ಜೆಂಟ್ ಬಿಡಿ ಔಷಧ ಮೆಮೊ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಅವರು. They are submitting memos
Madam,
ಈಗ even they
second list.
ನೀವೆಲ್ಲ ಹೇಳಿರೋದು ಅದರ್ ಸೈಡ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ. ಯಾವ್ದು ಹೇಳಿ ಸೀರಿಯಲ್
Madam, second list.
ಬೇಕಾಗಿದ್ರೆ ನೋಡಿ.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ ಐ ವಿಲ್ ಸಿ. ನಿಮಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು ತಾನೆ? ನೋಡಿ ಅದಾದ್ಮೇಲೆ ಮೆಮೊ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ವಾ ಅವರು?
ಇದು ನಾನು ಹಾಕಿದ್ರೆ
ನೀವ್ ಹಾಕಿದ್ದೆ.
ಇದು ಮುಂಚಿನ ಹಾಕಾಯ್ತು ಇವಾಗಲ್ಲ.
ಡೇಟ್ 28 ಸರ್, ಒಂದ್ ನಿಮಿಷ 28/7 ಅಂತ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಮಿಸ್ಟೇಕ್. ವಿ ಆರ್ ಆಸ್ ಫಾರ್ 29.
ಆಯ್ತು ಬಿಡಿ, ಇವಾಗ ಹೋಯ್ತಲ್ಲ. ಇವಾಗ ನಿಮ್ದು ಇವತ್ತಿಗೆ ಅರ್ಜೆಂಟ್ ಆಗೋಯ್ತಲ್ಲ, ಏರೇ ಮಾಡಲ್ವಲ್ಲ. ನಾಳೆ ಡೇಟ್ ತಗೊಂಡಿದ್ದು ನಾಳೆನೂ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲೇ ಬರುತ್ತದು. ಡೇಟ್ಸ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ರೀಚ್ ಆಗೋದಿಲ್ಲ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇಟ್ ವಿಲ್ ಬಿ ಗೋ. ಅದು ಹೋಗ್ತಾ ಇರುತ್ತೆ ಡೇಟ್ಸ್.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ಇವ್ರೆ, ಇವಾಗ ನಿಮ್ಗೆ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು. ಇದು ಸ್ಟೆನೋಗ್ರಾಫರ್ 28/7 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಇವತ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಆಯ್ತಾ. ಇವತ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ನಿಮ್ಗೆ ಇದು ಬೇಡ ಹಿಯರಿಂಗ್ ಅಂತ ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಗೋ ಅಧ್ಯಯನ್. ವಿ ವಿಲ್ ಅಧ್ಯಯನ್. ನಾಳೆ ಬರಲ್ಲ, ನಾಳೆಗೂ ರೀಚ್ ಆಗಲ್ಲ ಅದು.
ಮಿಸ್ಟೇಕ್ ಯಾವ ಕಡೆ ಇದೆ? ನಮ್ಮ ಕಡೆ ಇಲ್ಲ.
ಈಗ ಇವಾಗ ಇದು ನಾಳೆಗೆ ರಿಪೀಟ್ ಮಾಡಿಸ್ಬೇಕಾ?
ನಾಳೆ ಬೇಕಲ್ಲ.
ನಾಳೆಗೆ ಬೇಕಂದ್ರೆ ನಾಳೆಗೆ ರಿಪೀಟ್ ಮಾಡಿಸ್ತೀನಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ. ಆಯ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟದು? 6 ಅಲ್ಲ? ಆಯ್ತು ಆಯ್ತಾಯ್ತು. 29 ನೀವು ಡೇಟ್ ಅದ್ ನೋಡಿ ಸರ್, ಯಾವತ್ತು ಅಪ್ಡೇಟ್ ಆಗಿದೆ? ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ಇದು ಏನೋ ಇದು ಕಾಂಪ್ಲಿಕೇಶನ್. ಯಾರದು ಟೀಕೆ ಏನ್ ಮಾಡಿರೋದು? ನಿಮ್ಮ ಅದರ್ ಸೈಡ್ ಕೇಳ್ಕೊಂಡಿರ್ತಾರೆ ಇವ್ರೆ. ನೀವೆಲ್ಲ ಕೇಳ್ಕೊಂಡು ಹೋಗಾದ್ಮೇಲೆ ಅವ್ರು ಬಂದು ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡ್ ಮಾಡಿರ್ತಾರೆ. ಆಯ್ತಾಯ್ತು.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದು ಕೇಳಿದ್ರು, ಟ್ಯೂಸ್ಡೇ ನಾವಿಲ್ಲ, ನೀವು ವೆಡ್ನೆಸ್ಡೇ ಬೇಕಂದ್ಬಿಟ್ಟು ಕೇಳಿದೀವಿ ಕ್ಲಿಯರ್ ಆಗಿ.
ಡೇಟ್ಸ್ ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ಇವ್ರೆ. ಅದೆಲ್ಲ ಬರ್ಬೇಕು ಡೈರೆಕ್ಷನ್ ಅಲ್ಲಿಂದ. ಓನ್ಲಿ ದಟ್ ಟುಮಾರೋ ರಿಪೀಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅಷ್ಟೇ ಡೈರೆಕ್ಷನ್ ಬಂದಿರೋದು. ದಟ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಡ್ಮಿಷನ್ ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ಇರೋದು ಮಾತ್ರ ನಾಳೆ ಬರುತ್ತೆ. ಇದೆಲ್ಲ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ. ಬಿ ಗ್ರೂಪ್ ಬೇರೆ, ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಸ್ಟೇಜೇ ಬೇರೆ. ಬಿ ಗ್ರೂಪ್ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ.
ಮೇಡಮ್, ಲಿಸ್ಟ್ ರಿಪೀಟ್ ಮಾಡ್ತೀರಾ?
ಏನಾಗಿದೆ ಅಪ್ಡೇಷನ್ ಏನ್ ಮಾಡಿದ್ದೀರಾ ನೀವು? 29th ಅಂತ ಇದೆಯಾ ಡೇಟ್?
ಮೇಡಮ್,
28ಗೆ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ. 29th ಅಂತ ಅಪ್ಲೋಡ್ ಆಗ್ತಿದೆಯಾ ಅಂತ. 15 ಆಯ್ತಾಯ್ತು. ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀರಲ್ವಾ ಸರ್? ನೀವು ಬೆಳಗ್ಗೆ 10:00ವರೆಗೆ ನಿಮ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ ಆಪ್ಷನ್ ಇದೆ ತಾನೆ? ಪ್ಲೀಡಿಂಗ್ ಯುವರ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ. ಮತ್ತೆ ಸರ್, ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡ್ ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ ಆಪ್ಷನ್ ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವೋ? Then when you are not able to plead your extreme urgency in 10:30, you are pressurizing me. No, I can't do anything. Whatever the instructions of the lordship, I have to follow.
Madam, list
ಅದೇ ಅದೊಂದು ನಾಳೆ
Madam, list serial number 21.
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 123 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ನಂಬರ್ ಕೊಡ್ತೀನಿ.
ನಾವು ಲಿಸ್ಟ್ ಮಾಡ್ಸಲ್ಲ ಸರ್. ಅದೇನಿದೆ ಇವಾಗ ಕೋರ್ಟ್ ಒಂದ್ ನಿಮಿಷ ಇವ್ರೆ, ಕೋರ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಎಲ್ಲ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ಗೆ ಪವರ್ ಇರಲ್ಲ. ಆಯ್ತು ಅದನ್ನ ನಾವು ವಾಪಸ್ ಕಳಿಸಿದಾಗ ಅವ್ರಿಗೆ ನೋಡಕ್ ಹೇಳ್ತೀನಿ. ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ? 123 ನಲ್ಲಿ ಇನ್ನೊಂದ್ ಮ್ಯಾಟರ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆಯಾ? 123 ಅಲ್ಲ? I will instruct the branch to put up also. ಯಾವ ಡೇಟಿಗೆ ಅದು ಹೋಗುತ್ತೆ ಆ ಡೇಟ್ ನಾಳೆ ಇವಾಗ ಹೇಳಿಲ್ವಾ ಇವ್ರೆ? ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ ಬರ್ಲಿಲ್ವಾ ನಾನು? ಓನ್ಲಿ ದ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಂಡ್ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಟುಮಾರೋ ಅಂಡ್ ಆಲ್ ಅದರ್. ಏನಿದೆ ಆರ್ಡರ್ಸ್ ಇದೆ? ಹ್ಯಾವ್ ಯು ಸೀನ್ ದ ಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಪ್ರಾಪರ್ಲಿ? It is there in the orders. IA orders and B group matters will be idagutte.
Madam, list number serial number 21, madam, entry model.